Chapter 17. The Network. Marcos had the cell tower data spread across his desk Wednesday morning when Salazar walked into the bullpen at 7:15. He'd been there since 6. She could tell by the coffee. First cup empty on the desk, second in his hand, half full. Trident Mobility's fleet insurance covers 37 vehicles, he said without looking up. The Ram 1500 from Kingman is in the fleet. I pulled the GPS tracking data through the insurance subpoena Okafor filed Monday. Salazar set her bag on her desk and pulled her chair to the gap between their workstations. Marcos turned his laptop so they could both see the screen. He had a map application open with a line drawn across it in blue. The line started in Scottsdale, angled northwest to Kingman, then ran west along I-40 through the desert. The GPS unit on the Ram logged a departure from a commercial lot on Decatur Boulevard in Las Vegas at 4:17 p.m. on Saturday, March 1st, Marcos said. That's the Apex Fleet Solutions address. The truck drove south on the 15 to the 93 and then south to Kingman. Arrived Kingman at 8:42 p.m. Stopped for 19 minutes at a Motel 6 on Andy Devine Avenue, then continued south on the 93 to I-40 east. East, toward Scottsdale. Toward Scottsdale, the GPS record shows the truck on I-40 east to Flagstaff, then south on I-17 to the 101 loop. It arrived at an address on North 68th Street in Scottsdale at 1:47 a.m. on March 2nd. Salazar looked at him. North 68th Street. Fraser's apartment complex. How long did it stay? She said. 23 minutes. The truck departed at 10:40 p.m. and went back the way it came. I-17 north to Flagstaff, I-40 west. The Flying J charge was at 2:14 a.m., 3.5 hours later. That's the fuel stop we already had. The truck was at Fraser's building for 23 minutes. Then it fueled in Kingman heading west. Heading west, and it kept going west. Marcos pointed at the blue line on the screen. It continued from Kingman across the Arizona border into California. I-40 west to Needles. The truck crossed the California Agricultural Inspection Station at 4:22 a.m., then west through the Mojave to Barstow. Barstow. The truck stopped in Barstow at 6:03 a.m. Parking lot of a Denny's on East Main Street, off the I-40 and I-15 interchange. Stopped for 38 minutes. Then it moved again. The blue line on the screen continued from Barstow, but it didn't go west toward Bakersfield or south toward Los Angeles. It went north. Highway 395 north, Marcos said. From Barstow up through the high desert. Kramer Junction. Red Mountain, Johannesburg. The truck arrived at its final GPS position at 8:14 a.m. on March 2nd. He zoomed the map. The blue line ended at a point northeast of a small town in the upper Mojave Desert, between the southern end of the Sierra Nevada and the Argus Range. The town was Ridgecrest, California. Salazar had heard of Ridgecrest. Naval Air Weapons Station China Lake was there, the Navy's largest single landholding, 1 million acres of restricted airspace and weapons testing ranges in the middle of the desert. The town existed because the base existed. 15,000 people in a grid of streets between the desert floor and the mountains, 3 hours from Los Angeles by way of the 14 and the 395, or 3 hours from Las Vegas by way of the 15 and the 395 through Barstow. Far enough from both cities to be invisible. Close enough to either to reach in a morning's drive. Where exactly? Salazar said. Marcos zoomed closer. The endpoint was northeast of town, off a road that ran through open desert toward the Argus Range. No street grid, no development visible on the satellite layer, just road and desert and the brown folds of the mountains in the distance. The GPS signal holds at this position from 8:14 a.m. March 2nd through the present, Marco said. The truck hasn't moved in 26 days. A parking spot in the desert. A property. The satellite view shows a structure. I printed it. He reached under the cell tower printouts and pulled out a color printout of a satellite image. The resolution was commercial grade, good enough to show shapes but not details. A rectangular building sat in the center of a large parcel. Lighter ground around it suggested cleared or graded earth. A dark line ran from the building to the road, probably a gravel or dirt driveway. Two other shapes near the building could have been outbuildings or vehicles. Nothing else within a quarter mile in any direction. I pulled the Kern County Assessor records this morning, Marco said. The parcel is 22.3 acres, zoned agricultural residential. The improvement is a single-family residence, built 1997, 3 bedrooms, 2 baths, detached garage, domestic well. Assessed value $212,000. Owner. Desert Vista Holdings Trust. The property was transferred into the trust in 2018. The trust was established by a law firm in Bakersfield called Garrett and Rowe. Salazar wrote the name. Not Brannock Hale. Not any firm she'd seen in the Lusk case files. A different firm, a different city, a different part of the state. I ran Garrett and Rowe, Marco said. Small firm, 4 attorneys, real estate, estate planning, agricultural law. Trust work for ranch properties in Kern County. Clean. No connection to Lusk, Citadel, Brannock Hale, or any entity in the prosecution file. Salazar looked at the satellite printout. A house on 22 acres in the desert outside a military town. A truck that hadn't moved in 26 days. 23 minutes at Fraser's apartment. Long enough to knock on a door, have a conversation, and leave with a person who had decided that leaving was safer than staying. The cell tower data, she said. You said you had it. The subpoena also covered Ridgepoint's corporate phone accounts. Cortez has a business line registered to Ridgepoint. I pulled the tower records for February 25th through March 5th. And Cortez's phone was in the Las Vegas area through February 28th. On March 1st, it pinged towers along the route the truck took. Las Vegas, Kingman, Scottsdale. The phone went dark at 11 p.m. on March 1st. No tower pings at all from 11 p.m. March 1st through 6 a.m. March 2nd. He turned it off. He turned it off before he went to Fraser's apartment and turned it back on after he was past Barstow heading north. The phone pinged a tower in Ridgecrest at 6:48 a.m. on March 2nd. It's been pinging Ridgecrest towers consistently since then. Salazar looked at the map. The gap in the cell records matched the critical hours. The drive from Kingman to Scottsdale, the 23 minutes at Fraser's apartment, the drive back through Kingman and west across the desert to Barstow. The hours when the operation happened, the phone was dark. Everything before and after was visible. The operational window was clean. That's a professional protocol, she said. That's exactly what it is. Phone goes dark for the operational period. Comes back up when you're clear. Standard procedure for anyone who's done this kind of work. Marco said it the way he said most things. Flat, factual, dry. But there was something in the way he said standard procedure. Something that carried more weight than the 2 words usually held. You recognized the protocol, she said. He picked up his coffee and drank from it, set it down and turned it once on the desk. I recognized it because I've seen it before, he said. Not from law enforcement, from the other side. 6 years in the gang unit had put Marcos in rooms with people who operated in the gray zone between legal and illegal. He didn't talk about those years unless a case required it. This case was starting to require it. Private security contractors who did work corporate firms wouldn't touch. Witness relocation, personnel extraction, not kidnapping. Professional services for people who had reasons to disappear and the money to do it right. Always former military, licensed, insured, professional. But the clients needed things done quietly, and quietly costs more than loudly. Marcos looked at the blue line on his screen. I worked a case in 2017, he said. Gang unit. A mid-level supplier named Anaya needed to disappear. 3 days later, apartment empty, car in the lot, phone on the counter. The same signature. We never found him, but we found the firm that moved him. Highline Protective Group, Henderson, Nevada. Former Marine Raiders, licensed, insured. They did corporate security for casinos and ran a side business in personnel relocation. $20,000 for a standard package. $50,000 for long-term. We couldn't charge them. Anaya went voluntarily. And the network. The principals retired in 2020. The network didn't retire with them. Same ecosystem, different logos. Some of them work for Cortez now. Marcos looked at her. I still know people who know people, he said, from the gang unit days. Contacts who operate in that space. Not criminals, not exactly. People who have information because information is currency in that world, and they trade it the way bond traders trade paper. IA is already asking questions about your contacts. IA is asking questions about the Whitmore investigation, about the boot print evidence and whether I followed chain of custody. They're not asking about my gang unit contacts because they don't know those contacts are relevant to anything. If you start making calls to people in the gray zone while you're under an IA inquiry, and those calls connect to the Lusk case, you're giving them everything they need. I know. Marcos. I know. He picked up the coffee cup and looked into it and set it down empty. But the GPS data and the corporate filings give us the truck and the route and the property. They don't give us the client. Cortez didn't relocate Frazier because he woke up one morning and decided to drive to Scottsdale. Someone hired him. Someone who knew Frazier's name and address and the hearing date and the significance of his testimony. The corporate chain is clean. Every link is insulated. The only way to find out who hired Cortez is through the people who work in that network. And the people who work in that network don't talk to cops. They talk to you. They talked to me 6 years ago, when I was in the gang unit and I had relationships that took years to build, and those relationships were based on the understanding that I would use the information to go after people who were hurting the neighborhood, not to burn my sources. And now I'm a homicide detective at Hollywood Division under an IA inquiry for evidence handling in a case that has nothing to do with the gang unit. If I call Luis Aguilar or Danny Tran or any of the other people I used to work with in that world, I'm not calling as a gang unit detective with institutional backing. I'm calling as a guy who needs a favor. Will they answer? Marcos was quiet for a moment. He looked at his desk, at the coffee cup, at the printout with the satellite image of a house in the desert. at the notebook where he'd written the names and numbers and corporate filings in his small, precise handwriting. "Luis will answer," he said. "Luis always answers. He's not in the business anymore. He runs a body shop in Pacoima. But he knows everyone who's still active, and he keeps track because keeping track is what kept him alive for 20 years. If Ridgepoint is operating in the same network as Highline, Luis will know. And if IA finds out you called him, then IA finds out I called a retired associate who runs a body shop. That's not a crime. That's not even a policy violation. It's a phone call. It's a phone call that connects your gang unit history to the Lusk case while you're under inquiry for your involvement in the Whitmore case. It draws a line between the two things that IA doesn't have right now. IA already has whatever they have. The inquiry was filed. The questions were asked. I answered truthfully. Whether I make a phone call to a guy in Pacoima doesn't change what they're looking at. It changes what I can find out about who hired Eric Cortez to drive to Scottsdale and put Robert Frazier in a house in the desert. Salazar looked at him. Marcos looked back. His face was the same face it always was. Steady, unreadable, the face of a man who processed everything internally and only released what he chose to release. But his eyes were clear and his jaw was set, and she could see the decision already made behind the expression that didn't change. This was Marcos. This was who he'd been 8 months ago when he brought the boot print evidence directly to her instead of routing it through the chain of command. This was who he'd been 2 weeks ago when he told her in her kitchen on Beechwood Drive that he'd make the same choice again. He calculated the risk. He weighed the consequences. And then he did what the case needed because the case was the thing that mattered, and the institutional pressure was the thing that would pass, and the work would remain after the inquiry closed and the hearing concluded, and the bureaucracy moved on to its next target. "Make the call," Salazar said. Marcos picked up his phone. He stepped out of the bullpen and walked down the corridor toward the stairwell. Salazar watched him go. He held the phone to his ear with his left hand and opened the stairwell door with his right, and the door closed behind him, and he was gone. She turned back to her desk. She opened her notebook and drew a new column. In the middle, a space she left blank. The client. The blank space was the case. She worked the Gower stabbing while she waited. A DMV hit on a 2019 Camry from Marcos's partial plate work. She was pulling the registered owner's prior when Marcos came back. He sat down at his desk. He didn't say anything for a moment. He put his phone in his pocket and picked up the pen and wrote something on his legal pad. Then he turned to her. "Luis says Ridgepoint is real," Marcos said. "Active. They do corporate security for 2 casino resorts in Henderson and a tech company in Summerlin. That's the legitimate side. The other side is what Luis called relocation services. Discreet personnel movement for clients who need someone removed from a situation without law enforcement involvement." How many clients? Luis doesn't know the client list. Nobody outside the firm does. But he knows the network that Ridgepoint operates in because it's the same network that Highline operated in before the principals retired, and he told me something about the network that changes the picture. Salazar waited. The relocation business isn't freelance. It's not a menu you order from. The clients come through referral, specific referral. A law firm or a corporate attorney or an in-house counsel calls someone who knows Cortez. The buffer is always legal, always an attorney. Because attorney-client privilege covers the communication and the referral, and the client's name never appears on any document that Ridgepoint generates. The law firm is the cutout. The law firm is the insulation. Cortez gets a call from an attorney who says I have a client who needs a person moved. Cortez doesn't ask who the client is. He doesn't need to know. He gets the name of the person to be moved, the location, the destination, and the fee. The attorney handles payment through a trust account. The fee shows up as a legal expense on the client's books, not as a payment to a security firm. Salazar looked at the satellite printout again. A house on 22 acres in the desert, held by a trust established by a law firm in Bakersfield. Garrett and Rowe, she said. Luis doesn't know the name Garrett and Rowe. He doesn't work at that level, but the structure matches. A law firm sets up a trust. The trust holds property. The property is used as a relocation destination. The firm that set up the trust is the same firm that received the referral call. They're not just the real estate attorney, they're part of the network. A Bakersfield firm that does ranch trusts and agricultural law. A Bakersfield firm that does ranch trusts and agricultural law and also takes phone calls from people who need a house in the desert for someone who can't be found. It's not in their brochure. It's not on their website. It's a service they provide to a very small number of clients through a very specific referral chain. And the referral chain connects to Lusk. The referral chain connects to the ecosystem that Lusk operated in. Not to Lusk directly. That's the design. Cortez doesn't know who the client is. Garrett and Rowe may not know who the client is. The attorney who made the referral call is the only person who knows both ends, and that call is protected by privilege. Marcos put the pen down. Luis told me one more thing, he said. He said to be careful. He said the people who run this kind of network are not the people who get arrested when things go wrong. They're the people who survive because the structure is designed so that nothing connects back to them. The operators get exposed. The facilitators get exposed. The principals never do. Salazar closed her notebook. She looked at the blank space in the middle column. The client. The person who had survived Lusk's arrest, and Kelso's arrest and Hadley's proffer, and the Whitmore investigation and the habeas hearing and was still operational, still making calls, still moving pieces. We have the property, she said. We have the truck. We have Cortez's phone records showing he was on the route. We have the GPS data putting the truck at Fraser's apartment for 23 minutes. We have the destination. We have everything except the name that matters. We don't need the name for the hearing. We need Fraser's testimony. We have Fraser. What we need is the property and the proof that the relocation was connected to the defense ecosystem because that supports Okafor's forfeiture argument under Giles. If Lusk caused Fraser's absence, Strand's Crawford motion fails. And after the hearing. After the hearing, we give everything to major crimes. The corporate chain, the GPS data, Cortez, the network. Let them trace the referral. Let them subpoena Garrett and Rowe's trust records and phone records and find the attorney who made the call. Marcos looked at her. You're going to Ridgecrest, he said. I'm going to Ridgecrest. Not alone. Not alone. He nodded once. He stood up and took his empty coffee cup to the break room. Salazar heard the pot clank against the cup and the sound of someone pouring coffee that had been sitting too long and didn't care. She picked up her phone and called Okafor. He answered on the second ring. She could hear the office. She could hear the sound of a man who had been at his desk since before she was at hers, working a case that was 15 days from its final argument. Thomas, she said, I know where Fraser is. The line was quiet for a beat. "Where?" Okafor said. "A property outside Ridgecrest, California. High desert. A house on 20 acres held by a trust. The truck that was at the Flying J in Kingman drove from Scottsdale to this property on March 2nd. It hasn't moved since. Marcos traced the fleet records, the cell tower data, and the corporate filings. The truck belongs to the same ecosystem as Citadel EP, different names, same network." "Can you get to him?" "I'm leaving this afternoon. Marcos is coming with me." "Elena, if Frazier is there voluntarily, you don't have authority to remove him. You don't have jurisdiction. You don't have a warrant." "I'm not going to remove him. I'm going to knock on the door and talk to him. The same thing I did in Scottsdale. And if someone else answers the door—" Salazar looked across the bullpen at the stairwell door that Marcos had walked through to call a man in Pacoima who knew the shape of the network they were reaching into. She looked at the satellite printout on her desk. A house in the desert. A truck that hadn't moved in 26 days. A man who had been taken from his apartment in the middle of the night and driven 700 miles to a place where no one would find him. Someone had found him. "Then we'll find out who," she said. Chapter 18. Ridgecrest. They took the 14 North out of Santa Clarita and picked up the 395 past Palmdale. The Mojave opened up around them. Brown hills stripped of everything but rock and scrub. Joshua trees standing in clusters along the road shoulders. Marcos drove. Salazar rode shotgun with the Kern County Assessor printout on her lap and the GPS coordinates written on a post-it stuck to the dashboard. 22.3 acres northeast of Ridgecrest. Single-family residence. Desert Vista Holdings Trust. They didn't talk much for the first hour. Marcos had the radio on low, a country station out of Lancaster that dissolved into static past Red Rock Canyon. He turned it off, and the silence of the desert filled the car. "What's the play when we get there?" Marcos said. "We knock on the door." "And if Cortez is there?" "Then we talk to Cortez." "We don't have jurisdiction, we don't have a warrant, we don't have a case number. We have a missing witness and a GPS track that ends at a house in the desert." Marcos looked at her and then looked back at the road. He didn't say anything else about jurisdiction. They passed through Ridgecrest at 2:45. The town sat low against the desert floor. Fast food and gas stations along the 395 corridor. A Dollar General. A Tractor Supply. China Lake Naval Air Weapons Station to the west, its perimeter fence running along the highway for miles. A town that existed because the military needed it to. Past the town center, Marcos turned east on Ridgecrest Boulevard and then north on a 2-lane county road with no center line. The pavement was cracked and patched. Desert stretched flat to the mountains on both sides. No other cars. Salazar checked the GPS. 4 miles. The road climbed into low brown hills dotted with creosote and brittlebush. A cattle guard rattled under the tires. No cattle anywhere. No fencing either. Just the guard set into the road from some earlier arrangement that nobody had bothered to remove. "There," Salazar said. A dirt driveway broke off the county road to the right. No mailbox, no gate, no number posted, just tire tracks worn into the hardpan leading over a rise. Marcos turned onto the driveway and they climbed the rise and the property came into view. A single-story house with tan stucco walls and a flat roof. Not new and not falling down. A covered carport on the left side with a white pickup truck parked underneath. Ram 1500. Salazar could read the first 3 characters of the plate from 200 yards. They matched. No other vehicles. No outbuildings besides a small metal shed 30 yards from the house. No dogs, no cameras that she could see, no fence around the property itself. Just 20 acres of desert and a house sitting in the middle of it. Marcos pulled up behind the Ram and killed the engine. The silence was immediate and total. No traffic noise, no neighbors, no wind, just the ticking of the engine cooling in the afternoon heat. Salazar got out and stood for a moment looking at the house. The front door was solid wood with no window. 2 windows on either side, both with blinds drawn. A swamp cooler on the roof humming on low. Somebody was home. She looked at Marcos across the roof of the car. He had his hand resting on his belt near his badge, but not near his weapon, reading her the way he always did. "I'll knock," she said. She walked to the front door. The concrete step was swept clean. A welcome mat with the bristles worn flat. She knocked 3 times and stepped back to where she could be seen through the peephole. Nothing for 10 seconds. Then the sound of weight shifting on the other side of the door. A pause, the deadbolt turning. The door opened 6 inches, and Robert Fraser looked out at her through the gap. He was thinner than the photograph in his Scottsdale apartment. His cheeks had gone hollow and the skin under his eyes was dark. A week of gray stubble on his jaw. He wore a flannel shirt that hung loose on his shoulders and jeans that looked like they'd been bought for a bigger man. His eyes moved from Salazar to Marcos to the car, to the empty road behind them and back to Salazar. The whole scan took 2 seconds. "Mr. Fraser," Salazar said. "I'm Detective Renata Salazar, LAPD Hollywood Division. We spoke on the phone in January." Fraser's hand tightened on the edge of the door. His eyes moved past her again to the road. "Are you alone?" he said. "Just my partner, Detective Marcos. Can we come inside?" He looked at her for a long moment. She could see him working through whatever calculation he'd been running for 26 days in this house in the desert. Whether she was who she said she was. Whether the people behind her were who they said they were. Whether opening the door was the thing that saved him or the thing that ended him. He opened the door. The inside of the house was cool and dim. A living room with a couch and a recliner and a television that wasn't on. A kitchen visible through an open doorway. The blinds were drawn on every window. A paperback book lay face down on the arm of the recliner. A glass of water on the side table with condensation running down the sides. The house was clean. The carpet showed vacuum tracks. The kitchen counter was wiped. A dish rack by the sink held a single plate and a single fork. A man living alone and keeping the space tight because there was nothing else to do. Fraser stood in the middle of the living room with his arms at his sides. He didn't sit down. He didn't offer them anything. He just stood there looking at Salazar with an expression she had seen before on witnesses who had been carrying fear so long it had become the baseline state. Not panicked, not calm, just permanently braced. "How did you find me?" he said. "Your credit card, a truck stop in Kingman. We traced the vehicle." He closed his eyes for a moment and then opened them. "I used the card once. He told me not to use it at all." "Who told you?" Fraser looked at the drawn blinds on the front window as if he could see through them to the road. "Can we sit down?" Salazar said. He sat in the recliner. Salazar took one end of the couch. Marcos stayed standing near the kitchen doorway where he could see the front door and the hallway that led to the back of the house. A positioning choice that was automatic for both of them, and that Fraser either didn't notice or didn't care about. "Mr. Fraser, a lot of people have been looking for you," Salazar said. "Mr. Okafor has been calling for weeks. Scottsdale PD did a welfare check. I flew to Phoenix and went through your apartment." "I know," Fraser said. "I saw the missed calls when I left. I couldn't call back." "Couldn't or wouldn't?" "Both." She waited. He rubbed his hands on his knees and then stopped and placed them flat, controlling the motion. She could see him assembling the words, putting them in order the way people do when they've rehearsed a story in their head for a long time without ever saying it out loud. "A man came to my apartment," Fraser said. "February 28th, Friday evening. I was making dinner. He knocked on the door." "What time?" "Around 6:30. Still light out." "Did you look through the peephole?" "Yes. A man I'd never seen. 40s, dark hair, wearing a sport coat. He was standing back from the door so I could see him. Hands visible. He looked like a real estate agent." Salazar glanced at Marcos. The physical description matched Navarro, matched the man at Kowalski's dental office, matched the figure on the Flying J footage. "He said his name was Mike. He said he was a security consultant. He showed me a business card, white card, blue lettering. I don't remember the company name. He said he needed to talk to me about my safety." "Your safety?" "He said my sworn statement in the Cole case had put me in a position. Those were his words, a position. He said there were people connected to the original case who were aware of what I'd said, and that my testimony in the upcoming hearing would make me a target for retaliation." "Did he say who?" "No, he said he wasn't authorized to share specifics. He said his job was to offer me a safe option." "What was the option?" Fraser rubbed his hands on his knees again, caught himself again, put them flat. "Relocation. Temporary. He said arrangements had been made. A house in a quiet area, furnished, stocked, no contact with anyone until the situation was resolved. He said it was my choice and that he would leave if I said no." "And you said yes?" "Not right away. I told him I needed to think about it. He said he understood. He said he'd wait in his car for 30 minutes and then he'd leave and I'd never see him again." "What did you do?" "I sat at my kitchen table. I thought about the phone calls." "What phone calls?" Fraser looked at his hands. "After I gave the sworn statement in January. 2 calls, both from blocked numbers. The first one was just breathing, 10 seconds, and then it disconnected. The second one was a voice, a man. He said my name and then he said, 'You should have stayed quiet.' That was all." Salazar kept her face still. This was new, not in Fraser's statement, not in anything Okafor had shared. "Did you report these calls?" "No." "Why not?" "Because I didn't know who to report them to. I gave the statement. I told the truth. I thought it was over. Then the calls came and I understood it wasn't over. It was never going to be over." He paused. The swamp cooler hummed on the roof. Somewhere outside, a bird called once and stopped. So, when the man came to my door and said he could keep me safe, I wanted to believe him. I wanted to believe someone was looking out for me. Did he tell you who sent him? He said he worked for a firm that handled security matters for legal proceedings. He said it was better for everyone if I didn't know the specifics. And that didn't concern you. Fraser looked at her with something that might have been anger or might have been shame. It was hard to tell. They lived in the same part of the face. Detective, everything concerned me. Everything has concerned me since the day I walked into a room and told a stranger what I saw in a parking lot in 2016. His hands were flat on his knees again. Being concerned doesn't mean you know what to do. It means you're afraid and you're waiting for someone to tell you the right move. He stopped talking. He was breathing harder than when he'd started. She gave him a moment. "What happened next?" she said. "I packed one bag. He drove. I sat in the passenger seat. We drove all night. He stopped once for gas in Arizona. I stayed in the truck. We got here in the morning." "Did he use your credit card at the gas stop?" "I don't know. He went inside the station. He might have taken it from my bag. I had my wallet." "Your wallet was on your dresser in Scottsdale." Fraser stared at her. "He must have taken it out of my bag before we left. I didn't notice until the next day. By then we were already here." "So he had access to your wallet, your keys, your phone." "He left them in the apartment to make it look like I was still there, or coming back. I don't know which." "Did he tell you that's what he was doing?" "No. He just said to bring one bag and that everything I needed would be here." "And it was?" "Clothes, food, toiletries, books. The place was already set up, like someone had stocked it for exactly this." "How long were you supposed to stay?" "He said until the situation was resolved. He said someone would contact me." "Has anyone contacted you?" "No, he left the first morning. I haven't seen him since. He left a phone, a prepaid. He said to use it only if there was an emergency and to call the one number programmed into it." "Have you called it?" "Once, 2 weeks ago. It rang 4 times and went to voicemail. No name, no greeting, just a tone. I hung up." Salazar looked at Marcos. He was writing in his notebook. He caught her look and gave a small nod. He had the same question she did. "Mr. Fraser," she said, "do you believe this man was protecting you?" Fraser didn't answer right away. He looked around the room as if seeing it for the first time. The drawn blinds, the clean carpet, the single plate in the dish rack, the silence of 20 acres of desert on all sides. "I don't know," he said. "That's what I've been asking myself every day for 26 days. He looked at the drawn blinds. He never threatened me. He never raised his voice. He gave me a choice, and I made it. He brought me here alive and unhurt." He paused. "But he also took my phone. He took my wallet. He took my keys. He drove me to the middle of nowhere in the dark and left me with no car and no way to contact anyone except a phone number that nobody answers. He told me not to call anyone. He told me not to leave. He said it was for my safety." Fraser looked at Salazar. "So you tell me. Was I rescued or was I captured? Because I've been sitting in this house for almost a month and I still don't know." The question sat in the room. No threats, no violence, no demands. But the effect was the same. Fraser was removed from the case. Not Lusk. His world had been Kelso and direct action, not Strand. She filed motions. Someone else. Salazar looked at Fraser. He was watching her face for the answer she didn't have. "The prepaid phone," she said. "Where is it?" He got up and went down the hallway. She heard a drawer open and close. He came back holding a cheap black flip phone. She took it with the tissue from her pocket and turned it over. No brand marking on the case. She opened it. One contact in the directory, a 702 area code. Las Vegas. "Marcos," she said. He came over and took the phone from her, still wrapped in the tissue. He wrote down the number and checked the call log. One outgoing call, 14 days ago, 42 seconds. No incoming calls, no texts. "Mr. Fraser," Salazar said, "I need to ask you something, and I need you to think about it carefully." He waited. "The man who came to your door, the calls you received after your statement, did anyone else know you had given a sworn statement in the Cole case?" "Mr. Okafor knew. You knew. I assume the district attorney's office knew." "Did you tell anyone else? Family, friends, neighbors?" "I don't have family. I don't have friends in Scottsdale. My neighbor across the hall and I say hello in the hallway. That's it. I didn't tell anyone." "So only people inside the legal proceedings knew about your statement." Fraser looked at her. He understood what she was saying. The fear came back into his face, not new fear. The old fear, the one that had been sitting in his chest for 26 days and longer. The fear that the system he'd trusted enough to tell the truth was the same system that had delivered him here. "I want to leave," he said. "I want to leave this house." "We can take you out of here right now," Salazar said. "But I need you to understand something. There's a hearing in 14 days. Your testimony matters. Without you, the case is weaker." "I know what the case needs. I've been sitting here for a month with nothing to do but think about what the case needs." "And?" Fraser stood up. He walked to the front window and pulled the edge of the blind aside an inch. Desert. The empty road. The white ram under the carport. He let the blind fall back. "I'll go with you," he said. "I'll leave this house. But I'm not making any promises about testifying, not today. I need to think. I need to talk to Mr. Okafor. I need to understand what happens to me if I walk into that courtroom." "That's fair," Salazar said. "Is it? Because nothing about any of this has been fair. Not for me. Not for 10 years. She didn't argue with him. There was nothing to argue with. Fraser went down the hallway to pack his bag. The same bag he'd packed in Scottsdale 26 days ago. Marcos stepped close to Salazar. "The 702 number," he said. "I can have it run by tonight." "Do it." "The truck stays here?" "The truck stays. It's Apex Fleet. It's evidence. We need to photograph the house, document everything." "I know." She paused. "How's your thing with IA?" "Still open, hearing next week." "You shouldn't be here, Luis." "I'm here." They spent 15 minutes photographing the house with their phones while Fraser packed. The pantry. The bathroom with toiletries still in drugstore packaging. The bedroom, the prepaid phone already bagged, the Rams plates. Fraser came out with his bag. He stood on the front step and looked at the desert. She couldn't read his face. They got in the car. Fraser sat in the back seat behind Marcos. Salazar turned to look at him. "Buckle up," she said. "It's 3 hours." Marcos started the engine and pulled down the dirt driveway toward the county road. In the rear-view mirror, the house got smaller and then disappeared behind the rise. The Ram sat alone under the carport. The swamp cooler ran for nobody. Salazar pulled out her phone and dialed Okafor. It rang twice. "We have him," she said. "He's alive. He's coming back." She could hear Okafor exhale on the other end. "Is he willing to testify?" "He's willing to talk. That's where we are." She hung up and looked out at the desert rolling past. Brown hills and creosote, and the 395 stretching south toward a city where 14 days from now a judge would decide whether 10 years of silence had meant anything at all. She had the witness, she had the prepaid phone, she had the 702 number and the Ram and the house and Fraser's account. What she didn't have was the name of whoever decided that protecting Robert Fraser was worth more than his testimony, and until she had that name, the question Fraser had asked in the living room of a house in the desert would keep asking itself. Was he rescued, or was he captured? The answer mattered, not just for the hearing, for everything that came after. Chapter 19. The Choice. They put Fraser in a hotel on Cahuenga Boulevard near Franklin, not one of the places tourists stayed. A 2-story motor lodge with exterior corridors and parking in front of the doors and a woman at the front desk who didn't look up when Salazar paid cash for a week. Room 214. Second floor, corner unit. A view of the Hollywood freeway overpass and the back wall of a storage facility. Okafor wanted Fraser downtown. Conference room, court reporter, the whole legal team. Salazar told him no, not yet. Fraser had been in a house in the desert for 26 days with drawn blinds and a dead phone. He needed a shower and a meal and 12 hours where nobody asked him anything. She left him at 11:15 Wednesday night with a prepaid phone she'd bought at a 7-Eleven on Highland. Her number and Okafor's written on a piece of paper folded in the back of the case. She told him to sleep. He closed the door, and she heard the deadbolt turn and then the chain. She drove home to Beechwood Drive and sat at her kitchen table for 20 minutes without taking off her jacket. 3 hours back from Ridgecrest. Fraser in the back seat behind Marcos. He'd said almost nothing for the first 2 hours. Then, somewhere past Mojave, he'd said a single sentence that she'd written in her notebook at the next red light in Palmdale. "There's something else I haven't told you." She'd asked him to hold the thought. Too tired, all of them. She told him she'd come back in the morning. Now it was morning, Thursday. 14 days until the hearing. She stopped at the Cuban bakery on Sunset in Vermont for 2 café con leches and a bag of pastelitos and drove up to the hotel. She parked in front of 2 at 14 and climbed the exterior stairs. Knocked. Fraser opened it wearing the same flannel shirt from the desert house. He'd shaved. His face looked 10 years older without the stubble, the skin loose along the jaw, the hollows under his eyes deeper in the morning light. He looked at the coffee in her hand and stepped back to let her in. The room was small and clean enough. A queen bed, a desk and chair, a television mounted to the wall. The curtains were open. She noticed that and filed it. In the desert house, every blind had been drawn. She set the coffee and the bag on the desk. He took the café con leche and held it with both hands and sat on the edge of the bed. She took the desk chair and turned it to face him. "You said there was something else," she said. Fraser drank, set the cup on the nightstand, picked it back up. "After I gave the sworn statement," he said, "in January, Mr. Okafor's office. You were there." I was there. I went home to Scottsdale. I felt good for about 3 days, like I'd finally done the thing I was supposed to do, said what I saw, put it on the record. He paused. Then I got a phone call, blocked number. January 15th, about 4 in the afternoon. A woman's voice, calm, professional. She said, "Mr. Fraser, you've done a brave thing. We want to make sure you're safe." Salazar's hand stopped halfway to her coffee. She asked if I had family nearby, if I had considered what my testimony might mean for my living situation. She gave me a phone number to call if I ever felt unsafe. She said it wasn't connected to any law enforcement agency, a private service for people in my situation. "Did you write the number down?" "On a napkin. I threw it away the next day." "Did you call it?" "No." "Did you tell Okafor?" "No." "Why not?" Fraser looked at the cup in his hands. "Because she didn't threaten me. She didn't tell me not to testify. She didn't even mention the hearing. She just wanted to make sure I was safe, and at that point, I wanted to believe that someone was watching out for me." He set the cup down on the nightstand carefully, centering it on the coaster. 2 weeks later, a man came to my apartment. January 29th, a Wednesday, around noon. Standing there in a gray suit. 60s, silver hair, thin, he had a folder. "Different man from the one who relocated you." "Completely different. The man in February was younger, dark hair, the one who called himself Mike. This man was older, quieter. He'd done this before." "What did he say?" "He said he was following up on the phone call. He represented a group that assisted witnesses in high-profile cases. Not law enforcement, not a non-profit. He didn't say who." "All of this in your kitchen." "At my kitchen table. He had printed forms, relocation assistance, financial support, new identification if necessary. Laid it all out like he was selling insurance." "Did he show identification?" "A business card, white stock, good paper, a name and a phone number, no company, no logo." "Do you remember the name?" "Prescott. First name started with a D. David or Daniel." "Do you still have the card?" "It was in my wallet, which was on my dresser in Scottsdale when you found it." She noted that. If the wallet was still in evidence, she could pull the card. "What happened with this man?" "He sat in my kitchen for 40 minutes. He explained options the way a financial advisor explains options. He said the hearing was going to be difficult and that there were people who didn't want me to testify and that those people had resources. He could make arrangements for me to be somewhere safe during the proceedings. Afterward, I could decide whether to return or start fresh." "And you said?" "I said I'd think about it. He said the number from the phone call would still work. He picked up his folder and left." "Did he tell you not to contact anyone about the visit?" "He said it was confidential, that the program worked best when witnesses didn't discuss it with attorneys or law enforcement." "And you kept it confidential." "I didn't tell Mr. Okafor. I didn't tell you. I put the business card in my wallet and sat in my kitchen for an hour, trying to understand what had just happened. Fraser stood up from the bed. He crossed to the window and looked out at Cahuenga Boulevard. Then the threatening calls started. February, a different voice, a man. You should have stayed quiet. I told you about those at the house. You told me. And then Mike came, February 28th. And Mike didn't talk about safety programs. He talked about my life being in danger. Right now, tonight. 3 different approaches, Salazar said. The nice call, the nice visit, then the threats. And I couldn't tell which side any of them were on. Same people, different people. When Mike said he could take me somewhere safe, I said yes, because I was done trying to figure out who was telling the truth. He turned from the window. That's what I haven't told you. There was a whole thing before the relocation. Layers. Like someone was building something around me one piece at a time. Salazar sat with it. January 15th, the phone call. 12 days after the sworn statement. January 29th, the man with the folder. Then February, the threats. Then February 28th, Cortez. Each contact narrowing the space around Fraser until the only move left was to disappear. The woman on the phone and the man with the folder, Salazar said. Were they connected to the man who took you to Ridgecrest? I don't know. Mike never mentioned them, but the timing, you see the timing. She saw it. Mr. Fraser, the hearing is April 14th. I need to ask you if you're willing to testify. He sat back down on the bed, not on the edge this time. Further back, his shoulders against the headboard, his legs stretched out, the posture of a man too tired to sit up straight. I knew you were going to ask me that. I know you did. I've been thinking about it since you knocked on the door in Ridgecrest. Since the first week in that house when I understood that nobody was coming and the phone number didn't work and I was just sitting in the desert waiting for something that was never going to happen. He looked at the ceiling. If I testify, what happens to me after? After the hearing? After everything, where do I go? I can't go back to Scottsdale. I can't go back to California. I've been running for 10 years, Detective. Since the day I watched that conversation in that parking lot and didn't say anything. And I'm tired. His voice didn't break. It stayed flat and level and exhausted. I'm 54 years old. I have a Social Security check and $11,000 in savings. I don't have a career or a family or a friend within 500 miles of anywhere I've lived in the past decade. He looked at his hands. I gave a statement because you and Mr. Okafor told me it mattered, and within 2 weeks my life as I knew it was over. Not because someone beat me up or put a gun to my head, because the phone rang and a nice woman said she wanted to keep me safe. He looked at Salazar. So, if I testify, if I do this thing, what happens to me? Who takes care of Robert Fraser after the system is done with Robert Fraser? She didn't have an answer. She was a homicide detective from Hollywood Division. She didn't run a witness protection program. She had her badge and her notebook and the fact that she'd driven to the desert and knocked on the door. I'll figure something out, she said. Fraser studied her face. He'd spent 26 days reading the walls of a house in the desert. He could read a face. You don't know, he said. I don't know yet. I'll talk to Okafor. There are programs. The last person who told me there were options laid them out on my kitchen table in a folder, and I ended up in a house in Ridgecrest with no phone. She let it land. He was right. Mr. Fraser, I can't guarantee your safety. I can't guarantee what happens after the hearing. What I can tell you is that there's a man named Marcus Cole who has been sitting in a cell for 10 years for something he didn't do, and your testimony is part of what gets him out. I'm not going to pretend that's your problem, but you asked me in Ridgecrest if you were rescued or captured. Those are the right questions. I don't have all the answers, but I'm not going to put you somewhere and disappear. The room was quiet. Cahuenga Boulevard hummed outside the window. Fraser sat against the headboard, looking at her for a long time. Long enough for a siren to pass on Franklin and fade east toward Los Feliz. Long enough for the refrigerator in the corner to cycle on and off. "I'll testify," he said. She waited. "But I have a condition. Not negotiable." "Tell me." "I'm not going to Los Angeles Superior Court. I'm not sitting in a room with those lawyers and that judge and the people who watched a man get sentenced to die based on a trial that was fixed. I'll testify by video, by phone, by deposition, whatever method the law allows, but I'm not setting foot in a courtroom in Los Angeles." "Can they do that? Can the judge allow it?" "There are provisions for remote testimony," Salazar said. "Penal Code Section 1447. The court can allow it if there's good cause." Good cause. I was relocated to a house in the desert by someone who may or may not have been trying to help me. I've received threatening phone calls. A man came to my home with a relocation folder. I haven't slept through the night in 2 months. Is that good cause? I think a judge would find that persuasive. A judge. The same system that sentenced Cole and lost my report and sent a nice man to my kitchen with a folder. She didn't tell him he was wrong. "If the judge allows it, you'll testify from a monitored location, a federal building or a courthouse in another jurisdiction. Camera, screen, court reporter. It gets entered into the record the same as if you were in the witness chair." "And Strand gets to cross-examine me?" "Yes. That's what makes it admissible. And if you testify remotely, the Crawford objection goes away. Your statement comes in. Your live testimony comes in. Strand loses her strongest motion." He was quiet. She could see him working through it. Slowly. A man who had learned that moving fast meant moving into traps. "Remote testimony. Not in Los Angeles." "Not in Los Angeles. And you'll talk to Okafor about what happens after." "Today." "And you'll call me. On this phone. You won't just disappear and send someone else." "I'll call you myself." He nodded. He picked up the café con leche that had gone cold and drank the rest of it. Set the cup on the nightstand next to the one from before. 2 cups. The most dishes she'd seen him use since Scottsdale. "I want to ask you something," he said. "Go ahead." "The woman who called me. The man with the folder. And then Mike. 3 different people, 3 different contacts. Do you think they all work for the same person?" "I don't know. But someone decided this. Someone decided that Robert Fraser needed to disappear, and they spent 6 weeks building it. Phone call, visit, threats, extraction. Somebody sat in an office somewhere and mapped it out. That's what it looks like." "Who?" Salazar looked at the pastelito bag on the desk. Neither of them had eaten. "That's what I'm trying to find out. And you can't tell me who." "Not today." Fraser walked to the window again. the bed and the window, back and forth. "I keep thinking about something," he said. "The woman on the phone. She said, 'You've done a brave thing.' Not, 'You did a brave thing.' Present perfect. Like she knew within hours that I'd given the statement. Like she was watching in real time." Salazar was writing in her notebook. "Someone inside the proceedings," Fraser said. "Someone who knew the day I gave my statement and had a phone number ready to call me 12 days later." He turned from the window. "Whoever it is, they're still out there. They know I was in Ridgecrest. They might know I'm here. They'll know when I testify." "I know. And you can't protect me from someone you can't identify. I'm going to find out who it is." "Before the hearing?" She met his eyes. "I'm going to find out who it is." She didn't say before the hearing. She didn't say after. The fact that she didn't qualify it was the most honest thing she'd said all morning. Fraser looked at her for another moment, and then he opened the bag on the desk and took out a pastelito and bit into it. "This is good," he said. "I haven't eaten anything that didn't come out of a can or a box in a month." Cuban bakery on Sunset. He finished the pastelito and wiped his hands on his jeans. "I'll testify. Remote. Not in that building." "Understood." She stood up and he walked her to the door. She stopped in the doorframe. "Robert, the man Prescott, the folder with forms. Was there a letterhead, a logo, anything identifying the organization?" He looked at the wall above the television. She watched him pull it up from wherever he kept it. Months ago, a kitchen table, a man in a gray suit laying out papers. No letterhead, plain paper, but the forms had a case number at the top. Numbers and letters. I remember thinking it looked like a government filing number. Can you remember any of it? WR and then numbers. I didn't memorize it. I wasn't expecting to need it. She wrote it in her notebook. "Thank you, Robert." She walked down the exterior stairs to the parking lot. The morning sun was hitting the storage facility wall and bouncing back warm and white. She sat in her car and called Okafor. "He'll testify," she said. "Remote only. He won't set foot in the courthouse." Okafor was quiet for a moment. "Strand will oppose it," he said. "She'll argue he's available and choosing not to appear." He was relocated to the desert by a professional who left him with no phone. He's received threatening calls. A man showed up at his apartment with a relocation folder before any of it. He has legitimate fear. Does he have documentation? A business card in his wallet. The wallet's an evidence from Scottsdale. The card belongs to a man named Prescott who visited him in January, and there's something else. She told him about the phone call on January 15th. The woman's voice. The offer of safety. Then the man with the folder 2 weeks later. When she finished, Okafor said, "January 15th, 12 days after the sworn statement." "That's what I said." "Who knew about the statement?" "You, me, your team, and whoever the filing was served on." "The filing wasn't served on anyone yet. We hadn't filed the supplemental petition in January. The statement was taken for preparation. It wasn't on any court record until February." The line was quiet. "So the only people who knew were the people in the room," Salazar said. my office, my paralegal, you, Marcos, and Fraser. 5 people. And whoever any of those 5 told. Salazar stared through the windshield at the hotel. Room 214. Curtains still open. "I'll file the remote testimony motion today," Okafor said. 1947, Fraser's declaration on the threats and relocation. Strand gets notice by close of business. And the hearing is in 14 days. Which means Yamada rules on the motion at the latest on day 1. If she grants it, Fraser testifies by video link. If she denies it, he either appears in person or we lose him. He won't appear in person. I understand. I'll make some calls about what comes after. There are organizations, nonprofits that assist witnesses in wrongful conviction cases. It's not a program, but there are people who do this work. She started the engine. 14 days. A witness who would testify but not in person. A defense attorney who would oppose. And somewhere in the background, someone who had known about Fraser's statement within 12 days and spent 6 weeks building the machinery of his disappearance. WR and then numbers. A woman's voice saying, "You've done a brave thing." Present perfect. Someone who was watching in real time. She turned south on Cahuenga toward Hollywood Division. The Gower stabbing was still cold. Marcos had left 2 messages, one about the 702 number, one about his professional standards callback on Monday. The desk didn't stop because the hearing was coming. None of it stopped. Chapter 20. Who Sent the Man? Friday. 13 days until the hearing. Salazar spread the corporate filings across her desk at Hollywood Division and started from the vehicle. That was the only hard evidence. Everything else was a voice on a phone, a man in a gray suit, a business card in a wallet. The white Ram 1500. Arizona plate. 3 layers of corporate registration between the plate and the man who drove it. Fleet company to mobility group to security firm. At the bottom of the chain, Ridgepoint Security Consulting. Managing member Eric Cortez. Former Army MP. Former Citadel EP. Cortez was the man who called himself Mike. The man who drove Fraser through the desert to the house outside Ridgecrest on February 28th. That chain was documented. GPS data, cell tower records, fuel receipts, insurance subpoena returns, every link verified. But Cortez was the hand, not the brain. Marcos came back from the break room with 2 coffees and set one on the corner of her desk without looking at the papers. "You get my message about the 702 number?" "I got it." Prepaid. Bought at a Walmart on Tropicana in Las Vegas. January 8th. Cash purchase, no ID for activation. January 8th, Salazar said. 7 days before the woman called Fraser. Someone bought a phone a week before the first contact and gave Fraser the number as a safety line. The 702 prefix is Las Vegas, same city as Apex, Trident, Ridgepoint, and Cortez. And Prescott? I ran every Prescott with a first name, starting with D in the Nevada and California bar registries, PI license databases, corporate officer filings, and voter rolls for Clark County. Nothing clean. 14 David Prescotts, 3 Daniel Prescotts. None of them connect to security consulting, witness services, or any entity in the Lusk ecosystem. It's a work name. Almost certainly. The business card in Fraser's wallet is at Scottsdale PD in the evidence hold from the welfare check. I called this morning. They'll release it to us with a letter from Okafor on the habeas case letterhead. We should have it Monday. Salazar picked up her coffee. It was burnt. She drank it anyway. The property trust, she said. Desert Vista Holdings, established by Garrett and Rowe, general practice firm in Bakersfield. They set up the trust, they hold the title, they pay the property tax. Clean on paper. And Luis told you Garrett and Rowe received the referral. The referral came through attorney channels. Somebody called somebody who called Cortez, and the law firm that received the call is the same firm that set up the destination property. Attorney-client privilege covers every conversation in the chain. So, we have a vehicle registered to a fleet company managed by a holding company that services a security firm run by a former Citadel EP employee. We have a property held by a trust established by a law firm that received an attorney referral. We have a prepaid phone bought with cash in Las Vegas a week before the first contact. And none of it leads to a name. Marcos sat down at his desk. He leaned back in his chair and looked at the ceiling. 3 possibilities, he said. Salazar waited. 1. Lusk's people. What's left of the network. Marcos picked up a pen and turned it between his fingers. Brannock Hale is still the registered agent for every Lusk entity. Someone in that ecosystem picked up the phone. To make Frazier unavailable. Legally, quietly, and if we ever trace it, they say they were trying to help a frightened witness. He set the pen down. The defense is built into the operation. Every piece is defensible. Every piece makes us look paranoid for asking questions. 2, Salazar said. A third party. Someone from the original conspiracy who wasn't exposed. Hadley flipped. Kelso is in custody. But the planning commissioner is dead. The Brannock Hale associates who handled the Citadel EP registration are still practicing, and we never identified everyone at the March 2015 party at Lusk's house. Someone who knows the network exists because they were part of it. Someone who has the contacts and the money and the motivation to keep Frazier away from the witness stand without getting their own hands dirty. 3. Marcos looked at her. Someone who genuinely wanted to protect him. Salazar put her coffee down. You don't believe that. I'm listing possibilities, not endorsing them. Which one do you like? Marcos was quiet for a moment. A phone rang somewhere in the bullpen and stopped. Option 1, he said, and it's not close. Why? Because it's too clean. The fleet company is legitimate. The security firm is licensed. The property trust is legal. He tapped the desk with his index finger. The prepaid phone is untraceable by design, not by accident. And the first contact came 12 days after Frazier gave his sworn statement. 12 days. The only people who knew about it were in Okafor's office. Salazar pulled her notebook closer. That doesn't mean someone in the room. It means someone who was told, or who saw the file, or who handles intake for the Capital Defense Unit. Salazar opened her notebook. The 2-column page she'd been building since Scottsdale. Left column, what she knew. Right column, what it meant. The woman who called Frazier, she said. Professional. Calm. Offered a safety program. Gave him a Las Vegas number. 12 days after the statement. Intake, Assessment. Establishing contact. The man who came to his apartment, Prescott or whatever his name is, January 29th, gray suit, folder with printed forms, case number starting with WR, sat in the kitchen for 40 minutes explaining options. Recruitment, building the file, making it feel institutional. Then the threatening calls. February, different voice, male, direct. Pressure, creating the fear that makes the extraction feel necessary. And then Cortez, February 28th, the extraction itself. Marcos nodded slowly. 4 contacts, 4 different people, 4 different functions. Intake, recruitment, pressure, extraction. That's not someone trying to help a scared man. That's a campaign. Salazar stared at the corporate filings on her desk. The Nevada Secretary of State printouts. The California Foreign Entity registrations. The insurance subpoena returns. Every document clean. Every entity registered. Every fee paid. Kelso was a pipe wrench, she said. Marcos looked at her. Kelso was Lusk's instrument last time. Former Marine. Boot print on a dead woman's porch. Cell tower pings 13 minutes before a murder. She tapped the Ridgepoint filing. This is different. This is someone with imagination. Blunt force. This is different. This is surgical. 4 contacts over 6 weeks. A prepaid phone bought a week before the first call. She counted on her fingers. Fleet vehicle from a legitimate company. Property trust through a general practice law firm. Attorney-client privilege at every junction. And at the end of it, a frightened man in a desert house believing he'd been rescued. Marcos finished his coffee and set the cup next to his keyboard. Different hands. Different hands, different level. Kelso made problems disappear permanently. This was the opposite. Make a witness disappear temporarily, legally defensible, emotionally persuasive, structurally untraceable. Which means either Lusk upgraded his methods, or someone else is in the mix who was always smarter than Lusk. Marcos let that sit. Lusk was a real estate developer. He solved problems with money and muscle. Kelso, Hadley, the planning commissioner's bribe. Direct payments, direct threats. The Fraser operation was none of those things. She picked up the phone and called Okafor. He answered on the second ring. I was about to call you. Strand filed her opposition to remote testimony an hour ago. 12 pages. She's arguing Fraser is voluntarily absent and the confrontation clause requires in-person cross-examination for a meaningful assessment of credibility. Is she right? She's making a serious argument. The case law on remote testimony in habeas proceedings is thin. Most of the 1347 precedent is from criminal trials during COVID, and courts have been pulling back since 2023. Yamada's going to have to weigh Fraser's safety concerns against Lusk's constitutional right to confront witnesses. Fraser's not going to walk into that courthouse. I know. I'm drafting his declaration tonight. I need specifics. The threatening calls, the woman's voice, the man with the folder, the relocation, all of it. Dated, detailed, and under penalty of perjury. I'll put it together. But that's not why I'm calling. What? The relocation, who ordered it? Okafor was quiet for a beat. She could hear papers on his desk. Elena, I need Fraser's testimony admitted. That's the priority. If we get the remote testimony ruling, Strand loses Crawford. If we lose it, we lose Fraser entirely. The question of who relocated him is important, but it's not April 14th important. It might be. How? Because if Strand can show that the relocation was protective, not obstructive, it undermines our argument that Fraser was in danger. If someone genuinely tried to help him, Strand argues he had options and chose to disappear. That makes his fear subjective, not reasonable. And subjective fear doesn't meet the 1347 threshold. The line was quiet. That's a good point, Okafor said. And if the relocation was Lusk's network, that's forfeiture by wrongdoing. Strand's client caused the witness's absence. Under Giles, the confrontation clause doesn't apply at all. Not only does Fraser testify remotely, but his original sworn statement comes in without cross-examination. Which is why Strand will argue it wasn't her client. Which is why I need to prove it was. In 13 days. In 13 days. Okafor exhaled. She could picture him in room 412 with his tie loosened and his reading glasses pushed up on his forehead and file folders covering every flat surface. What do you have? Corporate chain from the vehicle to a former Citadel EP employee named Cortez. Property trust through a Bakersfield law firm. Prepaid phone bought in Vegas 7 days before the first contact. That's the infrastructure. And 3 pre-relocation contacts. A woman's call, a man's visit, threatening calls, 4 different people, 4 different functions, 6 weeks. The pre-relocation contacts are new. Fraser held them back until yesterday. He wanted to see if I'd come back. And you came back. I came back. Thomas listened to me. Kelso put a boot print on Patricia Whitmore's porch. That was a pipe wrench. This operation has a prepaid phone, a fleet vehicle, a security firm, a law firm, a property trust, and 4 separate human contacts over 6 weeks. That's not the same person giving orders. You think there's someone above Lusk. I think the man who hired Kelso to solve problems with blunt force didn't design an operation with 4 phases and attorney-client privilege at every link. Someone else built this. Someone who was in the original network or connected to it. Someone who knew about Fraser's statement within 12 days and had the infrastructure to act. Okafor didn't respond immediately. She heard his chair creak. The statement wasn't filed in January, he said. It was taken for preparation. Internal work product, my office, my paralegal, you, Marcos, and Fraser. And whoever was told. Nobody was told. I didn't disclose it to the court until the supplemental petition in February. I didn't discuss it with co-counsel until I brought on the UC Irvine team in late January. I didn't share it with the Innocence Organization until February 3rd. When did you bring on UC Irvine? January 22nd. Salazar wrote the date in her notebook. January 22nd, UC Irvine. 7 days before Prescott showed up at Fraser's kitchen table. Who at UC Irvine? Professor David Shin and 2 research fellows, all vetted, all experienced in capital defense. David Shin. Different David. His last name is Shin, not Prescott. But he knew. He knew we had a juror who was cooperating. I didn't share the statement itself until the first week of February. You told him there was a cooperating juror on January 22nd. In general terms, that we had a breakthrough. A juror willing to provide sworn testimony about intimidation during deliberations. And he could have mentioned it in a faculty meeting, at a conference, over dinner, not maliciously, just the way people talk about interesting cases. The line was quiet for a long time. "I'll get you a list," Okafor said. "Everyone in my office who touched the file. Everyone at UC Irvine who was briefed. The Innocence Organization contacts, dates, names, access levels. By tomorrow. By tomorrow." She hung up. Marcos was looking at her from across the desk. He'd been listening. "UC Irvine was briefed January 22nd, she said. Prescott showed up at Fraser's door January 29th. 7 days. The woman called on January 15th. The prepaid phone was bought January 8th. Marcos pulled a legal pad toward him and wrote the dates in a column. January 8th. Phone purchased Las Vegas. January 15th. Woman calls Fraser. January 22nd. Okafor briefs UC Irvine. January 29th. Prescott visits Fraser. He looked at the column. Then he looked at Salazar. The phone was bought before Okafor briefed UC Irvine. The woman called before he briefed them. The operation started before the information left Okafor's office. Salazar stared at the dates. She'd been building toward UC Irvine as the leak. 7 days between the briefing and Prescott. It fit, it was clean, it made sense. But the phone was bought January 8th, and the woman called January 15th. Both before January 22nd. "So, it's not UC Irvine," she said. "Not unless they were briefed earlier than Okafor remembers. Or not unless the information came from inside Okafor's office." Marcos set his pen down. 5 people, he said. In the room when Fraser gave his statement on January 3rd. Okafor, his paralegal, you, me, Fraser. And whoever handles Okafor's case files. His secretary, the office manager, anyone who saw the intake form or the scheduling calendar or the name Robert Fraser on a conference room booking. You're going to ask him to audit his own office. I'm going to ask him to give me the access log for the Fraser file. Who opened it, when, from which terminal. Marcos looked at the papers on her desk. The corporate filings, the timeline, the notebook with 2 columns. Salazar. What? This is going to make him uncomfortable. I know. He's your ally. He's Cole's lawyer. He's the only reason this hearing is happening. I know that too. And you're about to ask him whether someone in his office sold out his witness. Salazar closed her notebook. Kelso was blunt force, she said. This is surgical. I need to know whose hands held the scalpel. And right now, the timeline says the information left the building before Okafor thinks it did. Marcos nodded once. His IA interview was Thursday. He hadn't mentioned it. He turned back to his desk and picked up the Gower stabbing file. The cold case that wouldn't stay cold and wouldn't get warm. He opened it and started reading. Salazar looked at the dates on his legal pad. January 8th, January 15th, January 22nd, January 29th. The phone was bought a week before the first call. The first call came a week before UC Irvine was briefed. The operation was already running when the information was supposedly still inside Okafor's office. Which meant one of two things. Either the information leaked from inside the Capitol Defense Unit before January 15th, or someone learned about Fraser's cooperation through a channel that had nothing to do with Okafor's office at all. Her phone buzzed, a text from the prepaid number she'd given Fraser. Still here, curtains open. She typed back, "Good, I'll call this afternoon." She put the phone down and looked at the dates one more time. January 8th, a Walmart on Tropicana Avenue in Las Vegas. Someone walking in with cash. Buying a phone. Programming it with a 702 number. Walking out. 5 days before Okafor even told his own paralegal about Fraser's statement. 5 days before anyone in the legal system knew Robert Fraser had agreed to talk. She reached for the corporate filings and started again from the beginning. Chapter 21. Witness List. Monday. 11 days until the hearing. Salazar was at her desk, running the partial plate from the Gower, stabbing through the DMV database when Okafor called. Strand's office acknowledged receipt of the supplemental witness list this morning. They signed for it at 9:12. How long before she files something? She has 10 business days to object to a new witness, but Strand won't wait 10 days. She'll have a response by Wednesday, Thursday at the latest. And Navarro? That's why I'm calling. You should talk to Medina. Salazar leaned back in her chair. The supplemental witness disclosure had gone out Friday afternoon. Okafor's paralegal, David Shin, hand-delivered it to the clerk's office in Department 127 and served a copy on Strand's firm by messenger. 48 hours ago. The list contained one name, Lucia Medina, court interpreter, certificate number 24871. You think Strand already has someone on her? I think Strand had Navarro photographing Kowalski's workplace within 72 hours of learning her name. Marcos nodded. Medina's address is on the disclosure. Her employer, her certificate number. Everything Navarro needs to start a background workup is in that filing. I'll go see her. Don't go to the clinic. Call first. I know. She hung up and dialed Medina's number. It rang 4 times and went to voicemail. Salazar left a short message. Call me when you can. Nothing urgent. 2 hours later, while she was typing the supplemental on the Gower stabbing, her phone buzzed. Unknown number, 323 area code. Detective Salazar. It's Lucia. Medina's voice was quiet, controlled. The precision of someone who translated other people's words for a living and chose her own carefully. There's a man watching me. Salazar put her pen down. Where are you? I'm at the clinic, in the break room. He's been outside since this morning. Dark blue truck across the street on Whittier. Since 7:30? I saw him when I came in. Then I went out to move my car at lunch and he was still there. Different spot, same truck. Dark blue, suburban? I think so, a big SUV. Dark blue or black, he has a camera. I saw him lift it when I walked across the parking lot. Did he approach you? No. Did he speak to you? No, he just sat there, with the camera. Salazar opened her notebook. What does he look like? I couldn't see him clearly from across the street. White or light-skinned, dark hair, sunglasses. He was wearing a sport coat. Which direction is the truck facing? East on Whittier. He's parked on the south side between the tire shop and the laundromat, maybe 50 yards from the clinic entrance. Is he still there now? I don't know. I've been in the break room for 20 minutes. I don't want to go look. Salazar wrote the location down. Whittier Boulevard, south side, between tire shop and laundromat. 50 yards east of the East Los Angeles Community Health Center. Lucia, listen to me. The man in the truck is almost certainly Paul Navarro. He's a licensed private investigator who works for Victoria Strand's firm. The line was quiet. He's allowed to observe you in public spaces, Salazar said. He's allowed to photograph you entering and leaving your workplace. He's allowed to run your background, pull public records, check your credit, and interview people who know you. All of that is legal. 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 Defense attorneys hire investigators to build profiles on prosecution witnesses. It's standard practice in any serious case. Navarro was doing the same thing to Doreen Wyatt in Ventura 2 weeks ago. He was watching the old woman too? He went to her care facility, asked questions at the front desk, used her alias to identify her room. He never threatened anyone. He never broke any law. Medina didn't say anything for a moment. Salazar could hear voices in the background. A PA system, the sounds of a busy clinic. My daughter walks home from school past this clinic. Salazar stopped writing. Sophia's school is on Breed Street, 3 blocks east. She walks to the clinic every afternoon at 3:15 and waits in the lobby until my shift ends at 5. She's done it since September. How old is Sophia? 12. You know that. I know. I'm asking because I need to understand the route. She walks west on Cesar Chavez to Soto, then south on Soto to Whittier, then 1 block west to the clinic. 7 minutes. She carries a purple backpack, and she has headphones on, and she's 12 years old, and there's a man with a camera sitting 50 yards from the door she walks through every day at 3:15. Navarro is not going to approach your daughter. You don't know that. I know how defense investigators work. He's building a file on you. Background, employment, daily patterns. My daughter. He's not going to approach a 12-year-old girl. That's not his job, and it would compromise his license. Detective Salazar. Medina's voice was very even. I came forward because you told me it mattered. I agreed to testify because I've been carrying this for 10 years. She paused. But I have a daughter. I told you what happened to Kowalski because you deserved to know. And now I know. A man went to her office and sat in the waiting room and explained exactly what would happen to her life if she testified. And she quit. And now there's a man sitting outside my clinic with a camera. Kowalski's situation was different. How? Navarro went to Kowalski's workplace and had a direct conversation with her about the consequences of testifying. What he's doing with you right now is passive surveillance, observation, photographs, background research. He hasn't approached you. He hasn't spoken to you. Yet, Salazar didn't argue with that. She looked at the clock on the bullpen wall. 1:47. An hour and 28 minutes before Sophia walked out of school. Here's what I'm going to do, Salazar said. I'm going to call Lisa Garza. She's a sergeant with the Ventura County Sheriff's Department. She's been helping me coordinate security for another witness in this case. The old woman, Wyatt. Yes. Garza has contacts with LAPD's Hollenbeck Division, which covers Boyle Heights. I'm going to ask her to coordinate with Hollenbeck for increased patrol presence near the clinic and near your apartment on Cesar Chavez. What does that mean? Increased patrol presence. It means a black and white driving past the clinic 2 or 3 times during the afternoon. It means a patrol car on Cesar Chavez between Soto and Mott during school pickup hours. It means officers who know your name and your address and your daughter's school schedule. Is that protection? No, it's presence. I can't assign you a protective detail. You're not in witness protection. There's no court order. What I can do is make sure that there are uniforms visible in your neighborhood on a regular basis. Navarro knows what a patrol car looks like. He'll adjust his behavior accordingly. Adjust his behavior. He'll keep his distance. He won't sit 50 yards from the clinic entrance with a telephoto lens if there's a Hollenbeck unit rolling past every 45 minutes. Medina was quiet. Salazar could hear her breathing. Steady, measured. I told you what this would involve, Salazar said. At the coffee shop. I told you there would be a defense investigation, background scrutiny. I told you it would be uncomfortable. You told me. I remember everything you said. I have a very good memory, detective. That's the problem. Are you telling me you want to withdraw? The question hung on the line. Salazar waited. She didn't fill the silence. She didn't reassure. She waited because Medina deserved the space to answer honestly. No, Medina said. I'm not withdrawing. I'm telling you that a man is sitting outside the building where I work with a camera, and my daughter walks past that building every afternoon, and I need you to do something about it. I'm doing something about it right now. Today, before 3:15. Before 3:15. I'll call Garza as soon as we hang up. She'll have Hollenbeck rolling by 3. And tomorrow? Tomorrow too, and the day after, until the hearing. Medina let out a breath. The woman who filed the complaint, Wyatt, did she have to deal with this? She had a man show up at her care facility asking about her by name. She had a court-ordered cognitive evaluation where a doctor asked her to draw a clock and remember a list of words to prove she was competent enough to testify about something she's remembered perfectly for 10 years. And she's still testifying. She told me she didn't wait 10 years to be chased off by a lawyer. She sounds like my grandmother. Salazar almost said something about Wyatt's strength. She didn't. Medina wasn't looking for inspiration. She was looking for evidence that the system she was about to re-enter wouldn't swallow her the way it swallowed her complaint 10 years ago. Lucia, Navarro being outside your clinic means the filing worked. Strand knows your name now. She knows what you heard, and the first thing she did was send someone to watch you. That tells you how seriously she's taking your testimony. That doesn't make me feel better. It's not supposed to make you feel better. It's supposed to tell you that what you heard in that hallway matters enough for a defense attorney to spend money surveilling you 11 days before a hearing. The PA system in the background announced something Salazar couldn't make out. Medina said something to someone in the room, her voice muffled. Then she was back. I have a patient in 5 minutes. Go. I'll call Garza now. You'll see a Hollenbeck unit near the clinic before Sophia gets out of school. And the man in the truck? He's allowed to be there. He's allowed to watch. He's not allowed to approach Sophia, he's not allowed to enter the clinic, and he's not allowed to interfere with your daily life. If he does any of those things, call me immediately. Not 911. Me. And if he just sits there? Then he just sits there, and the patrol car sits there too, and everyone watches everyone. And in 11 days you walk into a courtroom and you say what you heard. I've been saying what I heard for 10 years. Nobody listened until now. I'm listening. Medina hung up. Salazar looked at the phone for a moment, then opened her contacts and found Lisa Garza. Garza picked up on the third ring. Background noise. Wind. She was outside somewhere. Garza. It's Salazar. I need a favor. Another one? Lucia Medina. She's the new witness on the supplemental list. Medical interpreter at the East Los Angeles Community Health Center on Whittier Boulevard in Boyle Heights. Strand's PI is already on her. Dark blue Suburban parked on Whittier, photographing her entering and leaving work. How long has he been there? Since this morning, maybe earlier. She noticed him at 7:30. That's fast. Filing went out Friday. Friday afternoon. 48 hours. Strand doesn't waste time. No, she doesn't. Medina has a 12-year-old daughter who walks from school to the clinic every afternoon. Breed Street Elementary to Whittier Boulevard. 7-minute walk. 3:15 arrival. Garza was quiet for a beat. What do you need? Hollenbeck Division. Increased patrol near the clinic and near Medina's apartment on East Cesar Chavez between Soto and Mott. Visible presence. Uniforms. Not a protection detail. Just cars in the neighborhood on a regular rotation during business hours and school pickup. You want me to call Hollenbeck? You have contacts there from the Valley Gang Task Force. Sergeant Reyna, right? Captain, now. Anna Reyna. She transferred to Hollenbeck 2 years ago. Can you call her? I can call her, but Elena, this isn't Ventura County. Hollenbeck covers 60,000 people in 4 square miles. They can't dedicate a unit to one intersection. I'm not asking for a dedicated unit. I'm asking for a couple extra drive-bys during the afternoon shift. Clinic on Whittier, school on Breed, apartment on Cesar Chavez. 3 locations, 3 blocks apart. 1 patrol car making the triangle twice between 2 and 5. Garza was quiet for a moment. I can pitch that. Reyna's good. She'll understand the context if I explain it's a habeas witness under defense surveillance. Don't put it in writing. I know how to make a phone call, Salazar. I know you do. Anything else? Navarro, Paul Navarro, former FBI, now private. Westlake Professional Services on Wilshire. He's the same one who was at Seaside Palms asking about Wyatt. The one who used her alias. Same man. He's running the defense investigation for Strand on every witness. Kowalski, Wyatt, now Medina. He's licensed, he's legal, and he's good at what he does. So, what's the play? The play is presence. He sees Hollenbeck units near the clinic. He moves back. He doesn't leave. He doesn't stop the surveillance. But he puts distance between himself and a 12-year-old girl's walking route. And if he doesn't, then I go have a conversation with him myself. Okafor told you not to do that. Okafor told me not to conduct counter-surveillance that Strand could use against us. A conversation is different. Is it? It is, if I do it right. Garza made a sound that might have been a laugh. I'll call Reyna this afternoon. You'll have your drive-bys by tomorrow morning. I need them today, before 3:15. That's 2 hours from now. I know what time it is. Garza paused. Let me see what I can do. No promises on today. Tomorrow is solid. Today matters, Lisa. The girl walks past the truck at 3:15. I heard you. I'll call Reyna now. Salazar hung up and looked at the clock. 1:59. An hour and 16 minutes. She pulled up the Hollenbeck Division duty roster on her terminal and found the watch commander's desk number. If Garza couldn't get Reyna in time, she'd call Hollenbeck directly, badge to badge, one cop asking another cop to drive past a clinic on Whittier Boulevard at 3 o'clock. Marcos came in from the hallway carrying a manila folder. Gower plate came back, he said. Registered to a body shop on Vermont. Reported stolen 2 weeks before the stabbing. Which body shop? Rodriguez Auto Body. Vermont south of Santa Monica. Owner says it was a customer's car, left for paint work. Noticed the plates missing when the customer picked up. Did the owner file a report? Filed it the day after the customer complained. 6 days before Hector Solis got stabbed on Gower. Get me the customer's name. Marcos set the folder on her desk. It's in there, along with the owner's statement and the theft report. You want me to run the customer? Run the customer and pull the Gower scene photos again. I want to see if there's a vehicle in the background of the alley shots. What are you working on? Medina. Navarro's on her already. Parked outside her clinic on Whittier since this morning. Marcos sat down. 48 hours. 48 hours. Garza's calling Hollenbeck for patrol presence near the clinic and the school. The daughter. The daughter walks past the clinic every afternoon at 3:15. Marcos looked at her. His IA interview had been that morning. She could see it in the set of his jaw. He opened the Gower file and started reading. Salazar's phone buzzed. Text from Garza. Reyna's on it. Unit 6A23 will swing Whittier Clinic at 14:45 and loop Breed Saint on the way back. Daily, starting tomorrow. Today is a one-time courtesy. Salazar checked the time. 2:11. She typed back, "Thank you." She put the phone down and looked at the supplemental witness list on her screen. One name, Lucia Medina. Certificate number 24871. Employer, East Los Angeles Community Health Center. Address, East Cesar Chavez Avenue, Boyle Heights. Every piece of information that Navarro needed to find her, photograph her, and build a file on her life. Filed with the court. Served on opposing counsel. Public record. The cost of testifying. Not the courtroom, not the cross-examination, not the legal arguments about memory degradation and overheard speech. The cost was a man in a dark blue truck on Whittier Boulevard at 7:30 in the morning, lifting a camera when you walked across a parking lot. The cost was your daughter's walking route becoming a line on someone else's map. Her desk phone rang. She looked at the caller ID, Hollenbeck Division. She picked up. Detective Salazar, this is Sergeant Ochoa, Hollenbeck Watch Commander. I got a call from Captain Reyna about a patrol request on Whittier near the Community Health Center. That's right. Unit's already rolling. They'll hit Whittier at 1445 and loop north to Breed. I've got the witness name and the vehicle description for the PI. Is there anything else I should know? The PI is Paul Navarro, licensed, former FBI. He's not going to cause a problem. He's going to sit in his truck and take photographs. Your unit doesn't need to approach him. Just be visible. Understood. We'll keep the triangle in the afternoon rotation through the end of the month. Reyna said it's connected to a hearing at the Criminal Courts Building. Evidentiary hearing, April 14th. We'll have your drive-bys. Thank you, Sergeant. She hung up. At 2:23, 52 minutes before Sofia Medina walked out of school with a purple backpack and headphones on, 3 blocks east of a man with a camera who was being paid to document her mother's life. Salazar picked up the Gower file and opened it to the scene photographs. She had cases to work. She had a partial plate and a stolen tag and a body shop owner and a customer who might have been in an alley on Gower Street the night Hector Solis bled out on the sidewalk. She had 11 days until the hearing. She had a witness list with 1 new name on it. She had Navarro on Whittier and Garza on the phone, and a Hollenbeck unit rolling south on Soto toward a clinic where a woman who remembered everything was seeing her first patient of the afternoon and trying not to think about the truck outside. Her phone buzzed, text from Medina. I told my supervisor I might need to adjust my schedule. She asked why. I said it was a legal matter. She didn't ask anything else. 11 days until the hearing. She typed back, Hollenbeck patrol starting today. Unit will be near the clinic by 2:45. 3 dots appeared, then disappeared, then appeared again. Thank you. Sophia just texted. She's staying after school for math tutoring until 4. She won't walk past the clinic today. Salazar stared at the message. A 12-year-old girl staying late for math tutoring. An accident of scheduling that meant she wouldn't walk past a man with a camera on the one afternoon it mattered most. She put the phone down and picked up the Gower photographs. A dead man on a sidewalk. 2 witnesses who saw a red jacket and then decided they didn't. A stolen plate from a body shop on Vermont. The work didn't stop. It never stopped. She spread the photographs across her desk and started looking. Chapter 22. Strand's Play. Wednesday. 9 days until the hearing. Salazar was at her desk reviewing the Gower stabbing customer interview notes when Okafor called at 8:14. She filed. How bad? Come read it yourself. Room 412, bring coffee. She drove south on Cahuenga to the 101 and took it downtown. Badged through the employee entrance at Temple Street and took the elevator to 4. Okafor was standing at his window. He was holding a document, not reading it, holding it the way you hold something you've already read 3 times. How many pages? She said. 22, plus exhibits. He handed it to her. She sat in the chair across from his desk. In the matter of the petition of Marcus Cole. Respondent's motion to exclude testimony of Lucia Medina, or, in the alternative, to limit scope of testimony. Filed by Victoria Strand Esquerle, Strand and Associates, on behalf of Respondent Warren Lusk. 22 pages in 48 hours, Salazar said. She had it drafted before the filing. She just needed the name. You think she knew about Medina? I think she had a template ready for any new witness. Plug in the name, adjust the specifics, file it Wednesday morning. That's how she works. Salazar started reading. The motion was organized into 5 sections, each a separate ground for exclusion. Salazar read them in order. Section 1. Hearsay. Medina's proposed testimony consisted entirely of words she claimed to hear through a wall. She did not participate in the conversation. She was not addressed by either speaker. Under Evidence Code Section 1200, an out-of-court statement offered for the truth of the matter asserted is inadmissible hearsay. The foreman's alleged statements about the jury vote were textbook hearsay if offered to prove that the vote was moving, that holdouts existed, or that the foreman had communicated with a non-juror about deliberations. Salazar turned the page. Section 2. Inability to identify the second speaker. Medina could not identify the second voice. Male, older, authoritative. But she could not see the speaker, could not name the speaker, and had never previously identified the speaker. Without identification, the prosecution's theory that the conversation involved improper outside contact was speculation. A voice through a wall could belong to another juror, a bailiff, a court clerk, or any person with legitimate access to the hallway. The failure to identify the second speaker was fatal to the relevance of the testimony and invited speculation, which Evidence Code Section 352 prohibited. Section 3. No written report. Medina claimed she reported to Bailiff Deputy Ronaldo on November 2, 2016. Ronaldo's duty log contained a notation, but Medina herself never prepared a written statement, signed a declaration, or provided a recorded account. The absence of a contemporaneous written report from the witness undermined the reliability of her account and raised questions about whether her testimony had been shaped by intervening events, media coverage, and contact with prosecution representatives. Salazar stopped on that paragraph. Contact with prosecution representatives. That meant her. She kept reading. Section 4. 10-year delay. Medina first reported in November 2016. She did not come forward again for 10 years. She did not contact the court, the district attorney's office, any innocence organization, or any law enforcement agency. She left court interpreting in 2019 without ever raising the issue. The 10-year gap created insurmountable reliability concerns. Memory research, including Dr. Whitfield's published work, established that overheard speech was the least reliable form of auditory memory, with retention rates below 12% after 1 week and confidence levels uncorrelated with accuracy. Section 5. Never previously identified as a witness. Medina was not identified during the original trial, the initial habeas petition, or the amended petition. Her name did not appear in any court record related to the Cole case until Okafor's supplemental filing 9 business days before the hearing. The late identification prejudiced the defense's ability to prepare adequate cross-examination and investigate the witness's background, credibility, and potential bias. Salazar set the motion on the desk. Exhibit A. Whitfield's Declaration on Overheard Speech Memory Degradation. Exhibit B. The Ebbinghaus forgetting curve applied to auditory-only accounts. Exhibit C. The firm's receipt of the supplemental witness list, time-stamped Friday at 4:47 p.m. 4:47, Salazar said. She's arguing we timed the filing. Page 19, paragraph 4. Okafor didn't need to look. The timing of this disclosure, at the outer edge of the permitted window, suggests a deliberate strategy to minimize defense preparation time. Is she right? About the timing, yes. We held until the deadline to protect Medina from Navarro, but Strand is correct that the effect was to compress her preparation time. Can she win on that? On timing alone? No. The scheduling order sets the deadline. We met it, but combined with the other 4 arguments, it contributes to a picture of a witness who appeared from nowhere at the last minute with a 10-year-old account. Okafor sat down and pulled a yellow legal pad toward him, already covered in notes, small handwriting, numbers in the margins. "Tell me which arguments are strong," Salazar said. Hearsay is real. If Medina's testimony is offered to prove the foreman was communicating deliberation information to an outsider, those are out-of-court statements offered for their truth. Hearsay under 1200. But the foreman was part of the case. Exactly. Party admissions. Hadley was the foreman. His own statements about the jury vote come in under the exception. He said it the way he said everything, like the law was a set of tools and he was picking the right wrench. What about the second voice? Her strongest point. Medina can't name the second speaker. Male, older, deliberate, but no name. Does she need to? No. Medina's testimony isn't offered to prove who the second speaker was. It's offered to prove that Hadley was communicating deliberation information to someone outside the jury. Identity goes to weight, not admissibility. Yamada can admit it and let Strand argue on cross that the second voice could have been anyone. Hadley's proffer. Hadley's proffer confirms contact with a non-juror during deliberations. Medina corroborates that independently. She doesn't need to identify the second speaker because Hadley already confirmed the contact occurred. You can't use Hadley's proffer to bootstrap Medina. I'm not bootstrapping. I'm showing Yamada that excluding Medina because she can't identify the second speaker would ignore corroborating evidence already in the record. Salazar picked up the motion again and turned to Section 4. The 10-year delay. Strand's weakest argument dressed up as her strongest. Why is it weak? Because the delay isn't Medina's fault. She reported to Ronaldo within 45 minutes. Ronaldo passed it to the judge's clerk. The clerk did nothing. The system swallowed her complaint. She didn't come forward for 10 years because she already came forward and nobody listened. Strand doesn't mention the suppression. Of course she doesn't. Strand frames it as Medina's inaction. A decade to come forward chose not to. She omits the fact that Medina reported to Ronaldo, Ronaldo passed it up, and the court buried it. The delay isn't evidence of unreliability. It's evidence of institutional failure. Will Yamada see that? Yamada granted the amended habeas petition. She knows the institutional history. She's not going to blame a court interpreter for the court's failure to act on a properly reported complaint. Salazar looked at the motion. 22 pages, 5 arguments. Even the weak ones were written to sound strong. No adjectives, no advocacy. Just facts arranged in an order that made Medina look like a problem. What about the written report? Credibility argument, not admissibility. Thousands of witnesses testify about events they never documented. Ronaldo's duty log is the written record. It contains Medina's name, the date, the time, and a summary. Strand will say Ronaldo's log is his version, not hers. That's what cross-examination is for. You don't exclude a witness because the documentation isn't perfect. You let the finder of fact evaluate the discrepancy. Finder of fact is Yamada. And Yamada has been a judge for 17 years. She knows the difference between an admissibility objection and a credibility argument wearing admissibility clothing. Salazar put the motion down. She looked at Okafor's legal pad. The notes were organized by section number. Each section had 2 columns. The left column listed Strand's arguments. The right column listed his responses. Every response had a case citation next to it. When do you file the opposition? Friday. I have 2 days. 2 days for 22 pages. I don't need 22 pages. I need 10. Her arguments are elaborate. Mine are simple. Party admissions under 1220. Identity goes to weight, not admissibility. Delay explained by suppression. Written report exists in Ronaldo's log. Late disclosure complied with the scheduling order. 5 arguments, 5 responses. 5 responses, 5 case citations, 1 clean conclusion. Admit Medina's testimony and let the hearing do what hearings are designed to do. Salazar stood up and walked to the window, West Temple 4 floors below. Which way does Yamada go? I don't predict judges. You've been in front of her for 10 years. Yamada follows the rules. If the hearsay exception applies, she admits it. If it doesn't, she excludes it. She's going to read the evidence code and apply it. The party admissions exception. If Hadley was acting as foreman when he made those statements, the hearsay objection fails. The rest becomes cross-examination, not exclusion. And if she doesn't buy 1220? Then Medina doesn't testify. We go in with Wyatt, Hadley, and whatever remote testimony we get from Frazier. Strand knows that. Every argument in this motion is calibrated to give Yamada a reason to exclude. She doesn't need all 5, she needs 1. 1 out of 5. 1 legally sufficient basis. Salazar turned from the window. And you need all 5 to fail. All 5, or I need a 352 balancing. Probative value of Medina's testimony outweighs the prejudice. The evidence is directly relevant to jury tampering. The prejudice is manageable through cross-examination. Hadley is a cooperating witness with a deal. His credibility is damaged. Medina is independent. No deal, no relationship with the prosecution, no history beyond 2 days as a contract interpreter. She reported what she heard and nobody listened. Cleanest witness we have. Salazar's phone buzzed. Text from Marcos. Gower customer interview at 11. Rodriguez, owner, says customer was at the shop night of the stabbing. Alibi or access. Handle. She typed back, handle it, downtown, back by 1. A second text. IA rescheduled to next Friday. Same questions, different room. She put the phone down. I want to read Whitfield's declaration, she said. Okafor pointed at the motion without looking up. Exhibit A, 7 pages. She cites her own book 3 times and 2 Ninth Circuit opinions. The opinions don't say what she implies. They address general memory reliability, not overheard speech in a party admissions context. You checked the citations. At 6 this morning. Salazar opened to Exhibit A. Stanford letterhead. 7 pages. Ebbinghaus curve. Loftus misinformation effect. Source monitoring errors. 12% retention for overheard neutral speech after 1 week. The last paragraph. In my professional opinion, the proposed testimony of Lucia Medina, based on words allegedly overheard through a wall approximately 10 years ago, falls below the threshold of reliability that should be required for testimony in a proceeding of this significance. The combination of auditory-only perception, inability to observe the speakers, extended temporal delay, and absence of contemporaneous written documentation creates conditions under which memory reconstruction, source confusion, and confidence inflation are not merely possible but expected. Expected, Salazar said. Whitfield's word. She's saying Medina should be expected to have contaminated memories. Not that she does, that she should be expected to. Is that science? Statistics applied to an individual. Whitfield can tell you what happens to overheard speech in a lab with neutral stimuli. She can't tell you what happened to Medina's memory of hearing a jury foreman discuss deliberations while she was an officer of the court in a capital trial. The emotional encoding. The 2008 Psychological Bulletin Meta-Analysis. The 2017 Applied Cognitive Psychology Study. Overheard alarming speech retained at 3 times the rate of neutral. Whitfield's entire framework assumes neutral stimuli. Medina didn't overhear someone ordering lunch. Do you have your own expert? Dr. James Ochoa, UC Irvine. Published on Emotional Memory Persistence. He reviewed Whitfield's declaration yesterday. His preliminary opinion, her retention statistics are inapplicable to emotionally arousing overheard events. His declaration goes in Friday. Strand will move to exclude Ochoa. Let her. 11 federal cases, 7 state. Qualified in the Central District, Northern District, and the Ninth Circuit. She can challenge him. She won't disqualify him. Salazar closed the motion. She looked at Okafor. He was still writing. Right column getting longer than the left. The specifics are custom, she said. Section 2 references details from our proffer. She didn't just plug in a name. No. She analyzed the proffer, identified the weaknesses, and built targeted arguments around each one in 48 hours, with Whitfield's declaration attached, which means Whitfield was already retained, already briefed, already prepared to provide a declaration on any new witness with a temporal delay issue. She's been building toward this. Crawford for Frazier. Cognitive evaluation for Wyatt. 11 and 50 for the jurors. Now a comprehensive exclusion motion for any new witness. Every motion is a brick. The wall is designed to leave Yamada with nothing but Hadley, and Hadley is a cooperator whose credibility Strand will destroy on cross. Not to win the hearing. To make sure the hearing doesn't have enough evidence. Salazar picked up her jacket. 9:47 on Okafor's wall clock. Friday, she said, the opposition. Filed and served by noon. I'll send you a copy before I file. Send me the draft tonight. You're not a lawyer, Salazar. I've read more motions in 2 months than I did in 16 years. Send me the draft. Something changed around his eyes. Not a smile. Close. Read it with fresh eyes. If anything sounds wrong, tell me. Not the law, the facts. I was there. That's why I want your read. She walked to the door, stopped. She's good, Okafor. I know she's good. 22 pages. 5 arguments. Expert declaration. All aimed at one witness who heard something through a wall and reported it to a bailiff who wrote it in a log that nobody read. Okafor set his pen down. Strand doesn't need Yamada to agree with all 5. She needs Yamada to feel uncertain. Uncertainty favors exclusion. A judge who isn't sure errs on the side of keeping evidence out because admitting questionable evidence creates appellate issues. The motion itself is the weapon. The motion is always the weapon. The ruling is secondary. Yamada spends 3 days reading briefs about whether Medina is reliable. She walks into the hearing already thinking about reliability. 12% retention rates. Memory degradation. Even if she admits the testimony, Strand has planted the framework for cross. The opposition needs to be better, she said. The opposition needs to be right. Better is Strand's game. 22 pages because volume creates the impression of substance. I write 10 because the evidence code is clear. And if Yamada splits it? Admits the testimony but limits scope, that's a win. Medina on the stand saying she heard the foreman discuss the vote with someone, even without identification. Even with Strand's cross. That's an independent witness with no deal, no history, no motive, who reported what she heard on the same day she heard it. To a bailiff. To a bailiff who wrote it down. And the system buried it. She took the elevator down and pushed through the Temple Street doors. Traffic on Temple. A bus at the corner of Spring. 9 days, 5 walls around 1 witness. Her phone buzzed. Text from Medina. A woman came to the clinic this morning. Said she was from a consulting firm retained by an attorney in a civil matter. Asked the receptionist if I was available for a brief conversation about a scheduling question. Maria told her I was with a patient. She left a card. Whitfield and Associates, Cognitive and Forensic Consulting. Salazar stopped on the courthouse steps. Whitfield, at the clinic. The same morning, Strand filed the motion with Whitfield's declaration attached. She typed, "Do not speak to her. Do not return the call. Keep the card. I'll pick it up this afternoon." 3 dots. Then, I wasn't going to speak to her. I'm not stupid, detective. I'm frightened. There's a difference. Salazar walked down the steps toward her car on Spring Street. In room 412 behind her, Okafor was writing. Left column, right column. 5 arguments, 5 responses. The foreman's own words, offered against the party whose agent he was. Her phone buzzed again. Okafor. Whitfield visited the clinic. Send me everything. I'm adding it to the opposition. Chapter 23. Cole. Thursday. 8 days until the hearing. Salazar left Beechwood Drive at 4:15 in the morning and took Cahuenga to the 101 west, then north on the 5 through Burbank and into the dark stretch past Santa Clarita. She stopped for gas and coffee at the Flying J in Lebec, south of the Grapevine. The coffee was too hot and too weak. She drank it anyway. The Grapevine was empty at 5 in the morning. She drove through the Tejon Pass in the dark and came out the other side into the Central Valley, the flatlands opening up on both sides of the freeway. Bakersfield to the east. Tule fog in patches across the fields. She passed the Bakersfield exits and kept driving. She had not seen Marcus Cole since San Quentin. That visit was 10 months ago, during the original investigation. Condemned unit. Wrists shackled to a waist chain. Sitting very still across a metal table in a room where the air was recycled and the light came through wire-reinforced glass. She passed Tulare at 6:20, Fresno at 7. The sun came up over the Sierra foothills and turned the irrigation canals bright. Her phone buzzed. Text from Okafor. Strand filed supplemental brief at midnight. New argument. Fraser's statement was given to you, not prosecutors. She's challenging chain of custody. Salazar typed back one-handed. Fraser gave his statement voluntarily. I transmitted it to your office same day. I know. She knows. She's making the record for appeal. Another front. Salazar put the phone on the passenger seat and watched the road. Okafor had arranged the visit. General population at California Medical Facility didn't require the same protocols as the condemned unit at San Quentin. No waist chain. No escort from the warden's office. She had filled out the visiting application 6 days ago and cleared the background check Wednesday. One visit, approved. Thursday, April 6th. Visiting hours, 8:30 to 2:30. She took the I-5 to the 505 interchange and then east on I-80 toward Vacaville. The facility was on California Drive, a long, low compound behind double fencing with razor wire along the top. She parked in the visitor lot at 8:12. The processing center was a single-story building between the lot and the main facility. She showed her LAPD identification and the approved visiting form to the corrections officer at the window. Relationship to inmate? I'm a detective. I worked his case. He looked at the form again, typed something, looked at her ID again. You're not his attorney. No. Legal visit or personal? Personal. He stamped the form and pointed her to a metal detector on the far side of the room. She put her phone, keys, and badge in a locker, walked through. A second officer checked her hands with a UV light and waved her into a hallway that led to the visiting room. The visiting room at CMF Vacaville was nothing like the one at San Quentin. Round tables with attached stools, vending machines along one wall, children's area with a plastic playhouse and a torn poster of a giraffe. 2 families already seated. A woman holding a toddler on her lap while a man in blue sat across from her, not touching. The fluorescent lights were the same everywhere. She took a table near the back wall and waited. Cole came through a door on the far side at 8:41. He was wearing blue denim pants and a light blue chambray shirt, state-issued but not condemned unit issue. No shackles, no waist chain. He walked across the room with the careful pace of a man who had learned that sudden movements drew attention. He sat down across from her. He looked different, thinner in the face. The stillness was the same, but the quality of it had changed. At San Quentin, he had been still the way a man is still when he's stopped expecting anything. Now he was still the way a man is listening for something he isn't sure he wants to hear. Detective Salazar. Mr. Cole. Marcus. Marcus. He put his hands on the table, flat, fingers spread. She noticed his nails were clean and trimmed. At San Quentin, they had been bitten to the quick. When's the last time you had a visitor? She said. Okafor's paralegal was here 2 weeks ago. David Shin. Dropped off documents for me to sign. Before that. My sister came in January. She drives up from Stockton. Takes her about 45 minutes. You have a sister in Stockton? Denise. She moved there after I got transferred. Said she wanted to be close enough to visit without it eating a whole day. She was in Oakland before. Hayward worked at Kaiser. Now she's at a clinic in Stockton. She took the pay cut. He said it without inflection. Someone else's facts. How's the transfer been? She said. Different. Different how? He looked around the visiting room. The woman with the toddler, the vending machines, the torn giraffe poster. San Quentin, you're in a cell 22 hours a day. You eat in your cell. You talk to people through steel doors. He put his hands flat on the table. Everything is about the schedule. When you eat, when you walk, when the lights go off. He paused. She waited. Here I have a job. Library. I shelve books, process returns, sometimes help guys with their legal filings. I eat in the cafeteria. I can go to the yard when it's open. I talk to people face to face. That sounds better. It is better. That's the problem. She didn't say anything. Better is harder, he said. When everything is the worst it can be, you just survive it. You don't think about what comes next because there's nothing next. You wake up and you get through the day and you do it again. It's simple. He moved his hands on the table, turned them over, and then flat again. Here I have time to think. I read. I talked to guys who are getting out, guys with release dates. What do they talk about? Where they're going to live, what kind of work, who they're going to call first, and I sit there and I listen and I don't have any of that. You might. I might. That's what's killing me. A corrections officer walked past their table. Cole watched him go. Then he turned back to Salazar. You know about the hearing, she said. April 14th, 8 days. Okafor sends updates through Shin. What has he told you? Frazier disappeared. Then you found him, somewhere in the desert. Ridgecrest. He's going to testify? Remote, video link. He won't come back to L.A. Cole nodded slowly. I don't blame him. There's a new witness, an interpreter from the trial. She heard the foreman talking about the vote during deliberations. Okafor told me. He said she doesn't have to testify, that she's choosing to. That's right. What about the old lady? Wyatt. She's testifying. They put her through a cognitive evaluation. She passed. And the defense attorney, Strand. She's filed motions to exclude almost every witness. He looked at his hands. You drove 6 hours to tell me things I already know, he said. I drove 6 hours because I haven't seen you since San Quentin. Why now? Because in 8 days a judge is going to hear testimony about what happened to you, and I wanted to see you before that happens. See me, or check on me. Both. He almost smiled. It didn't reach his mouth, just a movement around his eyes. Okafor's people check on me. Shin comes up once a month. My sister comes every 2 weeks. The Innocence Coalition sends a social worker every quarter. That's not what I meant. I know what you meant. The toddler at the other table started crying. The woman picked him up and bounced him on her hip. The man in blue watched them with an expression that Salazar had seen on Cole's face at San Quentin. Present, but removed. watching his own life from somewhere outside of it. "Is it going to work this time?" Cole said. She looked at him. He was looking at her directly. No performance, no hope arranged for her benefit. Just the question. "I don't know," she said. "What do you know?" "We have more than we had last time. The interpreter's clean. No connection to the case, no deal, no motive." She reported what she heard on the day she heard it. The system buried her report. She's coming forward now because someone finally asked. And Fraser. Fraser is alive and willing to testify, not in person, but on the record. Strand is going to go after all of them. Yes. Every one of them. That's what she does. Cole leaned back on the stool. The stool was bolted to the floor. He leaned back as far as the fixed seat allowed and then stopped. "The guys in here who are getting out," he said. "The ones with release dates. You know what they talk about." "What?" "Apartments, jobs, driver's licenses, whether their family is going to pick them up or they're taking the bus." They almost smile again. One guy spent 3 weeks deciding what he was going to eat first. Settled on a burrito from a place on Telegraph Avenue in Oakland that closed 4 years ago. "What do you talk about?" "Nothing. I don't talk about it." "Why not?" "Because they have release dates. They know they're leaving." He traced a line on the table with his finger. "I have a hearing. I have a judge. Okafor tells me the law is on our side. My sister tells me to stay positive. The social worker tells me to prepare for either outcome." He put his hands flat on the table again. "I've been preparing for one outcome for 10 years. I don't know how to prepare for the other one." "You don't have to prepare for it right now." "That's what everyone says. Focus on the hearing, one step at a time. But I'm sitting in a library shelving Louis L'Amour westerns and thinking about what happens if I walk out of here, and I can't picture it." "Can't picture what?" "Any of it. Where I go, what I do, who I am." He said it flatly, not for effect. "I was 32 when they arrested me. I was a framer, residential construction. I could frame a 2-story house in 9 days with a 3-man crew. I was good at it. I knew what I was good at." "You're still good at it." "I'm 42. I haven't held a framing hammer in 10 years. The guys I worked with moved on. The company I worked for doesn't exist anymore. My apartment in Atwater Village, somebody else has been living there for a decade. My truck was sold at auction in 2017. My tools are in my sister's garage in Stockton. Tools last. I last too. That's not the problem." She waited. "The problem is, I've been Marcus Cole, death row, for 10 years. That's who I am. That's what I know how to be. I know the schedule. I know the guards. I know which guys to talk to and which guys to leave alone. I know how to survive this. I built the whole thing from the ground up." He stopped, looked at the table. "Even if it works," he said. "Even if Yamada rules our way and the DA drops it and I walk out that gate. What am I? I'm not Marcus Cole the framer anymore. I'm not Marcus Cole death row. I'm Marcus Cole, the guy who spent 10 years in prison for something he didn't do. That's it. That's the whole identity." "That's not the whole identity." "It is from where I'm sitting." She looked at him. He was 42 years old. His hands were flat on a table in a visiting room with fluorescent lights and a torn giraffe poster, and a toddler crying at the next table. He had been in prison since he was 32. He had spent 10 of those years waiting to be executed for a crime he did not commit. "I talked to a woman last week," she said. "The interpreter, Medina, she carried what she heard for 10 years, reported it, nobody listened, and she carried it. She left her career over it. And now she's going to testify." "She is." "Why?" "Because she said if she doesn't, and you die in here, she spends the rest of her life knowing she could have said something. Again." Cole took that in. He closed his eyes and opened them. "Again," he said. "She reported it in 2016. The day she heard it, told the bailiff. He wrote it down. Nobody did anything. And she's coming back. She's coming back." He looked toward the far wall, the door he had come through. A corrections officer was standing beside it, arms crossed, watching the room. "You know what I think about at night?" he said. "What?" "The jury. Those 12 people sitting in that room deciding whether I live or die, and Hadley working them, talking to somebody outside the room about which ones were close and which ones weren't, and the foreman telling him the vote was moving, like I was a number on a spreadsheet. 2 holdouts. Wyatt was one. Wyatt was one. She held out for me, a woman I never met, never spoke to. She sat in that room and said no. She's still saying no. 10 years. She's been saying no for 10 years. He shook his head slowly. "I wrote her a letter. After the transfer. Okafor gave me her address at the facility. I wrote 3 drafts and threw them all away." "Why?" "What do you say? Thank you for believing me. Thank you for ruining your life over my case. She filed complaints for a decade and nobody listened. Same as Medina. Same as Frazier, who gave you his testimony and then had to disappear because of it. Frazier didn't have to disappear. Somebody made him disappear. Same thing." She didn't argue that. "Everyone who tried to help me got hurt," he said. "Whitmore is dead. Reyes is dead. Frazier got relocated to the desert. Wyatt's been fighting the court system since 2016. Kowalski pulled out because she's afraid for her kids. And you drove up here on your day off because you feel responsible." "It's not my day off." "It's Thursday. You left LA before 5. You're burning a whole shift driving 6 hours each way to sit in a visiting room." "I told my lieutenant I had a witness interview in Sacramento." Something crossed his face. Not a smile. Recognition. "Okafor does that too. Calls things what they need to be called so the paperwork works." "I'm not Okafor." "No. You're the one who found Frazier. You're the one who found Medina. Okafor tells me that." "I'm a detective. That's what I do." "You're a detective working a case that isn't yours anymore. You're a witness in the hearing, not an investigator. Okafor told me that too." She didn't answer. "You know what scares me?" he said. "Tell me." "It's not losing the hearing. I've lost before. I know what that feels like. I go back to the library and shelve books and wait for the next thing." He put his index finger on the table and traced a line on the surface. What scares me is winning. Walking out that gate and standing in a parking lot with a box of my things and nowhere to go and nobody waiting. Your sister would be there. Denise would be there. She'd drive me to Stockton. She'd set me up in her spare bedroom. And then what? I'm a 42-year-old man sleeping in his sister's spare bedroom in Stockton with a 10-year gap on his resume and the worst thing that can happen to a person stamped on his name. There are programs, re-entry services. I know about the programs. Shin gave me a packet, 18 pages, housing assistance, job training, mental health services, compensation claims. State pays $140 per day of wrongful imprisonment. $511,000 for 10 years. That's something. That's a number. It doesn't tell me who I am. I don't have an answer for that, she said. I know you don't. Nobody does. Okafor says take it one day at a time. Denise says pray about it. The social worker says it's normal to feel disoriented about the prospect of release after extended incarceration. She used those words, extended incarceration, like that's what happened to me. What would you call it? Burial, he said. They buried me alive, and now somebody might dig me up, and I don't know if what comes out of the ground is still a person. She held his eyes. He held hers. Is there anything you need? She said. For the next 8 days. I need it to be over. One way or the other. I need the waiting to stop. I can't make it faster. I know. Is there anything I can bring you? Books? Anything? Shin brought me a bag of trail mix last time. The commissary here doesn't carry the kind with the dark chocolate pieces. I'll bring trail mix. You're not driving back up here before the hearing. I might. He looked at her, that movement around his eyes again. Not a smile, but something close to where a smile used to live. You're a strange cop, Salazar. I've been told. Okafor said you grew up watching your father lose cases. Public defender in Bakersfield. Okafor talks too much. He says you fight like it. Like you know what losing looks like so you don't waste time pretending it's not possible. Your attorney has a lot of opinions about me. He has a lot of opinions about everything. Most of them are right. A buzzer sounded. Visiting hours weren't over, but a guard was moving between tables, checking wristbands. Midday count. The families shifted. The toddler had fallen asleep on his mother's shoulder. I need to ask you something, Salazar said. Ask. If this works, if Yamada grants a new trial, and the DA decides not to retry, would you want to be at the hearing? Okafor asked me the same thing. What did you tell him? I told him I didn't know. They don't transport inmates 400 miles for evidentiary hearings. Video link, maybe. But sitting in that courtroom, watching people argue about whether I deserve to be alive. He looked at his hands. I sat in a courtroom 10 years ago while 12 people decided I was guilty. I watched the foreman read the verdict. I watched the judge read the sentence. My mother was in the gallery. She died in 2019. Did Okafor tell you that? He told me. Heart attack. They let me talk to Denise for 5 minutes. She held the phone up to my mother in the ICU. She was already unconscious. I'll watch the hearing on video if they let me, he said, "but I don't want to be in that courtroom. Not because I'm scared. Because the last time I was in a courtroom, they took my life. I don't want to be in the room where they decide whether to give it back." "I understand." "Do you?" "No," she said. "I don't. I can't." He nodded. That was the right answer. The guard came to their table. 10 minutes to count. Wrap it up." Cole stood. She stood. "Salazar." "Yeah." The interpreter, Medina. "You said she carried it for 10 years. "She did." "Tell her I said thank you for coming back." "You can tell her yourself. After." "After." He said the word slowly. "I don't know what after looks like yet." He turned and walked toward the door on the far side. The careful pace, measured steps. The corrections officer opened the door and Cole went through it. The door closed behind him. Salazar stood at the table and listened to the lock engage. She collected her things from the locker: phone, keys, badge. Walked through the processing center and out into the parking lot. The razor wire along the fence line caught the afternoon sun. She got in her car and took California Drive to I-80 West, then south on the 505 to the 5. 6 hours back. She would hit LA traffic through the Grapevine. Her phone buzzed on the passenger seat at a red light on the on-ramp. Okafor. Yamada ruled on Medina motion. Hearing tomorrow, 9 a.m., both sides. Oral argument. She merged onto the freeway. 6 hours south. The Central Valley flat and endless in front of her. A text from Marcos. IA wants a second interview. Friday. Same building, different floor. Her phone buzzed again. Strand requested 15 minutes. Yamada gave her 30. She wants to present Whitfield live. Salazar pressed the accelerator and watched the speedometer climb. The hearing on the motion was tomorrow. She was 6 hours from L.A. Okafor was already writing. 8 days. Chapter 24. The hearing approaches. Friday. 7 days until the hearing. Salazar got back to Beechwood Drive at 11:40 the night before and set her alarm for 5:30. She slept 4 hours and 20 minutes. The alarm went off and she was already awake, staring at the ceiling, thinking about Hadley. She showered and drove to Hollywood Division. Marcos was at his desk with coffee and a stack of supplemental reports from the Western Avenue shooting. How was Sacramento? Long drive. He went back to his reports. She sat down and opened her laptop to the court docket. Okafor had filed the supplemental witness disclosure for Medina on Wednesday. Strand had filed a response Thursday morning. Yamada had set oral argument on the Medina admissibility motion for 9 o'clock this morning. Her phone rang at 7:15. Okafor. "Are you coming to the courthouse?" he said. "I was planning on it." Strand filed something at 6:42 this morning. I just got the notification. What is it? Motion in limine to exclude Hadley's proffer session in its entirety. She's arguing the proffer was obtained under duress. Salazar turned in her chair. Marcos looked up from his stack. "Duress how?" she said. The DA's office told Hadley he was facing conspiracy to commit murder charges. 3 counts: Whitmore, Reyes, and the attempt on Frazier. They told him a grand jury was convening and that cooperation was his only path to a reduced charge. That's standard. It is standard. Strand is arguing it crossed the line. She says the murder charges were speculative, that the evidence tying Hadley to the actual killings was circumstantial at best, that the DA's office used the threat of a life sentence to extract testimony they couldn't have gotten otherwise. The proffer was voluntary. Hadley had counsel present. He had Diane Okoro, panel attorney. She'd been on the case for 11 days. Strand is going to argue Okoro was outmatched, that Hadley was panicked, and that a reasonable person in his position would have said whatever the prosecutors wanted to hear to avoid a murder charge. Salazar looked at the clock on the wall above the break room door. 7:18. Can she win this? She can make the argument. That's all she needs to do. If Yamada excludes the proffer, the only direct evidence connecting Lusk to the jury tampering is Frazier's testimony about the threat, and Frazier's testifying remote, on video, from a location he was relocated to by someone we still haven't identified. Frazier heard Hadley deliver the threat. That doesn't change. Frazier heard Hadley tell him people who make things difficult have difficult lives. That's coercion. It connects Hadley to the tampering, but it doesn't connect Lusk to Hadley. The proffer does. The proffer is everything. Hadley says Lusk recruited him. Lusk offered the commercial lease. Lusk gave him the language for the threat. Without the proffer, the Lusk connection is circumstantial. She stood up. What time is oral argument on Medina? 9. Strand's Hadley motion will be calendared separately. Yamada's clerk told me to expect a hearing date early next week, probably Wednesday. That's 5 days before the evidentiary hearing. I know what it is. She could hear the strain in his voice. Okafor sounded like a man who had been awake since Strand's filing hit the docket at 6:42. I'll be at the courthouse at 8:30, she said. Elena. What? I need you in the gallery for the Medina argument. Strand is bringing Whitfield. If Whitfield testifies about memory degradation for overheard speech, I need to see your face while she talks. I need to know what a cop thinks about the science. I'm not an expert on memory science. You're an expert on whether testimony sounds like the truth. That's what I need. She hung up and turned to Marcos. Strand filed to exclude Hadley's proffer. The whole thing? Duress. Says the murder charge threat coerced him. Marcos set down his coffee. What's Okafor's read? If she wins, the Lusk connection goes circumstantial. Marcos looked at her for a 3 count. Go. I've got the desk. Your IA interview. What about it? Have you heard anything? Radio silence. 4 weeks. That's either good or it means they're building a file. Which do you think? I think I've got 3 open cases on my desk and a partner who needs to be at the courthouse. Go. She took her jacket off the back of her chair and drove downtown. The Hall of Justice was already busy at 8:20. She parked in the structure on Temple and took the elevator to the 3rd floor. Department 127. Okafor was in the hallway outside the courtroom door. Shirt sleeves rolled, tie loosened, reading glasses on his forehead. He had a red-welled folder in one hand and his phone in the other. A young woman Salazar didn't recognize stood beside him holding a laptop case and 2 accordion files. "Who's that?" Salazar said. "Priya Nair, 2nd year at the Innocence Coalition. She's been doing witness prep outlines since Tuesday." Since Tuesday. "I've had 4 people working 18-hour days for 10 days. Nair on witness outlines, Shin on demonstrative exhibits, Dr. Yamashita from UC Irvine on the memory expert rebuttal, and me on everything else." "When did you last sleep?" Define sleep. Horizontal, eyes closed, more than 3 hours. "I'll sleep on the 15th. The courtroom doors opened at 8:50. Salazar took a seat in the 2nd row of the gallery behind the bar. The clerk was arranging files at her desk below the bench. Strand came in at 8:54. Navy suit today. Same briefcase, reading glasses around her neck. A man in a charcoal suit walked beside her carrying a banker's box. Behind them, a woman in her 50s, dark blonde hair, tailored jacket, carrying a leather portfolio. Dr. Ann Whitfield. Salazar recognized her from the author photo on the book jacket she'd studied at the UCLA Law Library. Strand set her briefcase on the defense table and opened it with one motion. She took out a legal pad, a pen, and a single file folder. The man in the charcoal suit arranged documents from the banker's box. Whitfield sat in the first gallery row behind Strand, portfolio on her lap, hands folded. Okafor entered and went to the prosecution table. Nair sat behind him. "All rise." Yamada came through the chamber door. Mid-60s, silver-framed glasses, black robe. She arranged her files and looked at both tables. "We're here on the People's Supplemental Witness Disclosure and the defense motion to exclude," Yamada said. "Ms. Strand, you filed. You go first." Strand stood. "Your Honor, the people have disclosed a supplemental witness, Lucia Medina, a former court interpreter who claims she overheard statements in the hallway outside the jury room during the original Cole trial. The defense moves to exclude this testimony on 3 grounds." She didn't look at notes. First, reliability. Miss Medina claims to have overheard a conversation through a wall 10 years ago. Strand paused, let it land. Dr. Whitfield, who is present in the courtroom, has published extensively on auditory memory. Recall accuracy for overheard speech drops below 15% within 1 week. Miss Medina is being asked to reconstruct perception from a decade ago. Yamada was writing. Second, the people argue Evidence Code 1150 does not apply because Ms. Medina is not a juror. The defense concedes that point. She turned a page in her notes. But the conversation was between jurors, about the deliberative process. The policy behind 1150 applies regardless of who is listening. Admitting this testimony opens the deliberation room to any bystander who claims to have heard something through a wall. Third, prejudice. Ms. Medina was not disclosed until the 14-day deadline. The defense has had 13 days to prepare for a witness the people have apparently known about for weeks. The late disclosure prejudices the defense's ability to investigate this witness, retain responsive experts, and prepare cross-examination. She sat down. Okafor stood. "Your Honor, 3 responses." Okafor stood. On reliability, Ms. Medina reported what she heard to Bailiff Ronaldo within 45 minutes. The duty log entry is in evidence. He let the judge find the exhibit. This is not reconstructed memory from 10 years ago. This is contemporaneous reporting, documented, with a chain of custody through the court's own records. He paused, one beat. On 11:50, Ms. Strand concedes Ms. Medina is not a juror. That's the end of the analysis. Yamada looked up from her notes. Section 1150 bars inquiry into juror reasoning. It does not bar third-party testimony about statements made outside the jury room. The foreman's hallway conversation was not deliberation. It was a party admission overheard by court personnel. On timeliness, the people disclosed Ms. Medina on the 14th day, consistent with the scheduling order. Defense counsel's claim of inadequate preparation time is an argument for continuance, not exclusion. Ms. Strand has not moved for a continuance. Strand was writing on her legal pad. She didn't look up. Yamada turned to her. Ms. Strand, do you wish to present Dr. Whitfield's testimony on the memory issue? Yes, Your Honor, briefly. 15 minutes. Whitfield walked through the gate and took the witness stand. Strand asked her name, credentials, publication history. Whitfield answered in practiced sequences. Stanford Ph.D., 16 years of research in witness reliability, author of Credibility and Recall, retained as a consultant by the defense. Dr. Whitfield, in your research, what is the rate of accurate recall for overheard speech after 1 week? In controlled studies, approximately 12 to 15% of specific content is accurately recalled after 7 days. The rate declines further with time. And after 10 years? There is no meaningful experimental data for a 10-year interval because the assumption in the literature is that overheard speech memory is functionally degraded well before that point. What about confidence? Is a witness who is confident in her memory of overheard speech more likely to be accurate? No. In fact, the research shows the opposite for overheard speech. Confidence and accuracy are uncorrelated and, in some studies, negatively correlated. A witness can be highly confident and entirely wrong. Thank you, Doctor. Okafor stood for cross. Dr. Whitfield, your research on overheard speech. Were the subjects in those studies court interpreters? No. Were they trained in active listening as part of their professional certification? The studies used undergraduate participants. Were the overheard statements in your studies transgressive in nature? Did the subjects believe they were overhearing evidence of a crime? The studies used neutral content, conversations about weather, schedules, daily activities. Are you familiar with the 2008 Psychological Bulletin meta-analysis of 47 studies showing emotionally arousing events are retained at 2 to 3 times the rate of neutral events? I am familiar with that literature, yes. And the 2017 Applied Cognitive Psychology study showing that overheard transgressive speech is retained at 3 times the rate of neutral overheard speech, with a positive confidence accuracy correlation. I am aware of that study. The sample size was small. 64 participants, which is below the threshold for broad generalization. Ms. Medina overheard what she believed to be evidence of jury tampering. She reported it within 45 minutes. She was a certified court interpreter whose profession is active listening. Does your research address this specific combination of factors? Not directly. Thank you, Doctor. Yamada looked at both tables. I'll take this under submission and rule by the end of the day. The court notes that Ms. Medina's contemporaneous report to Bailiff Ronaldo is documented in the court's own records, which is a factor in the reliability analysis. Anything else on this motion? No, Your Honor, Strand said. No, Your Honor, Okafor said. Then I'll address the newly filed motion in Lemine regarding the Hadley proffer. Ms. Strand, you filed at 6:42 this morning. Yes, Your Honor. The defense moves to exclude the entirety of Mr. Hadley's proffer session on the grounds that it was obtained through coercive interrogation practices. Mr. Hadley was told he faced 3 counts of conspiracy to commit murder, carrying a potential life sentence. This threat was disproportionate to the evidence and was designed to overcome his will and extract testimony favorable to the prosecution. The people wish to respond, Yamada said. Okafor stood. Your Honor, the proffer was conducted with counsel present. Mr. Hadley was represented by Diane Okoro, a qualified panel attorney appointed after the Brannock-Hale conflict. The charges described to Mr. Hadley reflected the evidence available at the time. The people object to characterizing standard plea negotiations as coercion. I understand the positions, Yamada said. This is a significant motion that requires briefing and argument. I'm setting a hearing for Wednesday, April 9th. Both sides, written briefs due Tuesday by 5 p.m. Oral argument Wednesday at 9. Ms. Strand, is there anything else? No, Your Honor. Mr. Okafor? No, Your Honor. We're adjourned. Salazar waited in the gallery while the courtroom emptied. Strand packed her briefcase and walked out without looking at anyone. Whitfield followed. The man in the charcoal suit carried the banker's box. Okafor came through the gate and sat down in the gallery row next to Salazar. Wednesday, he said. 5 days before the hearing. If she wins, we lose the direct link between Lusk and the tampering. Everything else is inference. Hadley threatened Fraser, yes, but Hadley saying Lusk recruited him, Lusk gave him the threat language, Lusk offered the lease. That's all in the proffer. What's the counter-argument? Voluntary proffer with counsel present. Standard practice. He rubbed the bridge of his nose. Every cooperation deal involves the threat of charges. That's the incentive. If that's coercion, every cooperator in California got coerced. Is that enough? It should be. But Strand doesn't need to win the legal argument. She needs to make Yamada uncomfortable enough to hedge. A limiting instruction. A credibility finding. Anything that tells the court the proffer should be received with caution. Once you put that asterisk on Hadley's testimony, Strand can use it in closing to argue the entire Lusk connection is built on a frightened man saying what prosecutors wanted to hear. He took his glasses off his forehead and rubbed his eyes. I need to call Diane Okoro. Hadley's attorney. I need to confirm he's testifying and find out what she thinks about his cross-examination exposure. You want me there for the call? No. I want you to go back to your desk and work your cases and let me handle the legal strategy. I want you rested and focused for the 14th. You're a witness, Elena, not co-counsel. You've mentioned that. I'm going to keep mentioning it. She drove back to Hollywood Division. Marcos was gone. A note on her desk said he had a follow-up with the Western Avenue bar patron and would be back by 2. She worked the Gower stabbing file for an hour. The partial plate from the red jacket witness had come back to 6 possible vehicles, none registered to anyone in the victim's known associates. Dead end on top of dead end. At 1:15, her phone rang. Okafor. I spoke with Okoro. And? Hadley is testifying. Okoro says he understands the cooperation agreement and he'll honor it. But Okoro is worried about Cross. Hadley's credibility is already compromised. He's a cooperator who got a reduced charge in exchange for testimony. Strand is going to frame him as a man who was facing life in prison and said whatever the prosecutors needed to hear to get the conspiracy to obstruct charge instead. He's telling the truth. I believe that, you believe that. The question is what Yamada believes after Strand spends an hour on Cross, and Okoro says Hadley is not a strong witness under pressure. She says he's practiced and prepared, but that his instinct under attack is to hedge, to qualify, to say, I believe so, instead of yes, to say, to the best of my recollection, instead of stating a fact. That's a problem. Strand will use every hedge to argue his proffer was reconstructed, that he built a narrative that fit what the prosecutors wanted because the alternative was 3 murder charges. She'll ask him specific questions about dates and conversations, and he'll approximate, and every approximation becomes evidence that his memory isn't reliable. It's convenient. Salazar looked out the window of the bullpen, the parking lot. 2 patrol cars pulling in from afternoon shift change. You said there was corroboration. The Reyes letter. Victor Reyes wrote a letter to Patricia Whitmore 3 months before she was killed. The letter names Hadley and describes the same conduct Hadley admits to in the proffer. That's independent corroboration from a deceased witness who had no cooperation deal and no reason to lie. If I can get the letter admitted through Isabella Reyes's testimony about its provenance, it backstops everything Hadley says. If. Strand will fight the letter too. Hearsay. Authentication. But that's a different motion and she hasn't filed it yet. She's prioritizing the proffer because without Hadley's words, the letter is just a dead man's accusation. With Hadley's proffer confirming the same facts independently, the letter becomes devastating corroboration. So the whole case turns on Wednesday. The proffer admissibility is the last major motion. If Yamada lets it in, we walk into the hearing with a cooperator, an interpreter, a relocated witness, and documentary corroboration. If she excludes it, we have an interpreter who heard half a conversation, a witness who was relocated by someone we can't identify, and an 81-year-old woman who saw Hadley on a phone. Medina heard more than half. Medina heard the foreman. She didn't hear the second voice clearly. She can't identify who the foreman was talking to. A Strand will drive a truck through that gap. Medina heard enough. Elena, I'm telling you what the battlefield looks like. I'm not telling you we lose. I'm telling you every pillar is under assault, and the hearing is 7 days away, and I need to write a brief by Tuesday that keeps Hadley's proffer in evidence. Write the brief. I'm writing the brief. I've been writing briefs for 10 days. Nair is doing witness prep. Shin is doing demonstrative exhibits. Yamashita is preparing the memory expert rebuttal. And I'm sitting in a courtroom watching Strand file motions at 6 in the morning because she doesn't sleep either. Tom. What? I saw Cole yesterday. He stopped. She could hear him breathing on the other end. How is he? He's scared of winning. I know. He asked me to tell Medina thank you for coming back. Okafor didn't say anything for a moment. I'll put that in the brief, he said, in the section about why this case matters. That's not what he meant. I know what he meant. I'll tell her myself when she comes in for prep on Monday. He hung up. Salazar sat at her desk. The Gower file was open in front of her. 6 possible plates, no matches. Hector Solis, 28, bled out on a sidewalk. His mother called the station twice a week asking for updates. Salazar had nothing to tell her. She picked up her phone and dialed the Scottsdale number for the property management company on North 68th Street. Delgado's voicemail. She hung up without leaving a message. Frazier was at a disclosed location now. Cortez had disappeared. The referral chain from the white Ram truck through Apex Fleet to Trident Mobility to Ridgepoint Security to a former Citadel EP employee was documented in Marcos's supplemental report but led nowhere actionable. The client who hired Cortez remained unknown. Attorney-client privilege sealed the referral. Someone had spent money to make Frazier disappear. Not to hurt him. To remove him. Professional and clean, and nobody had claimed responsibility or been identified as the source. Her phone buzzed. Text from Okafor. Yamada ruled on Medina. Testimony admitted. Party admissions exception. Contemporaneous report corroborates reliability. Strand's 11-50 argument rejected. She read it twice, set the phone down. 1 ruling in their favor. 1 hearing left. Wednesday. The Hadley proffer. 7 days until the hearing. 5 days until the motion that would determine whether those 7 days mattered. Her phone buzzed again. Marcos. Bar patron gave me a partial description on the Western Ave shooter. Male, 20s, dark hoodie, left on foot southbound. I'm running it against the canvas from November. Back by 3. She picked up the Gower file and went back to work. Chapter 25. Yamada. Wednesday, April 9th. 5 days until the hearing. Salazar parked in the Temple Street structure at 812 and took the elevator to the 3rd floor. Department 127. The hallway was empty except for a clerk pushing a mail cart and a man in a wrinkled suit reading something on his phone outside Department 129. She'd been here Friday for the Medina ruling. Same courtroom. Same fluorescent lights with the flicker in the second panel from the door. Today felt different. Friday had been about whether they could add a witness. Today was about whether they could keep one. Okafor was standing near the water fountain, reading from a legal pad. No tie today. Shirt sleeves rolled to the elbows, top button undone. Same shirt since Monday, same legal pad. "Did you sleep?" she said. "I submitted the brief at 4:47 yesterday afternoon. Then I revised it until midnight. Then I revised the revision until 3. So, no." Define no. Priya Nair came around the corner carrying 2 accordion files and a laptop bag. She handed Okafor a coffee from the cart downstairs. He took it without looking at it. "Strand's brief came in at 4:59 yesterday," Okafor said. 13 minutes before the deadline. 22 pages. "How is it?" "Brilliant." He said it without admiration, the way a doctor describes an aggressive tumor. She built the entire argument around the timeline. Hadley was arrested on a Monday. By Wednesday, the DA's office had laid out the 3 murder charges. By Friday, Hadley was in a conference room with Okoro and 2 prosecutors, proffering. 4 days from arrest to cooperation. She argues that timeline proves the charges were leverage, not prosecution. Were they? He looked at her over his reading glasses. The charges reflected the evidence. Whether the DA's office would have taken all three to a grand jury is a different question. They didn't have to. Hadley cooperated. So, Strand's right that the charges were pressure. Strand's right that the charges created pressure. She's wrong that pressure equals coercion. Every cooperation agreement in the state of California involves pressure. That's how cooperation works. You face charges. You choose to talk. The question is whether the pressure was so disproportionate to the evidence that it overcame Hadley's will. And the answer is no. Because Hadley had counsel, Hadley was advised, and Hadley made a choice. Is that what your brief says? In 26 pages, with 14 footnotes and 6 case citations. The courtroom doors opened at 8:50. Salazar went in and took the same seat she'd had Friday. Second row, behind the bar, aisle side. A woman she didn't recognize sat at the far end of the same row, taking notes in a spiral-bound reporter's notebook. Press. Strand entered at 8:53. Navy suit again. Same briefcase. The man in the charcoal suit followed with the banker's box. No Whitfield today. Strand didn't need a memory expert for this argument. This was pure law. She set her briefcase on the defense table and took out one legal pad and one file folder. Same setup as Friday. She uncapped a pen and wrote something at the top of the pad. She didn't look at the gallery, the prosecution table, or the clock. Okafor came in with Nair. He arranged 3 folders on the prosecution table and opened his legal pad to a page dense with handwriting. All rise. Yamada came through the chamber door, silver-framed glasses. She sat, arranged her files, and looked at both tables the way she always did. Level. Patient. The face of someone who'd heard 10,000 arguments and knew that most of them came down to 3 or 4 sentences. We're here on the defense motion in limine to exclude Mr. Hadley's proffer. Ms. Strand, you filed. Proceed. Strand stood. No notes in her hand. She stood with her hands at her sides, weight even, and spoke to the judge. Your Honor, Carl Hadley was arrested on March 3rd of this year. He was 47 years old, a commercial real estate broker with no criminal record, no history of violence, and no prior involvement with the criminal justice system. Within 48 hours of his arrest, the district attorney's office informed Mr. Hadley through his newly appointed counsel that he faced 3 counts of conspiracy to commit murder. She paused, not for effect, to let Yamada write. 3 counts. The murder of Patricia Whitmore, the murder of Victor Reyes, and the attempted murder of Robert Frazier, each carrying a potential sentence of 25 years to life. Mr. Hadley was told, in substance, that he would spend the rest of his natural life in prison. 4 days later, Mr. Hadley was in a conference room with his panel attorney, who had been on the case for 11 days, and 2 senior prosecutors. He proffered. He told the prosecutors what they wanted to hear. He said Mr. Lusk recruited him. He said Mr. Lusk provided the language for the threat to juror Frazier. He said Mr. Lusk offered the commercial lease at Lusk Tower as compensation. Strand took 1 step to her left, closer to the bench. Your Honor, I want to be clear about what the defense is arguing. We are not arguing that Mr. Hadley is lying. We are arguing that it is impossible to know whether Mr. Hadley is telling the truth, because the circumstances of his proffer make it impossible to distinguish truth from self-preservation. Yamada looked up from her notes. Mr. Hadley had every incentive to implicate Mr. Lusk. Implicating Mr. Lusk was the only path to a reduced charge. The prosecutors told him so. His attorney told him so. The architecture of the proffer session was designed to produce exactly one result: testimony that connected the conspiracy to Mr. Lusk. And it did. The people will argue the proffer is corroborated. They will point to phone records showing calls between Mr. Hadley and Mr. Lusk during recesses. But phone records prove calls. They do not prove content. The people will point to Ms. Kowalski's identification of Mr. Lusk at the courthouse. But Ms. Kowalski saw two men in a hallway. She did not hear their conversation. She has since withdrawn as a witness. The people will argue that Mr. Fraser's testimony about the threat corroborates the proffer. It does not. Mr. Fraser testified that Mr. Hadley delivered a threat. The proffer is where Mr. Hadley says the threat originated with Mr. Lusk. That is the link the people need, and it exists nowhere except in the words of a man who was facing life in prison when he said them. She stopped, hands still at her sides. The proffer should be excluded because it is unreliable. Its admission would allow the court to consider testimony that was produced under conditions that make its accuracy unknowable. The defense asks this court to apply the standard it would apply to any confession obtained under comparable pressure. Exclude it. She sat down. Salazar watched Yamada writing. The pen moved steadily. Yamada didn't look up for several seconds after Strand finished. Mr. Okafor. Okafor stood. He held his legal pad but didn't look at it. Your Honor, Ms. Strand has described a proffer session that sounds coercive. I want to describe the same proffer session as it actually occurred. He moved to the podium between the tables. Mr. Hadley was arrested on evidence, not speculation, evidence. Phone records placing calls to Mr. Lusk during trial recesses. Financial records showing the lease arrangement at Lusk Tower executed within weeks of the verdict. Mr. Fraser's sworn testimony identifying Mr. Hadley as the person who delivered the threat. Miss Kowalski's identification of Mr. Lusk at the courthouse with Mr. Hadley, and the pattern of 2 juror deaths following the trial, both connected to individuals who had contact with Mr. Hadley. The charges presented to Mr. Hadley reflected that evidence. Were they pressure? Yes. That is the nature of criminal prosecution. Every defendant who cooperates does so because the alternative is worse. That is not coercion, that is the legal system functioning as designed. Ms. Strand argues the proffer is uncorroborated. The opposite is true. He looked at his pad for the first time. The proffer is corroborated by 5 independent sources. First, Mr. Fraser's testimony about the direct threat, which confirms the conduct Mr. Hadley described. Second, Ms. Kowalski's identification of Mr. Lusk with Mr. Hadley at the courthouse during the trial, which confirms the relationship Mr. Hadley described. Third, phone records showing 17 calls between Mr. Hadley and Mr. Lusk during the 2-week trial period, with call clusters during recesses, which confirms the coordination Mr. Hadley described. Fourth, financial records showing the Lusk Tower lease, executed on terms far below market, which confirms the compensation Mr. Hadley described. And fifth, the Reyes letter. Strand's pen stopped moving. Victor Reyes, juror number 12, wrote a letter to Patricia Whitmore 3 months before her murder. That letter names Carl Hadley and describes the same jury manipulation that Mr. Hadley admits to in his proffer. Mr. Reyes had no cooperation agreement. Mr. Reyes had no charges pending. Mr. Reyes wrote that letter because he was troubled by what he had witnessed during the trial, and he sent it to the one person he believed would understand. That letter independently corroborates the core of Mr. Hadley's proffer, not the details, not the conversations, the fundamental fact that Mr. Hadley engaged in jury tampering during the Marcus Cole trial. He set the legal pad on the podium. Ms. Strand wants this court to view the proffer in isolation. A frightened man in a room saying whatever prosecutors wanted to hear. But the proffer does not exist in isolation. It exists at the center of a web of independent evidence. Phone records, financial records, eyewitness identification, direct testimony of threat, and a letter from a dead man who named the same person, described the same conduct, and paid for that knowledge with his life. He paused. The proffer is not standing alone. It is the keystone of a bridge built from 5 independent sources. Removing it does not make the bridge disappear. It makes the bridge harder to walk across, and this court should not make that choice based on the unremarkable fact that a criminal defendant cooperated when confronted with criminal charges. He sat down. Yamada wrote for a full minute. The courtroom was quiet. The reporter in Salazar's row had stopped writing and was watching the bench. The clerk sorted papers at her desk. The sound of shuffled pages was the loudest thing in the room. Ms. Strand, anything further? Strand stood. Briefly, Your Honor. Mr. Okafor's bridge metaphor is evocative. But bridges require engineering, not metaphor. The phone records prove calls, not content. Ms. Kowalski saw 2 men in a hallway. She did not hear a conversation. She has withdrawn as a witness and will not be subject to cross-examination. The financial records show a business arrangement, not a bribe. There are legitimate explanations for a below-market commercial lease in a building with a vacancy. The Reyes letter is a separate evidentiary matter not before the court this morning. She looked at Yamada. What remains is Mr. Fraser's testimony that Mr. Hadley delivered a threat. That connects Mr. Hadley to jury tampering. It does not connect Mr. Lusk. The proffer is the only evidence in which Mr. Hadley says Mr. Lusk was the architect, and the proffer was obtained from a man who had been told he would die in prison if he did not cooperate. She sat down. Okafor didn't stand. Yamada hadn't invited further argument. The courtroom was quiet again. Yamada turned a page in her notes. She took off her glasses, cleaned them with a cloth from her desk, and put them back on. She looked at both tables. I'm going to rule from the bench. Salazar felt the air change. Okafor shifted in his seat. Nair closed her laptop. The defense motion to exclude Mr. Hadley's proffer presents a genuine issue regarding the reliability of cooperator testimony obtained under significant prosecutorial pressure. Ms. Strand's argument is well taken that the circumstances of the proffer, specifically the speed with which charges were presented and cooperation obtained, raise legitimate concerns about the voluntariness of Mr. Hadley's statements. Salazar watched Okafor's back. His shoulders hadn't moved. The court is not persuaded that the proffer rises to the level of involuntary testimony. Mr. Hadley was represented by counsel. He was advised of his rights. She cleaned her glasses again. The charges were serious but supported by available evidence. The proffer was not the product of coercion, prolonged interrogation, or deprivation. It was the product of a defendant choosing cooperation over trial. Strand's pen has started moving again. Mr. Okafor's argument regarding corroboration is persuasive. The proffer does not stand alone. Yamada looked at Strand. Phone records, financial records, the Kowalski identification, Mr. Fraser's testimony of the direct threat, all provide independent support. The Reyes letter, if admitted, would add corroboration from a deceased witness. Yamada looked directly at Strand. The motion to exclude is denied. Strand didn't react. Her pen continued moving at the same speed. But Okafor's pen stopped. The court will instruct the hearing panel to consider Mr. Hadley's testimony in light of the circumstances under which it was obtained. Specifically, the court will instruct the panel that Mr. Hadley was a cooperating witness who received a reduced charge in exchange for his testimony, that the proffer was obtained within days of Mr. Hadley learning he faced 3 counts of conspiracy to commit murder, and that the panel should weigh Mr. Hadley's credibility accordingly. Yamada closed her file. Ms. Strand, the instruction I've described gives you full latitude to challenge Mr. Hadley's credibility on cross-examination. You may present the timeline, the charge reduction, and the incentive structure to the panel. Mr. Okafor, you may present the corroborating evidence to support the proffer's reliability. The panel will weigh the testimony. That is their function. Anything else from either side? No, Your Honor, Strand said. Her voice was level, the same tone she'd used for the opening of her argument. No disappointment, no satisfaction. No, Your Honor, Okafor said. Adjourned. Yamada left through the chamber door. Strand packed her briefcase. 1 legal pad, 1 file folder, 1 pen. She closed the clasp with a single motion and stood. The man in the charcoal suit was already carrying the banker's box toward the door. Strand spoke to him once, quietly, and they walked out. Salazar watched her leave. The instruction. What Strand would do with it. The proffer was in. Hadley would testify. Okafor had won. But the instruction was a loaded weapon, every word of it. Strand would stand in front of the hearing panel and walk Hadley through the timeline. Arrested Monday. Charges Wednesday. 3 counts of conspiracy to commit murder. Life in prison. And then Friday, 4 days later, Hadley sits down and tells prosecutors exactly what they need to hear. The lease, the recruitment, the language of the threat, everything connecting Lusk. All of it delivered by a man who had just been told he would die behind bars if he didn't talk. Strand wouldn't need to call Hadley a liar. She would lay out the facts and let the panel do the math. And the instruction from Yamada, the court's own instruction, would tell the panel they were right to question him. Okafor came through the gate and sat next to Salazar. He put his legal pad on the bench between them and took his glasses off. He rubbed the bridge of his nose with his thumb and forefinger. "We won," he said. "You don't sound like it." "We won the motion. Strand won the instruction." "Can you fight the instruction?" "No, it's within Yamada's discretion, and honestly, it's fair. Hadley is a cooperator. The panel should know the terms. The problem is Strand didn't need the proffer excluded. She needed the permission to take it apart in front of the panel, and Yamada just handed it to her. Hadley's proffer is corroborated. You made that argument. Yamada cited it in the ruling. Corroboration supports the proffer. It doesn't inoculate the witness. When Hadley sits in that chair and Strand asks him to explain why he waited 4 days before telling the truth, every hedge, every qualified answer, every "to the best of my recollection" is going to land like a confession. The reporter in the second row was writing again. Salazar waited until she left before speaking. The Reyes letter. The Reyes letter is the backstop. If Hadley crumbles on cross, the letter says the same things he said, from a dead man who had nothing to gain. Has Strand filed to exclude it? Not yet, she will. But the letter is strong. Authentication through Isabella Reyes. Handwriting analysis. Postmark. The content matches the proffer independently. Even Strand will have trouble with that. He picked up his legal pad and stood. 5 days. 5 days. I need to rewrite the witness prep outline for Hadley. The instruction changes everything. He needs to own the cooperation, not apologize for it, not minimize it. Walk in and say, yes, I cooperated, yes, I got a reduced charge, and here is what I said because it is the truth and here is the evidence that proves it. Can Hadley do that? That's what Monday and Tuesday are for. He walked toward the door and stopped. Marcos, how is he? Radio silence from professional standards. 5 weeks. Tell him I asked. I will. Okafor walked out. Nair followed with the accordion files. Salazar sat in the empty courtroom. The clerk was gathering files. The overhead lights buzzed. The second panel from the door still flickered. She took out her phone. A text from Marcos, 40 minutes old. Solis, mother called again on Gower. I told her we're still working it. She asked if you were the detective. I said yes. She said she'd keep calling. She typed back, tell her I'll call her myself this afternoon. Then a second text from Marcos, sent 2 minutes after the first. Professional Standards wants a second interview. Friday. She read it twice, put the phone in her pocket. 5 days until the hearing. Hadley's proffer was in, with a loaded instruction Strand would deploy on cross. Marcos was going back to Professional Standards. Medina was coming in Monday for prep. Frazier was at his disclosed location waiting to testify on a screen from a room Salazar had found by tracing a truck through the desert. She stood up and walked out of Department 127 into the hallway where the fluorescent lights didn't flicker, and the mail cart had already passed, and the building hummed with the ordinary machinery of a system that was not built for justice but sometimes, imperfectly, arrived there anyway. Her phone buzzed. Okafor. Strand just filed. Motion to exclude the Reyes letter. Hearing Friday at 2. Chapter 26. Day 1. Monday, April 14th. Department 127. 8:17 in the morning. Salazar took the same seat she always took. Second row, behind the bar, aisle side. The gallery was fuller than she'd seen it. A row of press in the back with laptops and spiral notebooks. 2 sketch artists near the wall, already sharpening pencils. A woman from the Innocence Coalition in a dark blazer sat behind the prosecution table. 3 law students with yellow legal pads, probably from Okafor's UC Irvine team. The courtroom looked the same. Same fluorescent panels, same flicker in the second one from the door. Same clerk at her desk sorting files. Same American flag that hung slightly crooked behind the bench, tilted 2 degrees to the left. Salazar had noticed it 3 hearings ago, and it hadn't been fixed. Okafor was already at the prosecution table. Dark suit, tie actually knotted. He'd slept. She could tell because his shirt was different from the one he'd worn to the Reyes letter hearing on Friday. Nair sat next to him with 2 accordion files and a laptop. David Shin was at the end of the table with a stack of exhibit binders, numbered tabs visible. Strand entered at 8:21. Navy suit, same briefcase. The man in the charcoal suit carried a single banker's box. Behind them came a woman Salazar hadn't seen before. Mid-30s, dark hair pulled back, tablet in hand. New associate or paralegal. Strand set her briefcase on the defense table and took out 2 legal pads and 3 file folders, more than her usual setup. Lusk was not present. He didn't have to be. This was an evidentiary hearing on the habeas petition, not his criminal trial. His attorneys had filed a notice of appearance, and that was sufficient. At 8:27, a man in a brown sport coat entered through the gallery door and sat in the last row near the wall. 40s, short dark hair, composed posture. He took out a small notebook and a pen. Navarro. Salazar looked forward again. All rise. Yamada came through the chamber door at 8:32, silver-framed glasses. She arranged her files, took a sip of water from the glass on the bench, and looked at both tables. Good morning. We are here for the evidentiary hearing in the matter of Marcus Cole, case number BA 4122836. Petition for writ of habeas corpus. Mr. Okafor, you are counsel for the petitioner. Ms. Strand, you are counsel for the respondent, appearing on behalf of Mr. Lusk in his capacity as a real party in interest. Is that correct? Yes, Your Honor, Okafor said. Yes, Your Honor, Strand said. Good. We have 5 days scheduled. I expect both sides to manage their time accordingly. The court's rulings on the pre-hearing motions stand as entered. The proffer of Mr. Hadley is admitted subject to the credibility instruction I issued on April 9th. The Reyes letter is admitted with the foundation established Friday. Ms. Medina's testimony is admitted as a non-juror witness. Mr. Frazier will testify by remote video pursuant to my order of March 28th. She looked at the gallery. For the members of the press and public, this is an evidentiary hearing, not a jury trial. I am the finder of fact. There will be no opening statements in the traditional sense, but I will allow brief frameworks from each side. Mr. Okafor, 5 minutes. Okafor stood. He moved to the podium between the tables and set his legal pad on it. He didn't look at it. Your Honor, Marcus Cole was convicted of first-degree murder on November 3, 2016. He was sentenced to death. He has spent 10 years on death row. He is innocent. He paused. Not long. The evidence this court will hear over the next 5 days establishes the following. The jury that convicted Mr. Cole was tampered with. The foreman, Carl Hadley, was recruited by the defendant Warren Lusk to secure conviction. Hadley manipulated the deliberations. He threatened at least one holdout juror. He communicated with someone outside the jury during deliberations about the status of the vote. That communication was overheard by a court interpreter and reported to the bailiff the same day. The report was passed to the judge's clerk. Nothing was done. 2 jurors, who later expressed concern about what happened during the trial, are dead. Patricia Whitmore was murdered. Victor Reyes died in a single car accident that the evidence will show was not an accident. A 3rd juror, Robert Frazier, was professionally relocated to prevent his testimony at this hearing. He will testify by video from a secure location. The People filed a complaint about jury misconduct in 2016. That complaint was removed from the court file. A retired court clerk will testify to witnessing the removal. The original complaint filed by juror number 9, Doreen Wyatt, was never acted on. Mrs. Wyatt is 81 years old. She has waited 10 years for someone to listen. He looked at Yamada. Your Honor, this case is about a system that failed, not once, repeatedly, over 10 years. The evidence will show that Marcus Cole's conviction was the product of jury tampering, that every attempt to expose that tampering was suppressed, and that a man has spent a decade on death row for a crime he did not commit. The petitioner asks this court to order a new trial. He sat down. Yamada wrote for 10 seconds, and then looked at Strand. Ms. Strand. Strand stood, hands at her sides, no notes. Your Honor, I want to say something at the outset that I mean sincerely. If Marcus Cole is innocent, the system should correct the error. That is what habeas corpus exists for. That is why this hearing is taking place. The defense does not oppose the hearing. The defense does not oppose the possibility that Mr. Cole was wrongfully convicted. She took one step toward the bench. What the defense opposes is the lowering of evidentiary standards in the name of a sympathetic result. Mr. Okafor asks this court to accept 10-year-old memories as reliable, to credit a cooperation witness who received a reduced charge in exchange for his testimony, to admit overheard fragments of a conversation through a wall by a witness who did not see the speakers, to rely on a letter from a deceased individual who cannot be cross-examined. The defense will show that the investigation leading to this hearing was conducted not by the district attorney's office or by any law enforcement agency with jurisdiction, but by a single LAPD homicide detective who was simultaneously working the Whitmore murder case and coordinating with habeas counsel, a detective who functioned as a de facto advocate for Mr. Cole's petition from the earliest days of her investigation. Salazar kept her hands still in her lap. The defense will show that every witness the petitioner intends to call was identified, contacted, and prepared through that detective's investigation. That the detective shared information with habeas counsel before and during the filing of the habeas petition. That the investigation and the habeas case were not parallel tracks, but a single operation run through 2 channels. Your Honor, memories degrade. 10 years is a long time. Cooperation agreements produce testimony that matches prosecutors' theories. Overheard speech through a wall is the least reliable form of eyewitness evidence. This court should hold the petitioner's evidence to the standard it deserves, not because the defense wants Mr. Cole to remain in prison, but because the standard is what separates evidence from advocacy. She sat down. Yamada wrote for 15 seconds. She looked at Okafor. Call your first witness. The petitioner calls Detective Elena Salazar. Salazar stood. She walked through the gate in the bar, past the prosecution table, and took the witness stand. The clerk administered the oath. Salazar said, "I do," and sat down. The chair was wooden, with arms. She put her hands on the armrests and looked at Okafor. From here, the courtroom looked different. The gallery was wider than she remembered. The press row was a line of faces she didn't know. Navarro was writing in his notebook. The sketch artist closest to the wall was already drawing. Detective Salazar, where are you currently assigned? LAPD Homicide, Hollywood Division. How long have you been a homicide detective? 16 years. In January of this year, were you assigned to investigate the murder of Patricia Whitmore? Yes. Can you describe how that investigation led to your discovery of evidence related to the Marcus Cole trial? This was the part Okafor had prepped. Keep it chronological. Keep it factual. Let the evidence build. Don't argue. Don't characterize. Brick by brick. Mrs. Whitmore was found dead in her home on South Marengo Avenue in Pasadena on January 6th. During the investigation of her murder, I learned she had served as juror number 7 in the Marcus Cole trial in 2016. As I investigated her murder, I discovered evidence suggesting that her death was connected to events that occurred during the Cole trial. Specifically, evidence of jury tampering. What was the first piece of evidence that suggested a connection to the Cole trial? A notation in Mrs. Whitmore's personal records. She had kept a file related to the trial. Inside that file was a letter from Victor Reyes, another juror, describing what he characterized as manipulation of the jury by the foreman, Carl Hadley. Did you verify the authenticity of that letter? Yes. Through handwriting analysis, postal records, and an interview with Mr. Reyes's sister, Isabella Reyes, who confirmed his handwriting and his concerns about the trial. What did you do next? I began contacting members of the Cole jury. I identified 12 jurors. 2 were deceased. Mrs. Whitmore, whose murder I was investigating, and Mr. Reyes. Of the remaining 10, I contacted or attempted to contact each one. How many agreed to speak with you? 5 provided some level of information. 3 refused contact entirely. 2 gave limited statements and then declined further participation. Okafor walked her through the next 40 minutes. The Fraser interview, the Wyatt complaint, the Sandoval and Park statements, the boot print evidence linking Daniel Kelso to the Whitmore scene, the corporate trail connecting Kelso to Citadel Executive Protection, connected to Lusk Development Group through Brannock Hale and Associates. She answered each question the same way: short, specific, dates, times, locations. She named the streets. She named the buildings. She described what she found and when she found it and who she told. At 9:47, Okafor asked about Fraser's sworn statement. Were you present when Mr. Fraser gave his sworn statement to my office? Yes. Why? Mr. Fraser was a witness in my homicide investigation. His account of the threat from Carl Hadley was relevant to establishing a motive for Mrs. Whitmore's murder. The threat suggested a pattern of intimidation that extended beyond the trial. Did you participate in the questioning during that statement? No. Your office conducted the questioning. I observed. Did you share information from your homicide investigation with my office prior to or during the preparation of the habeas petition? Yes. What information? Evidence I had gathered during the murder investigation that was relevant to both the homicide case and the habeas petition, the juror statements, the Reyes letter, the corporate connections between Kelso, Citadel EP, and Lusk Development. Did you share that information because you believed Mr. Cole was innocent? I shared it because it was evidence. The evidence pointed to jury tampering. Jury tampering was relevant to my homicide case because it established the motive for Mrs. Whitmore's murder. It was also relevant to Mr. Cole's petition. I did not make a determination about Mr. Cole's guilt or innocence. I followed the evidence. Thank you, Detective. No further questions. Yamada looked at Strand. Cross-examination. Strand stood. She picked up one of the file folders from the defense table and walked to the podium. She opened the folder and set it flat. Good morning, Detective Salazar. Good morning. Detective, you testified that you shared evidence with Mr. Okafor's office. When did you first contact Mr. Okafor? January 9th, 3 days after the Whitmore murder. 3 days. And at that point, what was the status of your homicide investigation? It was active. We had a crime scene, a victim identification, and preliminary canvassing results. Had you identified a suspect? No. Had you identified the connection between Mrs. Whitmore and the Cole trial? I had identified that she served on the jury, not the significance of that service. But you contacted Mr. Okafor on day 3. Yes. Why? Standard procedure. When a homicide victim has involvement in a capital case, we notify relevant counsel. Standard procedure. Strand looked at the folder. Detective, in your 16 years in homicide, how many times have you contacted death penalty defense counsel within 72 hours of a murder? Salazar paused 1 second. This was the first time. The first time, so it was not standard procedure, it was a judgment call. It was appropriate given the circumstances. I'm not questioning whether it was appropriate. I'm establishing that it was your decision, not a protocol requirement. Is that correct? Yes. Thank you. Now, Detective, you testified that you contacted or attempted to contact all 12 jurors from the Cole trial. Did you do that as part of your homicide investigation? Yes. All 12. All surviving jurors, yes. Detective, how many of those 12 jurors were suspects in the Whitmore murder? None of them were suspects. How many were persons of interest? None. How many had any connection to the physical evidence at the Whitmore crime scene? None. So you contacted 12 jurors, none of whom were suspects or persons of interest in your homicide, as part of your homicide investigation. They were potential witnesses. Mrs. Whitmore's service on the Cole jury appeared to be connected to her murder. Contacting the other jurors was a logical investigative step. A logical investigative step. Strand turned a page in the folder. Detective, I have here the transcript of your deposition taken on March 5th of this year. Do you recall that deposition? Yes. During that deposition, I asked you how many conversations you had with Mr. Okafor between January 9th and January 23rd. Do you recall your answer? 14 calls and 3 in-person meetings. 14 calls and 3 meetings in 14 days, with the attorney representing the habeas petitioner, while you were investigating a homicide. The cases overlapped. The same evidence was relevant to both. I understand, but Detective, did you document those 17 contacts with Mr. Okafor in your homicide case file? Salazar paused again. Not all of them. How many? 3. The initial notification. A follow-up regarding the Reyes letter, and the meeting where I provided copies of the juror statements. 3 out of 17. So, 14 of your communications with habeas counsel during a homicide investigation went undocumented in the homicide file. The contacts were related to the homicide. Not all contacts are separately documented in the murder book. Detective, is it standard practice in LAPD homicide to have 14 undocumented contacts with an outside attorney during an active investigation? No. Thank you. Strand closed the folder and opened the second one. Detective, let me ask about the juror interviews. When you spoke with Doreen Wyatt, did you inform her that you were investigating the Whitmore murder? Yes. Did you also inform her that there was a pending habeas petition on behalf of Marcus Cole? She was aware of it. I confirmed it. And when you spoke with Robert Fraser, did you inform him about the habeas petition? He was aware of it as well. Detective, when you told these jurors about the habeas petition, did you explain that their statements could be used in both your homicide case and the habeas proceeding? I told them their statements could be relevant to multiple legal proceedings. But you did not ask them to sign separate consent forms for the homicide investigation and the habeas case. No. You did not have separate interviews for each purpose. No. The information was the same regardless of which proceeding it served. The information was the same, but the purpose was different. In the homicide investigation, you were trying to establish who killed Patricia Whitmore. In the habeas case, Mr. Okafor was trying to establish that Marcus Cole was wrongfully convicted. Those are different objectives, are they not? They are related objectives. Related, but different. Yes. Strand set the second folder on the podium. Detective, your partner, Detective Marcos, obtained boot print evidence from the Whitmore scene. He brought that evidence directly to you rather than routing it through his chain of command. Is that correct? Detective Marcos identified a boot print at the crime scene and brought the comparison results to my attention. Through his chain of command? He brought them to me directly. Bypassing standard evidence routing protocols. He exercised judgment about the urgency of the evidence. I understand. And that boot print evidence became a critical element in both the homicide case and the habeas petition. Yes. Detective, are you aware that Detective Marcos is currently the subject of an inquiry by LAPD professional standards regarding his handling of that evidence? Okafor stood. Objection. Relevance. Detective Marcos's personnel matters are not before this court. Yamada looked at Strand. Ms. Strand, where are you going with this? Your Honor, the defense is establishing that the investigation underlying this petition involved multiple departures from standard police procedure. The professional standards inquiry is relevant to the reliability of the evidence chain. The objection is sustained as to the specific inquiry. You may ask about the procedure, not the personnel action. Thank you, Your Honor. Strand turned back to Salazar. Detective, you testified that Detective Marcos brought the boot print evidence directly to you rather than through standard channels. Was that consistent with LAPD evidence handling procedures? It was consistent with his judgment as a detective. That was not my question. Was it consistent with standard LAPD evidence handling procedures? No. Thank you. Strand picked up both folders. Detective, I want to summarize. You contacted habeas counsel 3 days into your investigation. You had 17 contacts with that counsel in 14 days, 14 of which were undocumented. You interviewed 12 jurors, none of whom were suspects in your homicide. You were present for the key witness's sworn statement to habeas counsel. Your partner bypassed evidence protocols to bring you evidence that served both the homicide and the habeas case. And at no point did your department assign a separate investigator to handle the habeas-related evidence independently. No one assigned a separate investigator because the cases were intertwined. The same evidence, the same witnesses, the same chain of events. I understand your position, Detective. My question is whether you can identify a single point in your investigation where you drew a line between investigating the Whitmore murder and building the case for Marcus Cole's habeas petition. Salazar looked at Strand. The courtroom was quiet. The sketch artist's pencil had stopped. Every interview I conducted was in service of the homicide investigation. The evidence I gathered supported both proceedings because the underlying facts were the same. I did not build the habeas case. I investigated a murder, and the evidence led where it led. Thank you, Detective. Strand turned toward the bench. No further questions. Yamada looked at Okafor. Redirect. Okafor stood. Detective Salazar, Ms. Strand asked whether you can identify a single point where you drew a line between the homicide investigation and the habeas case. I'd like to ask a different question. Can you identify a single piece of evidence you gathered that turned out to be fabricated, false, or unreliable? No. Can you identify a single witness you contacted who later recanted their account because you had pressured or coached them? No. The boot print evidence that Detective Marcos brought to you, was it subsequently verified by the LAPD crime lab? Yes. Was it verified by an independent forensic examiner retained by the district attorney's office? Yes. And the juror statements you gathered, were they subsequently reviewed by the district attorney's office? Yes. The district attorney's office used those statements as the basis for the charges against Carl Hadley and the grand jury presentation regarding Mr. Lusk. So, the evidence you gathered, through whatever process, was independently verified and formed the basis for criminal prosecution. Yes. Thank you. No further questions. Yamada looked at Strand. Strand shook her head. The witness may step down. Salazar stood and walked back through the gate to the gallery. She sat in her seat. Second row, aisle side. From here, she could see both tables. Okafor writing on his legal pad. Nair pulling a file from the accordion folder. Strand speaking quietly to the new associate, who was scrolling through something on her tablet. She could feel the cross-examination settling into the room. Not the specific questions, the shape of them. Strand hadn't called her a liar. Hadn't accused her of fabricating evidence. Hadn't suggested she planted anything or coached anyone. What Strand had done was simpler and worse. She had described a detective who made judgment calls at every turn, who contacted counsel too early, who documented too little, who blurred every boundary between investigation and advocacy, not because she was corrupt, but because she believed she was right. And some of it was true, not all of it, but some of it. She had called Okafor on day 3 because she already suspected the murder was connected to the trial. She hadn't documented every call because documenting them would have raised questions she didn't want to answer yet. She had been in the room for Fraser's statement because she wanted to hear it, not because her homicide investigation required her presence. She had done these things because the evidence demanded them. Because a man was on death row and jurors were dying and the system was not self-correcting. And Strand had taken every one of those decisions and arranged them into a frame that made conviction look like bias and thoroughness look like advocacy. Yamada spoke. Mr. Okafor, your next witness. Your Honor, the petitioner calls Doreen Wyatt. The gallery doors opened. An elderly woman in a dark blue dress walked in. She moved steadily, without a cane. Her white hair was pinned back. She carried nothing. She walked through the gate, past both tables, and took the witness stand. The clerk administered the oath. "I do," Wyatt said. Her voice was clear. It carried to the back of the courtroom without effort. Okafor stood and moved to the podium. "Good morning, Mrs. Wyatt." "Good morning." "Mrs. Wyatt, you served as juror number 9 in the trial of Marcus Cole in November 2016. Is that correct?" "Yes." "During that trial, did you observe anything that concerned you about the conduct of the jury foreman, Carl Hadley?" "Yes, I did." Salazar watched Strand uncap her pen. The hearing was 2 hours old, and they were already at the center of it. Wyatt on the stand, Strand preparing her cross. 5 days stretching out ahead of them in this room with the crooked flag and the flickering light, and the only question that mattered was whether the evidence could survive the frame that had been built around it. Wyatt sat straight in the witness chair and waited for the next question. Chapter 27. Day 2. Tuesday, April 15th. Department 127. 8:34 in the morning. Wyatt was already in the witness chair when Yamada took the bench. Same dark blue dress, same white hair pinned back. She had been sworn in the previous afternoon, and Okafor had taken her through the preliminary questions before Yamada recessed at 4:15. Now the courtroom settled, and Yamada nodded at the prosecution table. "Mr. Okafor, you may continue your direct examination of Mrs. Wyatt." Okafor stood and walked to the podium. He set his legal pad down but didn't look at it. "Good morning, Mrs. Wyatt." "Good morning. Yesterday we established that you served as juror number 9 in the trial of Marcus Cole in November 2016. I'd like to take you to the evening of November 1st. Where were you at approximately 5:45 that evening?" "In the courthouse parking structure, level 2. I was walking to my car." "Which car?" "Blue Toyota Camry, 2009. I parked in the same spot every day of the trial. Second level, northeast corner, near the elevator." "What happened as you were walking to your car?" "I heard a man's voice, loud enough that it carried. He was on a phone. I couldn't see who he was speaking to on the other end, but I could hear his side of the conversation." "Where was this man in relation to you?" "He was standing by a silver sedan near the elevator entrance. I was approximately 40 feet away, walking toward my car." "Did you recognize the man?" "Yes. It was the foreman, Carl Hadley." "How did you know it was Mr. Hadley?" "I had been sitting in a jury box with him for 6 days. I knew his face, I knew his voice. He was wearing the same gray suit he'd worn that day in court." "What did you hear Mr. Hadley say?" Wyatt straightened in the chair. Not because she needed to, because she was delivering testimony and she understood what that meant. "He said, 'We're close. One more day. The woman is the problem, but I can handle her.' Then he listened for a moment. Then he said, 'It'll be done by tomorrow afternoon. I'm telling you it's handled.'" "Did he say anything else?" "He said a name. I didn't catch the full name. It sounded like Warren or Lawrence. The acoustics in the structure made it difficult to hear clearly at that distance, but the rest of what he said was clear." "Mrs. Wyatt, when he said, 'The woman is the problem,' did you have any understanding of who he was referring to?" "Yes, me. I was the only woman on the jury who had expressed any doubt about the prosecution's case during deliberations." Salazar watched from the second row. Wyatt's hands were in her lap. Her voice carried the same as the previous afternoon. No tremor, no searching for words. She had rehearsed nothing and remembered everything. "What did you do after you heard this conversation?" I stood by my car for a moment. I was shaken. I sat in the car for several minutes trying to decide what to do. Then I drove home. "Did you report what you heard?" "Not that evening. I went home, and I wrote down exactly what I heard, word for word, on a piece of notebook paper. I put the date on it. November 1st, 2016. "When did you report it?" "The next day, November 2nd. During the afternoon break, at approximately 3:12, I went to the bailiff, Deputy Ronaldo, and told him what I had overheard in the parking structure the previous evening." "What did Deputy Ronaldo do?" "He wrote it down in his log. He said he would pass it to the judge's clerk." "Did anyone follow up with you?" "No." "No one from the judge's chambers?" "No." "No one from the district attorney's office?" "No." "What happened the next day?" November 3rd. The deliberations continued. The vote was taken. The verdict was guilty, unanimous. Okafor let the silence hold for 3 seconds. "Mrs. Wyatt, did you vote guilty?" "Yes." "Why?" "Because by the time the final vote was taken, I was the last holdout. Mr. Hadley had spent the morning of November 3rd going around the table, juror by juror, making his argument. He was persuasive. He was persistent. And I was alone." "Did you believe Mr. Cole was guilty?" "I believed the evidence was not conclusive. But I also believed that 11 other people had reached a different conclusion, and I questioned whether my doubt was reasonable or just stubbornness. Mr. Hadley told me privately during a break that if I held out, it would be a mistrial, and the family of the victim would have to go through another trial. He said I owed it to them to let the system work." "Did you change your vote because of what Mr. Hadley said?" "I changed my vote because I was exhausted and alone, and I made a mistake. The worst mistake of my life." Okafor paused. He picked up his legal pad. "After the trial, what did you do about what you had witnessed?" "I filed a formal complaint with the court. December 2016. I described what I had overheard in the parking structure. I described Mr. Hadley's conduct during deliberations. I described the pressure he put on me and on other jurors." "What happened to that complaint?" "Nothing." "Did you receive a response?" "I received an acknowledgement letter, a form letter. It said my complaint had been received and would be reviewed. I never heard from anyone again." "Did you follow up?" "I followed up 7 times over 4 years. 2017, 2018, twice in 2019, 2020, and twice in 21. Letters, phone calls. Each time I was told the matter was under review or had been referred to the appropriate office." "Was any action ever taken?" "No." "Mrs. Wyatt, when Detective Salazar contacted you in January of this year, how long had it been since you filed that complaint?" 10 years. Almost exactly 10 years. "And in those 10 years, did anyone from the court, the district attorney's office, or any law enforcement agency contact you about your complaint or your observations?" "No, not one person. Not until Detective Salazar knocked on my door." Okafor looked at Yamada. "No further questions, Your Honor." Yamada wrote for several seconds. She looked at the defense table. "Ms. Strand, cross-examination." Strand stood. She carried a single folder and a bound document. She walked to the podium and set them both down. She opened the folder first. "Good morning, Mrs. Wyatt." "Good morning." "Mrs. Wyatt, you've described an event that took place on November 1st, 2016. That's approximately 10 years ago, is that correct?" "Yes." "And you testified that you were approximately 40 feet from Mr. Hadley when you heard this conversation?" "Approximately, yes." 40 feet in a parking structure?" "Yes." "Mrs. Wyatt, have you ever been in a parking structure and noticed how sounds behave in that space? The echo, the way voices bounce off concrete walls and ceilings?" "I have been in many parking structures in my life." "Of course. My question is whether you've noticed the acoustic properties, the echo effect, how sounds can be distorted or amplified in an enclosed concrete space." "I noticed that his voice carried. That's why I could hear him." "His voice carried, 40 feet, through the ambient noise of a parking structure, cars moving, engines, ventilation systems." "There were no cars moving near us at that moment. The level was mostly empty. It was after 5. Most people had left." "Mostly empty. But you said he was standing near the elevator entrance. Were the elevator motors running?" "I don't recall whether the elevator was moving at that moment." "You don't recall. Mrs. Wyatt, you testified that Mr. Hadley said, and I'm quoting your testimony, 'We're close. One more day. The woman is the problem, but I can handle her. Then, it'll be done by tomorrow afternoon. I'm telling you it's handled.' And then a name that sounded like Warren or Lawrence. Is that accurate?" "Yes." "Those are the exact words." "Those are the words I heard. I wrote them down that evening." "You wrote them down that evening. Do you still have that piece of paper?" "No. I included it with my complaint filing in December 2016. So, the original document is in the court's complaint file. If the court still has the file, I submitted it." "Mrs. Wyatt, I want to ask you about the process of remembering. You heard these words once, 10 years ago, from 40 feet away in a parking structure. You wrote them down that evening. Since then, how many times have you repeated these words?" "I don't understand the question." "How many times have you told this story? To your family, to friends, to yourself?" "I have thought about it many times." "How many times have you spoken the words aloud?" "I told the bailiff the next day. I included them in my complaint. I told Detective Salazar in January. I told Mr. Okafor's office during preparation. I am telling this court now." "So, at least 5 occasions over 10 years. Each time, you repeated the same words." "Each time I reported what I heard." Strand picked up the bound document from the podium. She held it so the cover faced Wyatt. "Mrs. Wyatt, are you familiar with the field of cognitive psychology as it relates to memory and recall?" "I am not an expert in psychology." "Of course not. I'd like to introduce you to a concept. When a person experiences an event and then repeatedly retells that event over time, the retelling itself can become the memory, The person remembers their telling of the story rather than the original event. This is a well-documented phenomenon called retrieval-induced distortion. Are you aware of that concept? Okafor stood. Objection. Counsel is testifying. If the defense wants expert testimony on memory science, they should call their expert. Yamada looked at Strand. Ms. Strand, do you have a question for the witness? I do, Your Honor. Strand turned back to Wyatt. Mrs. Wyatt, is it possible that after 10 years and multiple retellings, the words you've reported are not the exact words Mr. Hadley spoke, but rather the words you've come to associate with the event through repeated recall? No. No. No, I know what I heard. I wrote it down within 3 hours of hearing it. The words I wrote that evening are the words I have reported every time since. They have not changed because what happened did not change. But the original document is in the court's file, which you no longer have access to, so you cannot compare your current testimony against your contemporaneous notes. The words have not changed. Strand turned a page in her folder. Mrs. Wyatt, you testified that you were 40 feet away. I'd like to discuss that distance. 40 feet is approximately the length of a school bus. In a concrete parking structure with reflective acoustic surfaces, a conversation at 40 feet would be subject to significant echo and distortion. Consonants in particular degrade over distance in reverberant environments. The difference between Warren and Lawrence, for example, is largely a matter of consonant sounds. I testified that I was uncertain about the name. I told this court I couldn't catch it clearly. I was honest about what I could and could not hear. I appreciate that honesty, Mrs. Wyatt. My concern is with the portions you are certain about. You are certain, he said, the woman is the problem, 40 feet away, through the acoustics of a parking structure. He was speaking loudly. He was not whispering into the phone. He was speaking the way a man speaks when he believes he is alone. Speaking loudly, Mrs. Wyatt, how would you characterize your hearing? My hearing is fine. Have you had your hearing tested recently? My doctor examines me annually. My hearing is within normal range for my age. Within normal range for your age, which is 81. Yes, 81. Mrs. Wyatt, I am going to refer to research conducted by Dr. Ann Whitfield, a cognitive psychologist at Stanford University. Dr. Whitfield has studied the acoustic properties of enclosed concrete structures, including parking garages, specifically as they relate to witness reliability. Her peer-reviewed research indicates that speech intelligibility in parking structures drops below 70% at distances greater than 25 feet and below 50% at distances greater than 40 feet. The primary factors are reverberation time, which in concrete structures averages 2.4 seconds, and the masking effect of ambient mechanical noise from ventilation, elevator motors, and vehicle systems. Okafor stood. Objection. Counsel is reading from a document that has not been admitted as an exhibit and is testifying to expert conclusions. If Ms. Strand wishes to present Dr. Whitfield's research, she should call Dr. Whitfield as a witness. Yamada considered. I'll allow the question if it's framed as a question. Ms. Strand, ask your question. Strand nodded. Mrs. Wyatt, given that research has shown speech intelligibility drops significantly at distances greater than 25 feet in parking structures, is it possible that what you heard at 40 feet was not the complete or accurate content of Mr. Hadley's phone conversation? No. You're certain. I am certain of what I heard. I am certain because I heard it. I wrote it down, I reported it, and I have carried it for 10 years. I did not mishear him, I did not imagine it, I did not confuse it with something else. Wyatt's hands had not moved from her lap. Her voice had not changed in volume or pitch. She looked at Strand the way she might look at a clerk who had misfiled her paperwork. Mrs. Wyatt, I am not suggesting you imagined anything. I am asking whether at 40 feet, in a reverberant concrete environment, with the acoustic limitations that are well documented in the scientific literature, it is possible that some of the words you attribute to Mr. Hadley were your interpretation of sounds rather than his exact language. You are asking me whether I know what I heard. I am asking whether it is possible that you are mistaken. And I am telling you that I am not mistaken. I heard him say the woman is the problem. I heard him say it'll be done by tomorrow afternoon. I heard those words clearly, at a distance I have described honestly, in a parking structure that was quiet because it was after 5 o'clock and the level was nearly empty. I was not confused then, and I am not confused now. Salazar watched Strand's face. Nothing changed. No tightening around the eyes. No shift in posture. She was listening the way a surgeon listens to a patient describe symptoms that don't match the scan. Mrs. Wyatt, let me move to a different area. You testified that you wrote down Mr. Hadley's words on the evening of November 1st. You filed your formal complaint in December 2016. Between November 1st and December, did you discuss what you heard with anyone? My husband. He was alive then. I told him that evening. What did he say? He said I should report it. Did you discuss the specific words with him? Yes. I read him what I had written down. Did he offer any opinion on what the words meant? He said it sounded like the foreman was fixing the jury. He said it sounded like that. Mrs. Wyatt, did your husband's interpretation influence how you understood what you had heard? My husband agreed with what I already knew. He did not change my understanding. He confirmed it. Mrs. Wyatt, you testified that you filed a complaint in December 2016 and followed up 7 times over 4 years. Why did you stop following up? I didn't stop. I moved to a retirement community in 2021. My husband had passed. I was alone. I continued to write letters until 2021. Nobody responded. At a certain point, you understand that the system is not going to act. But you still remembered. Of course, I still remembered. A man is on death row because of what I saw happen and nobody would listen. You don't forget that. Mrs. Wyatt, you said a man is on death row because of what you saw. Is it your testimony that Marcus Cole was wrongfully convicted because of jury tampering? It is my testimony that the foreman tampered with the jury. I saw him making a phone call about the deliberations to someone outside the jury. I reported it, nobody acted, and a man has been in prison for 10 years. You testified earlier that you voted guilty. I did. You voted guilty despite having heard this phone call the evening before. I reported the phone call to the bailiff. I expected the court to act on it. When no one acted, I was left in a room with 11 other jurors and a foreman who was pressuring me to change my vote. I changed it. I should not have. Strand paused. She closed the folder. Mrs. Wyatt, you testified that you filed a complaint, wrote letters, made phone calls, and waited 10 years. That is a long time to carry something. I want to ask you this respectfully. After 10 years of believing that an injustice occurred, after 10 years of telling this story, after 10 years of waiting for someone to listen, is it possible that the strength of your conviction about what happened has made you more certain about the specific words than the original experience warrants? Wyatt looked at Strand. The courtroom was quiet. The sketch artist had stopped drawing. Navarro's pen was still. Ms. Strand, I am 81 years old. I have buried my husband. I have been evaluated by a psychologist who confirmed that my memory is intact. I have told the same story in the same words since the evening it happened, because it happened. I did not become more certain over 10 years. I was certain the first night. I was certain when I told the bailiff. I was certain when I filed the complaint. I was certain every time I wrote a letter that no one answered. She paused, not for effect, because she was choosing her next words. I know what I heard. I've known it for 10 years. Don't tell me I'm confused. Yamada did not move. She did not write. She watched Wyatt. Strand stood at the podium for 2 seconds. Then she turned to the bench. No further questions, Your Honor. Yamada looked at Okafor. Redirect? Okafor stood. He did not go to the podium. Mrs. Wyatt, Ms. Strand asked you about the acoustics of the parking structure. You testified that the level was mostly empty and quiet. Was there anything preventing you from hearing a man speaking at normal volume from 40 feet away in those conditions? No. The level was quiet. His voice was clear. Ms. Strand asked about retrieval-induced distortion, the idea that retelling a story can alter the memory. You testified that you wrote down the words within 3 hours. Did you write them from memory that evening, or did you write them while they were still in your mind from the experience? I wrote them as soon as I got home. I sat at my kitchen table and wrote down exactly what I heard. It was fresh. It was not a memory of a memory. It was the event, recorded within hours. Mrs. Wyatt, in the 10 years since you filed your complaint, has anyone ever told you that your report was investigated and found to be without merit? No. Has anyone ever told you that your report was investigated at all? No. To your knowledge, was any investigation conducted? Not to my knowledge. I was never contacted. I was never interviewed. I was never told anything. Thank you, Mrs. Wyatt. No further questions. Yamada looked at Strand. Strand shook her head. The witness may step down. Wyatt stood. She smoothed the front of her dress with both hands. She walked past the defense table and the prosecution table and through the gate into the gallery. She did not look at Salazar. She did not look at anyone. She walked to the back of the courtroom and sat in the last row on the opposite side from Navarro. The courtroom was quiet for several seconds after she sat down. Yamada wrote on her legal pad. The clerk sorted a file. One of the law students in the front row turned to look at Wyatt and then turned back. Salazar sat in the second row and watched the bench. Strand's cross had been precise. She had not attacked Wyatt's character. She had not called her a liar or suggested she was senile or questioned her motives. She had done something more clinical. She had placed a 40-foot distance and a 10-year gap and the acoustic properties of a concrete parking structure between Wyatt's certainty and the court's ability to rely on it. She had introduced Whitfield's research without calling Whitfield to the stand, which meant the framework was in the room now, available for Yamada's consideration during deliberation on the ruling, planted in the record through the cross-examination questions themselves. And Wyatt had held. Not because she had countered the science or disputed the research. Because she had sat in that chair and said the words the same way she had said them for 10 years and dared the courtroom to disbelieve her. Whether that was enough depended on Yamada, on whether certainty carried weight against methodology, on whether 10 years of consistency meant reliability or rigidity. Yamada looked up from her notes. "Mr. Okafor, your next witness." Okafor stood. "Your Honor, the petitioner calls Lucia Medina." Salazar looked at the gallery doors. The afternoon stretched ahead. Medina in the hallway. Strand's folder already open to the next tab. Whitfield's research on overheard speech through walls. 12% retention. Confidence accuracy uncorrelated. The same framework that had just been aimed at Wyatt from 40 feet was about to be aimed at Medina through plaster and wood. The gallery doors opened. Chapter 28. Day 3. Wednesday, April 16th. Department 127. 9:02 in the morning. Medina had been sworn in the previous afternoon. Okafor had taken her through the preliminary questions before Yamada recessed at 4:30. Name, occupation, certification number. Her voice had been steady and precise. Each answer delivered the way a trained interpreter delivers a translation. One sentence at a time, nothing added, nothing omitted. Now, Medina sat in the witness chair wearing a dark blouse and gray cardigan. Her hair was pulled back in a low bun. Her hands were folded on the rail in front of her. She looked at Okafor and waited. "Good morning, Ms. Medina." "Good morning. Yesterday, we established that you were assigned as a certified court interpreter for the trial of Marcus Cole on November 1st and 2nd, 2016. I'd like to take you to the afternoon of November 2nd. Where were you at approximately 2:15? "In the interpreter's waiting area on the 3rd floor, adjacent to the jury room. The court keeps interpreters on standby during deliberations in case testimony is read back." "Describe the waiting area." "A small room. 1 table, 2 chairs, a lamp. The wall between the waiting area and the hallway outside the jury room was old plaster over a wood frame. Not soundproofed. You could hear conversations through it if people were speaking at normal volume." "What happened at approximately 2:15? "I heard a voice I recognized from the courtroom. The foreman. He was speaking in the hallway, not inside the jury room. The hallway was on the other side of the wall from where I sat." "How did you know it was the foreman?" "I had listened to him for 2 days during testimony. When you interpret, you learn voices, rhythm, pitch, cadence. I recognized it immediately." "What did you hear him say?" Medina's hands remained folded. She did not look at notes. She did not pause to remember. "He said, 'Votes moving. 2 holdouts. The woman won't budge, but the other one is close.'" "Did you hear anything else?" A second voice responded. Male, older, deliberate, but the words were muffled through the wall. "And then?" The foreman spoke again. He said, "By tomorrow." Okafor stood at the podium without moving. "Miss Medina, what did you do after hearing this?" "I sat for approximately 45 minutes deciding what to do. During the 3 o'clock break, I went to the bailiff. Deputy Ronaldo. I told him what I had overheard." "What did Deputy Ronaldo do?" "He wrote it in his duty log. He said he would pass it to the judge's clerk." Did anyone follow up with you? No. Were you asked to write a statement? No. Were you contacted at any point in the following 10 years? No, not until this year. Okafor picked up a document from the table. I'm showing you Petitioner's Exhibit 14. Deputy Ronaldo's duty log, November 2nd, 2016. Can you read the entry at 3:47 p.m.? Medina looked at the document. It says, Court Interpreter L. Medina reports overhearing foreman discussing jury vote with unidentified male in hallway ADJ to jury room. State's foreman said vote is moving, 2 holdouts, 1 close. Said by tomorrow. Interpreter waiting area, wall not soundproofed. Reported during 3 o'clock break. Does that match what you reported? Yes. Ms. Medina, you left court interpreting in 2019. Why? Medina was quiet for a moment, not searching for words, measuring them. I could not continue working in courtrooms knowing what I knew. I had reported what I heard. Nothing happened. Every time I stood in a courtroom after that, I thought about the man who was convicted. I thought about what the foreman said. I thought about the fact that I told someone, and no one did anything. Did you discuss what you heard with anyone else? Friends, family, co-workers? No. I reported it to the bailiff. That was my obligation as an officer of the court. When nothing happened, I carried it. Salazar sat in the second row. Medina's voice had not changed from the previous afternoon. The same measured delivery, the same interpreter's precision. She stated what she heard, what she did, what happened after. She did not editorialize. Okafor looked at Yamada. No further questions, Your Honor. Yamada wrote, Ms. Strand. Strand stood carrying the same bound document she had used during Wyatt's Cross, Whitfield's book. She set it on the podium. Good morning, Ms. Medina. Good morning. You testified that you heard the foreman's voice through a plaster wall. Is that correct? Yes. And you testified that the second voice was muffled, and you could not make out the words. The second voice was further from the wall, or speaking more quietly. So, the wall allowed some sounds through clearly and others not at all. It depended on volume, proximity, and direction. Ms. Medina, Dr. Ann Whitfield of Stanford University has conducted research on the reliability of overheard speech. Her peer-reviewed findings indicate that speech perceived through a physical barrier is subject to significantly higher rates of perceptual error than direct communication. The listener's brain fills in gaps with contextually plausible content. This is called perceptual completion. Her studies found that listeners who overheard conversations through standard interior walls correctly identified only 12% of specific word sequences after 1 week. Confidence in their recall remained high. People who overheard speech through walls were very confident about what they heard, but very often wrong. Okafor stood. Objection. Counsel is presenting expert testimony through cross-examination. Yamada looked at Strand. Frame your questions as questions, Ms. Strand. Ms. Medina, given that you heard these words through a plaster wall, is it possible that some of what you perceived was your brain filling in contextually appropriate words rather than the exact words spoken? No. You're certain? The foreman's voice was close to the wall. He was not whispering. I was sitting less than 4 feet from the wall on the other side. Strand turned a page. You testified that you waited 45 minutes before reporting. During those 45 minutes, did you write down what you heard? No. Mrs. Wyatt testified yesterday that she wrote down what she heard within 3 hours. You did not write down what you heard at all. I reported it verbally to the bailiff within the hour. He wrote it down in his duty log. The bailiff wrote it down, in his words, based on your verbal report. Based on my verbal report, the entry is accurate. Ms. Medina, you've reported these words on 2 occasions. To Deputy Ronaldo in 2016 and to this court today. 10 years apart. You did not speak them to anyone else, and yet you recall them with perfect clarity. Ms. Strand, I am a court interpreter. My job is to listen to words spoken in one language and reproduce them accurately in another language. I do this in real time, under oath, in proceedings where a person's freedom is at stake. I have been certified for 22 years. I have interpreted in over 300 proceedings. When I hear words, I retain them. That is not a claim, that is my profession. She paused, not for effect, because she was being precise. I heard the foreman say, votes moving. 2 holdouts. The woman won't budge, but the other one is close. I heard him say, by tomorrow. I reported those words within 45 minutes. The bailiff's record matches. The words have not changed because the words are correct. Strand looked at her folder. Miss Medina, you changed your entire career based on what you believe you heard through a wall. After 10 years of carrying this, is it possible that the strength of your conviction has made you more certain about the specific words than the original experience warrants? I changed my career because I reported a serious event, and the system did nothing. Nobody contacted me. Nobody investigated. The complaint was received and ignored. Strand closed her folder. No further questions. Yamada looked at Okafor. Redirect? Okafor stood. He did not approach the podium. Ms. Medina, when you heard the foreman's words, were you expecting to hear them? No, I was reading a magazine and waiting to be released. So the words were unsolicited and unexpected. Completely unexpected. Ms. Strand referenced Dr. Whitfield's research. 12% retention after 1 week. How long after hearing these words did you report them? Approximately 45 minutes. Not 1 week. Less than 1 hour. And the bailiff's contemporaneous log entry matches your testimony today. Yes. No further questions. Strand shook her head at the offer of recross. Medina stepped down from the witness chair. She walked through the gate and sat in the 3rd row on the prosecution side, directly behind Salazar. Salazar did not turn around. She heard Medina settle into the bench. Yamada looked at the clock. 10:17. Mr. Okafor, your next witness. Okafor stood. The petitioner's next witness is Robert Fraser. As the court is aware, Mr. Fraser will testify by remote video pursuant to this court's order. The clerk turned on the monitor mounted to Yamada's left. The screen flickered and resolved into a video feed. Beige walls, a table, a single window behind the witness, bright with desert light that washed the color from everything. Fraser sat at the table facing the camera. He wore a blue button-down shirt that looked new. His hair was shorter than the last time Salazar had seen him, cut close, exposing the gray at his temples. He was thinner. His eyes moved from the camera to something off-screen and back. The remote testimony setup placed Frazier in a room at the Kern County Superior Court building in Bakersfield, monitored by a court officer. Okafor had arranged it after Frazier refused to appear in Los Angeles. Not wouldn't, couldn't. That was the word he used when Salazar drove out to Ridgecrest the second time. Yamada administered the oath through the monitor. Frazier raised his right hand. His voice came through the courtroom speakers with a half-second delay that stripped the presence from his words. Robert James Frazier. Okafor approached the podium. Mr. Frazier, you served as juror number 6 in the trial of Marcus Cole in October and November 2016. During the trial, did anything unusual happen involving the jury foreman, Carl Hadley? Yes. Tell the court what happened. Frazier looked at the camera. On the monitor, his eyes appeared to look slightly to the left of everyone in the room. During the morning break on October 28th, the second week, Hadley came up to me in the hallway outside the jury room. He said the evidence was clear and that holding out would drag things out. I told him we weren't supposed to discuss the case outside deliberations. He said he was making conversation. Did he approach you again? 2 days later, October 30th, same hallway, more direct. He said, people who make this difficult have difficult lives afterward. Those were his exact words. His exact words. How did you interpret that? As a threat. What did you do? Nothing. Frazier's hands were flat on the table, fingers spread. I should have reported it. I didn't. Why not? Because I was scared. I didn't know who Hadley was connected to. I was a guy on a jury. I didn't know who to tell. Did Mr. Hadley's statement affect your vote? Yes. I had doubts about the evidence. I thought the prosecution hadn't proven it. But after what Hadley said, I voted guilty. After the trial, what did you do? I moved to Arizona. About 8 months later, I was afraid. Salazar watched the screen. The desert light behind Frazier made him look washed out, less than solid. The audio delay stripped his words of the urgency they carried in person. She had sat across from him in the house outside Ridgecrest and heard the fear in real time. Through the monitor, it sounded like recitation. Okafor moved through the remaining questions. The relocation, the isolation, the sworn statement in January. Frazier told the court that Salazar had found him in California and asked him to testify. He said yes, because she told him it mattered. No further questions, Your Honor. Ms. Strand. Strand walked to the podium with a single folder. Mr. Frazier, you testified that Mr. Hadley threatened you in October 2016. Did you report this threat to the bailiff? No. To the judge? No. To any court officer? No. Did you file a police report? No. Did you tell anyone at all at the time? No. A threat serious enough that you moved to another state, but you reported it to no one. I was scared. You were scared, and when you arrived in Arizona, did you contact law enforcement about the threat? No. Mr. Fraser, the first time you reported this alleged threat was in January of this year. To whom did you give that statement? Detective Salazar was present. Mr. Okafor's office arranged it. Detective Salazar, who is herself a witness in this proceeding, who had been working with petitioner's counsel throughout the investigation. Your sworn statement was not given to the district attorney's office. It was not given to a prosecutor. It was given in the presence of a detective who is herself a witness, arranged by petitioner's counsel and submitted by petitioner's counsel as evidence. At no point was it taken by a neutral party. Okafor stood. Objection. The circumstances of the statement were disclosed in our filing. Counsel's characterization is argument. Overruled. The witness may answer. Fraser looked at the camera. The pause stretched. I told the truth. I don't know about the legal chain of whatever. I told them what Hadley said to me. Strand turned a page. Mr. Fraser, you are testifying today by remote video from Bakersfield. You declined to appear in person. Yes. You were relocated from your apartment in Scottsdale to a location in California. Detective Salazar found you there. You have since been moved again. Throughout all of this, you have not filed a police report regarding any threat. I haven't filed a report, no. You are testifying from a remote location, through a video screen, about events from 10 years ago, based on a statement arranged by the petitioner's attorney. You have declined to appear in this courtroom, and you are asking this court to credit your testimony that a man threatened you a decade ago. He said it. I'm telling you, he said it. No further questions. Yamada looked at Okafor. Redirect? Okafor stood. Mr. Fraser, you said you were scared. In the 10 years since the trial, has anything happened that confirmed your fear? I was taken from my apartment in the middle of the night by a man I'd never met who knew my name, knew the hearing date, knew everything. I'm testifying through a screen because I can't sit in that courtroom. Okafor looked at Yamada. No further questions. The courtroom was quiet, except for the low hum of the monitor. Fraser's face filled the screen, his hands still flat on the table. He looked at the camera, and the camera looked back. Yamada wrote on her legal pad. The clerk disconnected the feed. The monitor returned to the court's seal. Fraser was gone. Not from the case, from the room. He had never been in it. Salazar sat in the second row and watched the empty screen. Strand's cross had done what it was designed to do. She had not called Fraser a liar. She had not attacked his memory. She had placed the circumstances around his testimony and asked the court to look at those circumstances instead of the testimony itself. No police report, no contemporaneous report to anyone. A statement given to a witness, not a prosecutor. Remote testimony from an undisclosed location. A man who had been hiding for 10 years presented through a screen that flattened his fear into pixels and compressed his voice into data that arrived half a second late. Medina had survived. Her precision, her contemporaneous report, Ronaldo's log entry. Strand had landed the Whitfield framework, but Medina had countered with what she was. A professional listener who reported within the hour. The duty log was the anchor. Fraser was different. On the screen, he had looked like a man who had been running for 10 years and was tired of it. In person, in Ridgecrest, Salazar had seen the fear up close, the way his hands shook when he talked about the night Cortez came to his door, the way he checked the windows. Through the monitor, none of that translated. The technology that protected him also diminished him. He was not in the room. He was not facing Strand. He was not real to the panel in the same way that Wyatt had been real when she sat in that chair and said, "Don't tell me I'm confused." The system did not reward what Fraser had done. He had come forward. He had given a statement. He had agreed to testify. And the format of his testimony, the remote video that he needed because he was afraid, was the thing that made him look least credible. Yamada looked at the clock. 10:51. "Mr. Okafor, we'll take our morning recess. Reconvene at 11:15. The gallery stirred. Salazar stood. Behind her, Medina stood too. They did not speak. Salazar walked through the gallery doors into the hallway. Okafor was already at the window, his back to the corridor, one hand on his forehead. She stopped beside him. "How bad?" Medina held, "She's clean." He dropped his hand. "Fraser is the problem. Strand didn't have to destroy him, the screen did it for her." Down the hall, the elevator opened. Strand walked out with a young associate carrying a file box. They turned toward the courtroom. Strand's briefcase hung at her side. She did not look at Salazar or Okafor as she passed. Okafor looked at his watch. "Hadley's tomorrow. Okoro confirmed he'll appear in person. Strand will have all night to prepare the cross." "What does she have on him?" "Everything. The cooperation deal. The sentencing consideration. 10 years of lies before he flipped. She'll take him apart." "Can he hold?" Okafor looked down the hallway where Strand had disappeared. Wyatt held because she's unbreakable. Medina held because she's precise. Fraser held because he was telling the truth and it didn't matter. He pushed off the wall. Hadley is a cooperator who cut a deal. Strand doesn't need Whitfield for him. She just needs the deal memo. Salazar turned from the window and walked toward the courtroom doors. Inside, Medina sat in the third row where she had been all morning, her hands in her lap, her cardigan buttoned to the neck. She looked at the empty witness chair the way a woman looks at a room she has waited 10 years to enter and is not sure she will ever enter again. Okafor came through the doors behind Salazar and opened a folder at the prosecution table. Tomorrow's witness prep. Hadley's proffer. The cooperation agreement with every line a weapon pointed in both directions. Salazar sat down. The courtroom clock read 11:08. 7 minutes until Yamada returned. The morning's testimony settling into the record, layered and compressed, waiting for the ruling that would determine whether any of it. Chapter 29. Day 4. Thursday, April 17th. Department 127. 9:07 in the morning. Carl Hadley walked through the courtroom doors in a navy suit and white shirt buttoned to the collar. No tie. His hair was shorter than the photographs from his arrest, cut close on the sides, combed back on top. He was 53 and looked 60. He moved through the gate and took the witness chair the way a man takes a seat in a restaurant he has been to before. He knew where the microphone was. He adjusted it without being asked. The clerk swore him in. Hadley raised his right hand and said, "I do," the way people say it when they have said it in rooms like this more than once. Salazar sat in the second row behind the prosecution table. Medina was beside her, hands folded in her lap, cardigan buttoned. The gallery was fuller than the previous 3 days. 2 reporters from the Times had come back. A sketch artist worked in the third row on the defense side. In the front row behind Strand, a man in a charcoal suit sat with a legal pad on his knee. Lusk's corporate counsel, watching the investment. Hadley settled his hands on the armrests. Okafor stood. Mr. Hadley, you served as the jury foreman in the trial of Marcus Cole in October and November 2016. Is that correct? That's correct. Prior to serving on that jury, did you have a relationship with Warren Lusk? I did not. When did you first meet Mr. Lusk? Approximately 3 weeks before jury selection, late September 2016. Describe the circumstances. Hadley looked at Okafor. His hands stayed on the armrests. His voice was even and practiced, the cadence of a man who had given this account in a proffer session, then in a deposition, then in front of the mirror. I was contacted by an associate at Brannock Hale. They said a client was interested in a commercial real estate opportunity. I had a company called Hadley Commercial Partners. I took meetings. What happened at the meeting? The associate introduced me to Mr. Lusk at the firm's offices downtown. Lusk said he had a ground-floor retail space at one of his properties that he was having difficulty leasing. He asked if I was interested. What property? Lusk Tower, South Grand Avenue. What was the value of the lease? Approximately 4,000 square feet on the ground floor. Asking rate was $100 per square foot, roughly $400,000 a year. Did Mr. Lusk offer you this space? 5-year lease at a significant discount. He didn't specify the discount at that meeting. What happened next? 3 days later, the associate called again. He said the commercial opportunity was connected to a civic matter. He used that phrase, civic matter. He said Mr. Lusk had a situation involving a trial and needed someone on the jury who would understand the bigger picture. Okafor paused. Mr. Hadley, did the associate explain what understand the bigger picture meant? Not at that meeting. But over the next 2 weeks, across 3 more conversations, it became clear. Lusk needed a guilty verdict. Why did he need a guilty verdict? I didn't know at the time. I learned later that the defendant was connected to a property dispute affecting one of Lusk's development projects. A conviction removed a problem. How were you placed on the jury? The associate gave me a preparation document, background on the case, the questions attorneys would ask during voir dire, suggested answers that would make me seem neutral. And you followed this preparation. Yes. Once you were seated as foreman, what did Mr. Lusk ask you to do? Hadley shifted in the chair. Not discomfort. Repositioning. He told me to manage the vote, make sure it went guilty. He said if there were holdouts, I should apply pressure. His exact words were, people who resist usually just need to understand the consequences of dragging things out. Did he provide specific language for you to use? He did. He told me to say, people who make this difficult have difficult lives afterward. He said that phrase had worked before. Salazar watched Hadley's face. The words came out clean and ordered. No hesitation, no searching. Each repetition across cooperation session, deposition, and now the stand had polished them smoother, the edges worn down to a flat professional surface. Did you use that language with any juror? Yes, with Robert Fraser, juror number 6. How many times? twice, once during the morning break on October 28th, once on October 30th. What was Mr. Fraser's reaction? The first time, he told me not to discuss the case. The second time, he didn't say anything. He went back into the jury room. During the trial, were you in communication with Mr. Lusk? Yes. How? Phone calls. Usually during recesses, sometimes during the lunch break. I would go to the corridor on the 9th floor near the elevators. I called a number the Brannock Hale associate had given me. How many calls? I don't know exactly. 8 or 10 over the course of the trial. Some were 30 seconds. Some were several minutes. What did you discuss? How the trial was going. What the evidence looked like. What the jury's mood was. Whether there would be problems with the vote. On November 2nd, the second day of deliberations, you spoke with someone outside the jury room. The interpreter waiting area was on the other side of the wall. Do you recall that conversation? I was on the phone with the associate. I had stepped into the hallway. I told him the vote was moving. 2 holdouts, one of them close. I said it would be done by tomorrow. Was that accurate? The vote came back the next day, guilty. Mr. Hadley, after the trial, what was your compensation? The lease at Lusk Tower was finalized in January 2017. 5-year term. $60 per square foot instead of $100. A discount of roughly $160,000 per year. $800,000 over 5 years. Okafor stood at the podium without notes. When did you first cooperate with authorities? January of this year, after Detective Salazar's investigation reopened the case. What were you facing at the time? Conspiracy to obstruct justice. My attorney, Ms. Okoro, negotiated a cooperation agreement. What did the agreement provide? In exchange for a full and truthful proffer, the district attorney's office agreed to recommend a reduced sentence, 4 to 8 years instead of the statutory maximum. What was the statutory maximum? 15 years. Were any other charges discussed during negotiations? Hadley paused, the first real pause. There was discussion of a conspiracy charge related to the deaths of Patricia Whitmore and Victor Reyes. Both were jurors. Both died. The prosecution indicated those charges could be filed based on evidence connecting calls I made to Mr. Lusk to the timeline of those events. Were those charges filed? No. They were dropped as part of the cooperation agreement. Okafor looked at Yamada. No further questions, Your Honor. Yamada wrote. The courtroom was quiet. The sketch artist's pencil moved. Hadley sat in the chair with his hands on the armrests. Ms. Strand. Strand stood. She picked up a folder from the defense table. A single folder, not thick. She walked to the podium and set it down. She did not open it. Good morning, Mr. Hadley. Good morning. You are here today pursuant to a cooperation agreement with the Los Angeles County District Attorney's Office, is that correct? Yes. And under that agreement you have provided testimony to the grand jury, in depositions, and now in this court. Yes. I'd like to discuss that agreement. She opened the folder, a single document, stapled, maybe 6 pages. This is People's Exhibit 22. Your cooperation agreement dated January 14th of this year. You've seen this document before. I have. Page 1, paragraph 3. The agreement states that in exchange for your full and truthful cooperation, the people agree to dismiss the charge of conspiracy to commit murder in the first degree. Is that correct? Yes. Conspiracy to commit murder carries a sentence of 25 years to life in California. Is that your understanding? That's what my attorney told me. So, when you walked into the district attorney's office to give your proffer, you were facing a potential sentence of 25 years to life. I was facing the obstruction charge. The murder conspiracy was under discussion. Under discussion. Strand looked at the document. Mr. Hadley, the agreement states, page 2, paragraph 5, that the people represented to defense counsel that they possessed sufficient evidence to file a charge of conspiracy to commit murder based on, and I'm reading, phone records establishing communication between the cooperator and Warren Lusk within 48 hours of the deaths of Patricia Whitmore and Victor Reyes, and evidence that the cooperator had knowledge of threats directed at both decedents. She looked up. You were not merely facing obstruction charges. You were facing a murder conspiracy charge that carried 25 to life. Hadley's hands stayed on the armrests. The charge was discussed. It was never filed. It was never filed because you agreed to cooperate. Page 3, paragraph 8. In consideration of the cooperator's proffer, the people agree to the following. 1. Dismissal of any potential charge of conspiracy to commit murder in the first degree. 2. A sentencing recommendation of 4 to 8 years on the obstruction count, reduced from the 15-year statutory maximum. 3. Placement in protective custody during incarceration. 4. Relocation assistance upon completion of sentence. She set the page down. Mr. Hadley, I want to make sure the court understands the arithmetic. Before the cooperation agreement, you were facing a potential sentence of 25 years to life plus up to 15 years on the obstruction charge. After the agreement, you are facing 4 to 8 years, protective custody, and relocation assistance. The agreement reflects the value of my cooperation. The value of your cooperation. Strand picked up the document again. Let's talk about that value. Page 4, paragraph 12. The agreement contains a truthfulness provision. It states that if the people determine at any point that the cooperator has been untruthful, the agreement is void and all charges, including conspiracy to commit murder, may be refiled. Correct? Correct. So, your continued freedom from a life sentence depends on the prosecution believing that your testimony is truthful. My testimony is truthful. That wasn't my question. Strand set the document down. My question is whether your freedom from a murder conspiracy charge depends on the prosecution continuing to credit your account. Hadley looked at her. The agreement says what it says. It does. It says that if you stop being useful, you go back to facing life in prison. She closed the folder. Mr. Hadley, when did you first become aware that the prosecution was investigating a connection between your phone calls and the deaths of Patricia Whitmore and Victor Reyes? My attorney informed me in early January. Before or after you agreed to cooperate? Before. That's why I cooperated. Because you were afraid of being charged with murder conspiracy. Because I wanted to tell the truth about what Lusk had done. You wanted to tell the truth after 10 years of not telling the truth. Yes. Mr. Hadley, for 10 years, from November 2016 until January 2026, you said nothing about Warren Lusk. You said nothing about the jury manipulation. You said nothing about the threats to Robert Fraser. You occupied a commercial space in Lusk Tower at a discounted rate and operated your business and paid your reduced rent for 10 years. That's correct. Did your conscience trouble you during those 10 years? It did. Did it trouble you enough to contact the district attorney? No. Did it trouble you enough to contact the police? No. Did it trouble you enough to contact the defense attorney for Marcus Cole, who was sitting on death row? No. Your conscience troubled you for 10 years, but not enough to do anything about it until you were facing life in prison. Okafor stood. Objection. Argumentative. Yamada looked at Strand. Sustained. Move on, counsel. Strand did not pause. Mr. Hadley, you testified that Mr. Lusk told you to say, "People who make this difficult have difficult lives afterward." And you testified that Lusk said this phrase had worked before. Those are powerful words. They suggest a pattern. They suggest premeditation. They are exactly the kind of detail a prosecutor building a conspiracy case would want to hear. She stopped. When you gave your proffer, were you aware that the strength of your testimony would affect the terms of your cooperation agreement? I told the truth. You told the truth. And the truth happened to be worth the dismissal of a murder conspiracy charge, a reduced sentence, protective custody, and relocation assistance. I told what happened. What happened to you, Mr. Hadley, is that you were facing the rest of your life in prison, and then you told prosecutors exactly what they needed to hear, and then you weren't facing the rest of your life in prison anymore. The courtroom was still. Hadley looked at Strand. His hands had moved from the armrests to the rail. His fingers were curled around the wood. I told the truth. You told a version of events that was worth 30 years of your life. That's not truth, Mr. Hadley. That's currency. Okafor stood. Objection. Withdrawn. Strand turned a page in the folder. She let the silence hold for 3 seconds. 4. Mr. Hadley, you testified that you made 8 to 10 phone calls to a number provided by the Brannock Hale associate during the trial. Is that correct? Approximately. The phone records and evidence show 7 calls from your personal cell phone to the number associated with the Brannock Hale associate during the trial period, not 8 to 10. 7. I said approximately. You also testified that you called from the 9th floor corridor near the elevators. That's where I usually went. Cell tower records show that 3 of those 7 calls pinged a tower consistent with the building's lower floors, not the 9th floor. I don't remember the exact floor every time. You remember the exact words Warren Lusk told you to say 10 years ago. You remember, people who make this difficult have difficult lives afterward. You remember, had worked before. But you don't remember which floor you were standing on when you made the calls. The words were important. The floor wasn't. The words are also the reason you're not facing life in prison. Strand closed the folder. Mr. Hadley, I have one more question. You testified that you cooperated because you wanted to tell the truth, not because you were afraid of a murder conspiracy charge. Is that your testimony? Yes. If the murder conspiracy charge had not been discussed, if the district attorney had come to you with only the obstruction charge, carrying a maximum of 15 years, would you have cooperated? Hadley was quiet. I don't know. You don't know? Strand nodded. She picked up the folder. No further questions. Yamada looked at Okafor. Redirect? Okafor stood. He walked to the podium and placed both hands on the edge. Mr. Hadley, Ms. Strand has spent considerable time on the benefits of your cooperation agreement. I want to ask about the content of your cooperation, the specific words you attributed to Mr. Lusk. People who make this difficult have difficult lives afterward. Where did you first provide those words? In my proffer session. And Robert Fraser, when he testified yesterday, what words did he say Mr. Hadley used to threaten him? I don't know what he said. I wasn't in the courtroom. The record will reflect that Mr. Fraser testified, quote, he said, people who make this difficult have difficult lives afterward, end quote. Okafor paused. Those are the same words. Strand stood. Objection. Counsel is testifying. Overruled. The record speaks for itself. Okafor continued. Mr. Hadley, did you and Mr. Fraser coordinate your testimony? No. Have you spoken with Mr. Fraser at any time in the last 10 years? No. Have you had any communication with Mr. Fraser directly or through any intermediary? No. Two witnesses who have not spoken in 10 years gave the same specific phrase, word for word, under oath, in separate proceedings. Mr. Hadley, is the reason they match because the words are true? Yes. No further questions. Yamada wrote on her legal pad. The clock on the wall read 10:29. We'll take our morning recess, reconvene at 11. The gallery stood. Salazar did not move immediately. She sat in the second row and looked at the witness chair where Hadley had been sitting. He had already stepped down and walked through the gate. His attorney Okoro met him in the aisle, and they went through the doors together. Strand had done it. Not Hadley lied. Something worse. Hadley had every reason to say exactly what he said regardless of whether it was true. The murder conspiracy charge. The sentencing gap. The relocation assistance. Each benefit was a brick in the wall she had built between his testimony and the court's ability to credit it. She had read from the deal memo line by line. She had not raised her voice. She had not called him a liar. She had made the truth and the lie look identical. The word match on redirect was strong. Okafor had landed it cleanly. Two people who had not spoken in a decade giving the same 9-word phrase. That was not something a cooperation deal could manufacture. But Strand's answer was already forming. Salazar could see it. Fraser gave his statement to Salazar and Okafor in January. Hadley gave his proffer in January. Both statements were in the case file. Both were available to both witnesses' attorneys. The word match could mean the truth. It could also mean both men had access to the same document. Medina touched Salazar's arm. Are you all right? I'm thinking. About what she did to him. About whether it matters. Medina looked at the empty witness chair. I listened to him. His voice was steady the whole time. The same pace, the same volume. He sounded like he'd said those words 100 times. He has. That's what concerns me. Salazar stood. The gallery had mostly emptied into the hallway. She walked to the doors and pushed through. Okafor was at the window again. The same window, the same posture from yesterday. One hand on his forehead, his tie loose at the collar. She stopped beside him. The word match. I know. He dropped his hand. It's the strongest thing I have. Two people, same phrase, no contact. Strand will argue they both had access to the filings. Fraser's attorney received a summary of the proffer, not the full document. The summary doesn't contain the verbatim quote. Can you prove that? I can represent it to the court. Whether Yamada credits it is another question. Down the hallway, Strand's associate came out of the courtroom carrying the file box. He walked to the elevator and pressed the button. Strand was not with him. Closings tomorrow, Okafor said. What's your lead argument? Corroboration across independent sources. Medina's report matches Ronaldo's log. Fraser's account matches Hadley's proffer. Wyatt's complaint matches the timeline. 4 witnesses who didn't coordinate and couldn't have manufactured the same details. Strand can attack each witness individually. She can't explain why all 4 tell the same story. She'll try. She'll try. He looked at the courtroom doors. Her argument is that cooperators say what prosecutors want to hear, that memory is unreliable, that the system that produced this evidence is the same system that produced the conviction. She's not wrong about any of it. But the evidence is real. The evidence is real, and the evidence was gathered by people with a stake in the outcome. Both things are true. Yamada has to decide which truth controls. Salazar looked through the window at the parking structure across Temple Street. A woman in a dark suit walked between rows of cars on the second level. From this distance, it could have been anyone. It could have been Strand. Okafor pushed off the wall. I need to prep closings. Strand will go first. Defense moves. She'll have 45 minutes to tell Yamada that everything she heard this week was manufactured by a broken system. I get 45 minutes to tell her it wasn't. He walked toward the courtroom. Salazar stayed at the window. Strand had not caught Hadley in a lie. She had not produced contradictory evidence. She had taken the cooperation system itself and turned it into reasonable doubt. Every benefit became a motive to fabricate. Every dropped charge became a reason to tell prosecutors what they wanted. The truthfulness provision became, in her hands, the mechanism of coercion. Tell us what we need or go to prison for life. Cooperation testimony was inherently transactional. A man trades information for freedom. The information might be true. It might be shaped. It might be invented. The transaction itself made it impossible to know which. Strand had not needed to prove Hadley lied. She had only needed to prove that the system gave him every reason to. Medina had survived because she had nothing to trade. No deal, no benefit, no charges pending. She reported what she heard and walked away for 10 years. Wyatt had survived because she was unbreakable and her complaint was filed in 2016. Fraser had survived, barely, because the fear was real even through the screen. Hadley was different. Hadley was exactly what Strand needed him to be. A cooperator, a man with a deal, a man who had been silent for 10 years and found his voice the same week he learned he was facing life. The morning recess crowd filled the hallway. Attorneys from other departments, clerks carrying files, a bailiff walking toward the elevators. Salazar stood at the window. The word match. 9 words. The same 9 words from 2 men who had not spoken since 2016. She had been in the room when Fraser said them. She had watched his hands shake. She had seen the way his eyes went to the window of the house in Ridgecrest every time he heard a car on the road. Strand could argue access to filings. She could argue contamination. She could argue that 9 words was a short phrase and coincidence was possible. She could not argue that Fraser was shaking because of a document. But Yamada had not been in Ridgecrest. Yamada had seen Fraser through a screen, washed out by desert light. And Yamada had seen Hadley in person, steady, practiced. 2 witnesses, 1 on a screen, 1 in the chair. 1 looked afraid, 1 looked rehearsed. Strand needed the court to believe that rehearsed meant manufactured. Okafor needed the court to believe that rehearsed meant consistent. The elevator opened. Strand walked out alone, carrying nothing. She turned toward the courtroom. As she passed Salazar, she glanced to the side. Their eyes met for less than a second. Strand did not nod or speak. She walked through the courtroom doors, and they closed behind her. Salazar turned back to the window. Inside the courtroom, Okafor was preparing the argument that 4 independent witnesses corroborated a pattern of jury tampering. Inside the courtroom, Strand was preparing the argument that the system had produced the testimony and the system could not be trusted to evaluate its own output. Tomorrow morning, one of them would go first. Salazar pushed off the window and walked toward the Chapter 30, Day 5. Friday, April 18th. Department 127. 8:51 in the morning. The courtroom was full. Both sides of the gallery packed tight, coats folded on laps. The Times reporters were in the front row behind the bar. The sketch artist had moved to the prosecution side. 3 law students from Loyola sat in the back with notebooks open. A woman Salazar did not recognize sat alone in the last row on the defense side. Dark hair pulled back. No notebook, no phone. Watching. Medina sat beside Salazar in the second row. She wore the same cardigan from Monday. Her hands were in her lap. She had not spoken since they walked in from the hallway. Yamada entered through the chamber door at 8:55. The bailiff called the room to order. Everyone stood. Yamada sat. Everyone sat. This is the continued matter of In re Marcus Cole, case number BA 416892. We are here for closing arguments. Yamada looked at the defense table. Ms. Strand, as the moving party, you may proceed. Strand stood. She buttoned the middle button of her jacket. She walked to the podium carrying a single legal pad. She set it down and looked at Yamada. Your Honor, on the first day of testimony, Mr. Okafor told you he would present a chain of evidence, link by link, independent, verified. I want to address the chain. She paused. Every link in that chain was forged in the same furnace. Strand turned the page on her legal pad. She did not look at it. A habeas investigation run by one detective who chose her conclusion before she had evidence. Detective Elena Salazar. Every witness this court heard this week was found by Detective Salazar, contacted by Detective Salazar, interviewed by Detective Salazar, or delivered to Mr. Okafor's office by Detective Salazar. Salazar sat still. She kept her hands on her knees. Let me trace the investigation as it actually occurred. On the third day of her homicide investigation into the death of Patricia Whitmore, Detective Salazar contacted Thomas Okafor, not the district attorney's office, not her supervising lieutenant, the capital defense attorney who had been trying for 10 years to overturn Marcus Cole's conviction. Strand looked at her pad. She did not call Mr. Okafor because she had evidence of jury tampering. She called because the murder victim was a juror in a capital case. That is an investigative lead. It is not a conclusion. But from that point forward, every decision Detective Salazar made was consistent with one theory, that Marcus Cole was innocent, that the jury was tampered with, that Warren Lusk was responsible. She set her hand flat on the podium. The chain has 5 links. I will address each one. She held up one finger. Link 1. Lucia Medina, a court interpreter who testified that she overheard a conversation through a wall 10 years ago. She was not a juror. She had no deal. She reported what she heard to a bailiff in 2016. All of this is true. Strand lowered her hand. It is also true that Ms. Medina's account was not discovered through routine investigation. It was discovered because Detective Salazar drove to Moreno Valley to interview retired bailiff Ronaldo. Mr. Ronaldo had never been contacted by any investigating agency in 10 years. Detective Salazar found him because Mr. Okafor identified his name in duty logs obtained through a habeas subpoena. The investigation and the habeas case were the same operation by that point. She turned the pad to a new page. Ms. Medina heard partial phrases through a plaster wall. She reported to the bailiff within 45 minutes. This is credible behavior, but the question is not whether Ms. Medina is credible. It is whether her account, reconstructed after 10 years, is reliable. Strand stopped. She looked at Yamada directly. Dr. Whitfield's testimony on memory degradation applies here. Miss Medina's account involves overheard speech, not a conversation she participated in, not words directed at her, words filtered through a wall, partially heard, reported immediately, and then not discussed again for a decade. Dr. Whitfield's research, which is cited in 3 Ninth Circuit opinions, establishes that overheard speech is the least reliable form of auditory memory. Confidence does not correlate with accuracy in overheard recall. Miss Medina is confident. That does not make her accurate. She paused again. 2 seconds. Link 2. Doreen Wyatt. Mrs. Wyatt is 81 years old. She passed a court-ordered cognitive evaluation. She is sharp, she is determined, and she testified to a conversation she observed in a courthouse parking lot 10 years ago between the jury foreman and an unidentified man. Strand set both hands on the podium. Mrs. Wyatt filed a complaint in 2016. That complaint exists. It was ignored. The question is what the complaint proves. Mrs. Wyatt saw 2 men talking. She identified one as the foreman. She did not hear the substance of their conversation. She observed body language. She drew inferences. Mrs. Wyatt also identified the second man as speaking in what she described as a deferential posture. She testified the conversation lasted approximately 2 minutes. None of this is disputed, but none of this constitutes evidence of jury tampering. 2 men spoke in a parking lot. Mrs. Wyatt noticed and reported it. What she reported was an observation, not a crime. Strand turned the page. Link 3, Robert Fraser. Mr. Fraser testified by video from a location outside this jurisdiction. He was visibly anxious. He described threats made by the jury foreman during trial. He used specific language. People who make this difficult have difficult lives afterward. She looked up. Mr. Fraser also disappeared from his home in Scottsdale, Arizona for approximately 6 weeks before this hearing. He was located by Detective Salazar at a property in Kern County. He testified that a man came to his apartment and told him it was not safe to remain. He left voluntarily. He was not restrained. Strand put down the pad. Your Honor, Mr. Fraser's disappearance is troubling, but the question for this court is not who relocated Mr. Fraser. It is whether Mr. Fraser's testimony about events in October 2016 is reliable. Mr. Fraser has lived for 10 years in fear. Fear of retaliation. Fear of being found. Fear of the consequences of his jury service. That fear is real, and this court should take it seriously. She paused. But fear affects memory. Fear reinforces the narrative that justifies the fear. Mr. Fraser has told himself for 10 years that he was threatened, that his verdict was coerced, that something terrible would happen if he spoke. Each retelling hardens the account. The foreman may have said exactly what Mr. Fraser remembers, or the foreman may have said something close, and 10 years of fear sharpened it into a threat. She picked up the pad again. Link 4. Carl Hadley, the cooperator, Mr. Okafor's most important witness, and the weakest link in the chain. Strand looked at Yamada. I addressed Mr. Hadley's testimony during cross-examination. The court has the record. Mr. Hadley was facing 25 years to life on a conspiracy to commit murder charge. He cooperated. He received dismissal of that charge, a reduced sentence, protective custody, and relocation assistance. In exchange, he provided testimony that is, I acknowledge, internally consistent and specific. She set the pad flat. But internal consistency is exactly what the prosecution purchased. Mr. Hadley had every incentive to provide a clear, detailed, consistent account. His freedom depended on it. The truthfulness provision gives the prosecution the power to void the deal if they determine he has been untruthful. Mr. Hadley cannot deviate from the account he has given, not because it is true, although it may be, because deviation means prison. She looked at the gallery for the first time since she had begun. Her eyes moved across the rows and back to Yamada. Link 5. The documentary evidence, phone records, financial records, Ms. Kowalski's identification, the Reyes letter. Mr. Okafor will tell you this evidence corroborates the testimony. Some of it does. Phone records show calls during the trial period. Financial records show the discounted lease. Ms. Kowalski, who declined to appear, told investigators she saw Mr. Hadley speaking with a man she identified from photographs as Warren Lusk. Strand closed the legal pad. But documentary evidence does not interpret itself. Phone calls between a commercial tenant and a developer are not inherently criminal. Discounted leases exist for reasons other than bribery. Ms. Kowalski made an identification from photographs shown to her by Detective Salazar, who had already concluded those men were conspiring. She stood at the podium without notes, without the pad, both hands resting on the wood. Your Honor, I want to return to where I began. The chain. Mr. Okafor will tell you this is not one witness telling one story. He will tell you it is 5 independent sources. He will tell you each link was independently verified. She shook her head once. They were not independent. Every link was discovered, developed, and delivered by the same investigation. Detective Salazar found Ronaldo. Ronaldo led to Medina. Detective Salazar found Fraser. Detective Salazar interviewed Kowalski. Detective Salazar worked with Mr. Okafor from the third day of the Whitmore homicide. Detective Marcos, her partner, bypassed departmental chain of command to bring evidence directly to her instead of routing it through channels. She stopped. This is not a chain of independent evidence. This is a single investigation with a predetermined conclusion. The links are not independent because the investigator is the same. The links are not verified because the verification was conducted by the same team that built the case. What Mr. Okafor calls a chain, I call institutional momentum. Every piece of evidence passed through one detective's hands. Every witness was contacted by one detective or her partner. Every document was obtained through subpoenas drafted by one attorney working with that detective. She picked up the legal pad and held it at her side. The chain is not evidence. It is institutional momentum. And institutional momentum is not proof beyond a reasonable doubt. It is not even proof by a preponderance. It is a narrative. And narratives are what investigations produce when the conclusion comes first. She looked at Yamada. Your Honor, the petition should be denied. Strand walked back to the defense table and sat down. She placed the legal pad precisely in front of her. She did not look at the gallery. The courtroom was quiet. The sketch artist's charcoal moved in short strokes. The woman in the last row on the defense side had not moved. Yamada looked at the prosecution table. Mr. Okafor. Okafor stood. He buttoned his jacket. He walked to the podium, carrying nothing. No pad, no folder, no exhibits. He put both hands on the wood and looked at Yamada. Your Honor, Ms. Strand just told you this case is about one detective. She's wrong. This case is about one man, Marcus Cole. He has been in prison for 10 years for a crime he did not commit, convicted by a jury that was manipulated by a man who paid the foreman $800,000 to deliver a guilty verdict. He paused. That is what the evidence shows. And I want to walk through it, not as a narrative, not as institutional momentum, as evidence. He took his hands off the podium. Lucia Medina, a court interpreter with no connection to the defense, no connection to the prosecution, no connection to Marcus Cole. She was assigned to the Cole trial through the normal interpreter pool rotation. On November 2, 2016, she overheard the jury foreman in the hallway outside the jury room say, "Votes moving, 2 holdouts. The woman won't budge, but the other one is close." She heard a second voice, then the foreman again. "By tomorrow." She reported this to Bailiff Ronaldo within 45 minutes. He logged it. The log exists. The clerk received it. Nothing happened. He held up one finger. Ms. Medina had no reason to fabricate this report. She was a contract interpreter. She had no stake in the verdict. She reported because she is an officer of the court, and she heard something wrong. She did not know it would matter. She did not know it would take 10 years. She left court interpreting 3 years later because she could not work in courtrooms while carrying the knowledge that her report had been ignored. She came to this courtroom this week and said the same words she said to Ronaldo in 2016. Okafor stepped back from the podium. Ms. Strand told you that overheard speech is unreliable. She cited Dr. Whitfield's research on routine overheard speech, casual conversation, background noise. Ms. Medina did not overhear a casual conversation. She overheard a jury foreman discussing the outcome of a capital murder trial during deliberations. Dr. Reeves testified that emotionally significant overheard speech is retained at 3 times the rate of neutral speech. Miss Medina is not just confident, The science says she is likely accurate. He returned to the podium. Doreen Wyatt, juror number 9, 81 years old. She passed a cognitive evaluation at the 95th percentile for her age group. She filed a complaint in 2016 documenting her observations of the foreman's behavior. That complaint was filed contemporaneously. It exists in the court record. It was ignored. He held up 2 fingers. Mrs. Wyatt observed the foreman speaking with an unidentified man in the courthouse parking lot during the trial. She described the interaction as deferential on the foreman's part. She reported it because it troubled her. Ms. Strand is correct that Mrs. Wyatt did not hear the words spoken. She is correct that the observation alone does not prove tampering. But Mrs. Wyatt's observation is consistent with every other piece of evidence in this case. The foreman was in contact with people outside the jury. Multiple witnesses saw it. Multiple witnesses reported it. The system failed to act. Okafor paused. He looked at his hands on the podium, then back at Yamada. Robert Frazier, juror number 6. He testified from Kern County by video because he is afraid to enter a courtroom in Los Angeles. He was threatened by the foreman during the trial. Twice. The words used were, "People who make this difficult have difficult lives afterward." Mr. Frazier reported those exact words. Carl Hadley, independently, in a separate proffer session, reported giving those exact words, the same 9-word phrase, word for word. He took one hand off the podium. Ms. Strand will argue that both men had access to filings. The record shows that Mr. Frazier's attorney received a summary of Hadley's proffer. That summary does not contain the verbatim quote. Mr. Frazier's statement to Detective Salazar was given in January, before he had access to any filing. The word match exists because the words are true. 2 men who have not spoken in 10 years gave the same phrase because one man said it and the other man heard it. He held up 3, then 4 fingers. Carl Hadley, the cooperator. Ms. Strand spent her entire cross-examination on his cooperation agreement. She showed you the charges he was facing. She showed you the benefits he received. She argued that his testimony was purchased. Okafor's voice stayed level. I won't pretend the agreement doesn't exist. Mr. Hadley received significant benefits. He avoided a murder conspiracy charge. He received a reduced sentence. These are facts. But cooperation agreements exist because people who commit crimes do not come forward voluntarily. We do not have the luxury of witnesses without self-interest. The question is not whether Mr. Hadley had incentive to cooperate. Of course he did. The question is whether his account is corroborated by independent evidence. He put both hands back on the podium. It is. Phone records match his account. Financial records confirm the lease terms. His description of the recruitment is consistent with corporate records from Brannock Hale. And his verbatim quote of the threat language matches Mr. Frazier's independent account. Mr. Hadley is a cooperator. He is also telling the truth. Both can be true. He counted on his fingers. The documentary evidence. Phone records showing 7 calls between Hadley and Brannock Hale during the trial. Financial records showing the lease at $60 per square foot instead of $100. $800,000 over 5 years. Sandra Kowalski's identification of Lusk speaking with Hadley in the courthouse corridor. And Victor Reyes' letter to Patricia Whitmore naming Hadley as the source of pressure. A letter written by a man who is now dead, before any investigation began. Okafor stepped to the side of the podium. Your Honor, Ms. Strand told you this chain was forged in a single furnace. She told you the links are not independent because one detective found them. He looked at Yamada. Detective Salazar did find them. One detective drove to Moreno Valley and found a retired bailiff who had been waiting for someone to ask. One detective drove to Boyle Heights and found an interpreter who had been carrying silence for 10 years. One detective flew to Arizona and found a man who left everything behind because he was afraid. That is not a flaw in the evidence. That is the evidence. The system failed to investigate for 10 years. One person investigated. He walked back behind the podium. This is not one witness telling one story. This is a chain. Medina heard the foreman. Wyatt saw the foreman. Frazier was threatened by the foreman. Hadley was the foreman and he confirmed all of it. Phone records confirm contact. Financial records confirm payment. Kowalski saw Hadley with Lusk. Reyes wrote a letter naming Hadley before anyone investigated. He held both hands flat on the wood. 5 independent sources. Not one detective's theory. 5 people in a set of documents that tell the same story from 5 different angles. Every link independent. Every link verified. Ms. Strand can attack each witness individually. She is good at it. She has done it skillfully this week. But she cannot explain why Medina's account matches Ronaldo's log. She cannot explain why Frazier's words match Hadley's words. She cannot explain why a dead man's letter names the same foreman that 3 living witnesses identified. He paused. The courtroom was still. The bailiff stood by the chamber door with his arms at his sides. The chain is not institutional momentum. The chain is evidence. And the evidence says that Marcus Cole's conviction was obtained through deliberate, coordinated jury tampering orchestrated by Warren Lusk and executed by Carl Hadley. Mr. Cole has been in prison for 10 years. He is asking this court to look at the evidence and order a new trial. The evidence supports that request. He looked at Yamada. Thank you, Your Honor. Okafor walked back to the prosecution table. He sat down. He put his hands flat on the table in front of him and looked at the bench. Yamada wrote on her legal pad. The pen moved for 10 seconds. 15. The courtroom waited. Someone in the back row shifted and the bench creaked. Yamada looked up. Thank you, counsel. The arguments have been thorough, and the court appreciates the professionalism of both parties throughout this proceeding. She set the pen down. The matter is taken under submission. The court will issue a written ruling. Parties will be notified. Okafor did not move. Strand did not move. The gallery was still. Is there any other business? No, Your Honor, Okafor said. No, Your Honor, Strand said. Court is adjourned. The bailiff called the room. Everyone stood. Yamada gathered her files and walked through the chamber door. It closed behind her. No timeline, no date. Under submission meant 14 days by statute, but Yamada had not said 14 days. She had said written ruling and parties notified and nothing else. The gallery began to empty. The law students closed their notebooks. The sketch artist packed charcoal sticks into a wooden case. The woman in the last row stood and walked out without looking at anyone. Medina was still beside Salazar. She had not stood when the bailiff called the room to order. She was sitting with her hands in her lap, looking at the bench where Yamada had been. How long? Medina said. Could be a week. Could be 2. She didn't say. No. Medina looked at her hands. I thought there would be something, a question, a sign, some indication of which way she was leaning. Yamada doesn't do that. No, I suppose she wouldn't. They sat in the second row while the gallery emptied around them. Okafor was at the prosecution table putting files into his briefcase, each folder aligned before it went in. Strand was already gone. Her associate had carried the file box out during the adjournment. The defense table was empty except for a pen someone had left beside the microphone. Salazar watched Okafor close the briefcase. 2 clasps. He straightened his tie. He picked up the briefcase and walked through the gate. He stopped beside Salazar's row. Both closings were strong, Salazar said. Hers was better. No. Her narrative is cleaner. 1 investigation, 1 detective. Institutional momentum. It gives Yamada permission to deny without calling anyone a liar. Your chain argument is real. It's real. Okafor shifted the briefcase to his other hand. Whether it's enough depends on how Yamada weighs corroboration against source contamination. If she decides the investigation was compromised, the corroboration doesn't matter. If she decides the corroboration is genuine, the investigation methods don't matter. Everything this week comes down to which frame she applies. He looked at the empty bench. I'll be in my office. 14 days. He paused. Probably. He walked to the doors and pushed through. The courtroom was nearly empty now. The clerk was organizing papers at the front desk. The court reporter was packing her stenotype machine into a black case. Medina stood. What do we do now? We wait. For how long? Until she decides. Medina buttoned her cardigan. She picked up her tote bag from the floor and put the strap over her shoulder. She looked at the witness chair. It was empty. The microphone pointed at nothing. I said what I heard. You did. And Fraser said what happened to him. And Mrs. Wyatt said what she saw, and Hadley said what he did. Yes. And now a judge is going to read a transcript and decide whether any of it mattered. Salazar stood. The clock on the wall read 9:47. 5 days of testimony. 4 witnesses. 2 closings. Under submission in 52 minutes. It mattered, Salazar said, whether she rules our way or not. They walked to the doors. Salazar pushed through into the hallway. The light was different out here. Fluorescent and flat. Attorneys from other departments moved past. A woman in a juror badge walked toward Department 104. The elevators opened and closed. Okafor was gone. Strand was gone. The hallway was just a hallway. Medina walked beside Salazar toward the elevators. Neither of them spoke. The hearing was over. The evidence was in the record. The witnesses had said what they came to say. Now the building would do what it did. Yamada would sit in her chambers and read the transcript and review the exhibits and write her opinion page by page, as many as it took. Salazar pressed the elevator button. The floor indicator showed the car on 7 dropping. The elevator arrived. The doors opened. Salazar and Medina stepped in. Salazar pressed L for the lobby. The doors began to close. Medina looked at her. Will you call me? When the ruling comes. I'll call you. The doors closed. The elevator dropped toward the Chapter 31. The Wait. Friday, May 2nd. 14 days since closing arguments. Salazar sat at her desk in the Hollywood Division bullpen and read the Gower stabbing file for the 4th time. Hector Solis, 28, one wound to the chest outside a bar on Gower south of Sunset. The 2 witnesses who saw a man in a red jacket running south had both recanted within a week. One moved to Bakersfield. The other stopped answering his phone. Marcos set a coffee on her desk. Break room, black. He sat down at his own desk and opened a property report. Anything new on Solis? Bar owner called, says he has a regular who was outside smoking that night. Didn't see the stabbing but saw someone get into a car on the south side of the street. Dark sedan, thinks it was a Honda. He have a name for the regular? First name only. Pete. Comes in Thursdays. Today is Friday. I know. So we go next Thursday. Unless you want to sit in a bar on Gower for 6 hours, waiting for a man named Pete. I've done worse. Marcos almost smiled. He turned back to his property report. Salazar closed the Solis file and put it on the stack. Underneath was a domestic from Cahuenga. Underneath that was a robbery report from a check-cashing place on Western. Hollywood Division work. The cases came in and she worked them, and none of them had anything to do with Judge Yamada's chambers, or the transcript sitting on her desk, or the 47 pages of closing argument she had listened to in Department 127 2 weeks ago. Her phone rang. She looked at the screen. Okafor. Any word? She said. No word. She leaned back in her chair. 14 days, Okafor said. I know. Statute gives her 14 days. She can take longer. Some judges take 6 weeks. Yamada won't take 6 weeks. You don't know that. She had her ruling half-written before closings. She was taking notes during testimony. She asked clarifying questions. She's not deliberating, she's drafting. Okafor was quiet for a moment. I've been telling myself the same thing. Then believe it. I haven't slept more than 3 hours in 9 days. Salazar looked at the clock on the wall. 2:17. When did you last eat? I had a granola bar. That's not food. It had almonds. Go home, Thomas. Eat something that didn't come out of a wrapper. Take a pill if you have to. Sleep. I can't sleep. You can't function without sleep either. He was quiet again. She heard papers moving on his desk. I keep reading the transcript, both closings, looking for the weakness, looking for the line where Yamada makes the turn, one way or the other. You've read it before. 11 times. Reading it the 12th time won't change the words. No, more papers. Strand's closing was good. You told me that in the hallway. It was better than good. It was elegant, single investigator contamination, institutional momentum. She gave Yamada a clean framework to deny without calling anyone a liar. Your chain argument was stronger. Was it? 5 independent sources. Verbatim word match between Fraser and Hadley. Rhea's letter predating the investigation. Medina's contemporaneous report. Yes, it was stronger. Strength doesn't always win. Salazar pulled her notebook from the desk drawer, the page with the 2 columns. Left column, facts, right column, damage. Both full. Call me when you hear something. You'll be the first. He hung up. Salazar put the phone on the desk and stared at the Solis file. She opened it again, read the recanting witness statements again, closed it. Her desk phone rang. Outside line. She picked it up. Detective Salazar. This is Denise Washington. I'm Marcus Cole's sister. Salazar sat up straight. Yes, Ms. Washington. I'm sorry to bother you. Mr. Okafor gave me your number. He said you were the detective on the case. I was the detective on the Whitmore homicide. I'm a witness in the habeas proceeding. He said you would know about the ruling, whether there was any word. There isn't, not yet. The line was quiet, then, how long does it usually take? The judge has 14 days by statute, sometimes longer. It's been 14 days. I know. Marcus calls me on Tuesdays. We have 15 minutes. He doesn't ask me about the ruling. He asks about my kids. He asks about my job. He talks about a book he's reading. He never mentions the hearing. Salazar waited. I know what that means. He won't let himself ask because he can't survive the answer if it's wrong. Miss Washington, I can't predict the ruling. I'm not asking you to predict it. I'm asking you to tell me the truth. Did the hearing go well? Salazar looked across the bullpen. Marcos was on the phone, turned towards the wall, writing something on a notepad. 2 other detectives were at the far end, heads down. The evidence was strong, the witnesses held up. The defense attorney was very good. Both sides made their arguments. The judge took it under submission without comment. What does that mean? Under submission. It means she's writing her opinion. Is that good or bad? It's neither. It's procedure. Denise Washington was quiet for 5 seconds. Detective, my brother was 22 years old when they convicted him. I was 19. I've been visiting prison since I was a teenager. San Quentin for 8 years. Vacaville for 2. I've driven that road so many times I could do it in my sleep. I understand. Do you? Yes. Another pause. Will you call me when you hear? I'll call you. Mr. Okafor said the same thing. I'm collecting promises. I keep mine. Denise Washington gave her a cell number. Salazar wrote it in the margin of the Solis file. They hung up. Marcos turned from the wall. Who was that? Cole's sister. He looked at her for a moment. Then he turned back to his notes. The afternoon went. Salazar made 3 calls on the check-cashing robbery. The owner had security footage from a camera he'd forgotten to mention. She scheduled a pickup for Monday. She wrote a supplemental on the Cahuenga domestic. She ate a sandwich from the vending machine in the break room and drank 2 cups of coffee. At 4:15, Marcos stood and put on his jacket. Professional standards cleared me, he said. Salazar looked up. When? Letter came yesterday. No finding of misconduct. No discipline. Investigation closed. That's good. The file exists. It'll exist forever. Anyone who pulls my jacket sees an IA investigation. Anyone who pulls your jacket also sees it was closed with no finding. That's not how people read it. That's exactly how I'd read it. Marcos buttoned his jacket. The questions were about the boot print, how I obtained it, who I gave it to, whether I had authorization to share forensic evidence with an officer on a related case. What did you tell them? The truth, that I handed you the evidence because you were the detective on the homicide and the boot print was relevant to your case. Which it was. Which it was. He picked up his keys. They also asked about contacts with outside counsel. Okafor. They didn't name him. I didn't volunteer it. Smart. I answered every question truthfully. I just didn't answer questions they didn't ask. Salazar nodded. Marcos walked to the door, then stopped. Whoever filed the complaint knew exactly which procedures to cite. Chain of custody, unauthorized disclosure, interagency protocol. That's not a civilian complaint. No. Strands people. Probably. It didn't work. It was never meant to work. It was meant to slow you down, create a file, give you something to think about during the hearing. Marcos looked at her. Didn't slow me down. I know. He left. The bullpen was quiet. Salazar sat at her desk and pulled up the property search database on her computer. She had been running a search for 3 days. Not on the Solis case. Not on any case assigned to her. This was the thread she couldn't release. Eric Cortez. Ridgepoint Security Consulting. The man who relocated Fraser to the property outside Ridgecrest. Former Army MP, former Citadel EP contractor, Nevada LLC, fleet vehicles through Trident Mobility. Professional. Clean on paper. But Cortez didn't find Fraser himself. Someone referred him. Someone knew Fraser was a witness. Someone knew the hearing was coming. Someone paid through a trust account and attorney-client privilege insulated the chain. Garrett and Rowe, the Bakersfield law firm that established the Desert Vista Holdings Trust for the Ridgecrest property. Small general practice. 3 attorneys, tax work, estate planning, real property. Salazar had pulled their California State Bar records on Monday. William Garrett admitted 1994. Karen Rowe admitted 2001. Associate named Philip Eng admitted 2018. No disciplinary actions. No public complaints. She'd pulled their court filings through the Kern County Superior Court database. Routine. Probate matters. Trust administration. Commercial leases. Nothing connected to criminal defense. Nothing connected to Lusk or Brannock Hale or Century City. But the trust, Desert Vista Holdings, established September 2023, 6 months before the habeas hearing was even scheduled. Whoever set up the property did it as infrastructure, not for Fraser specifically, for whoever might need to disappear. Salazar typed the trust name into the Secretary of State Commercial Filings database. Desert Vista Holdings Trust. Garrett and Rowe as registered agent. She'd seen this before. She went back to the search she'd run on Tuesday. Trident Mobility Group, the fleet management company that owned the White Ram 1500, managed by Dale Hargrove, Henderson, Nevada. She'd cross-referenced Trident's client list against security firms with California foreign entity filings. That search had produced Ridgepoint Security Consulting, Cortez's company. Now she ran a different search. Garrett and Rowe as registered agent for any entity, not just Desert Vista. 4 results. Desert Vista Holdings Trust, established September 2023. Ridgecrest Property. Copper Basin, LLC, established March 2021. No property records in Kern County. Sierra View Partners Trust, established June 2020. Property in Tehachapi, single-family residence on 8 acres. Antelope Ridge Holdings Trust, established January 2019. Property in California City, 12 acres, unimproved. 4 trusts, 4 properties, all rural, all isolated, all held by the same small Bakersfield law firm. Salazar pulled up the Kern County Assessor for Sierra View Partners. The Tehachapi property. Single-family home, constructed 2004, 3 bedrooms, well water, propane, 8.2 acres. Last transfer, June 20, from a private seller to Sierra View Partners Trust. Purchase price, $287,000. She ran the California City property through San Bernardino County Assessor. Antelope Ridge Holdings, 12 acres of unimproved desert northeast of town. Purchased January 2019 for $43,000 from a bank foreclosure. She opened her notebook, drew the map. 4 properties, 1 law firm, all within a 2-hour drive of each other in the high desert corridor between Bakersfield and Ridgecrest. Rural, private, hard to find if you didn't know where to look. Places where a person could stay for weeks without anyone knowing. Her phone buzzed. Text from Medina. Started the recertification paperwork today. Medical interpreter to court interpreter, if they'll have me back. Salazar typed, "They'd be lucky to have you." We'll see. How is the waiting? It's waiting. I'm keeping busy. Sophia has a science fair next Thursday. I'm helping her build a model of the water cycle. Good. Call me when you hear something. I will. Salazar put the phone down and went back to the screen. 4 trust properties. But Cortez's relocation of Frazier used Trident mobility vehicles and Trident-managed fleets for security firms. The corporate chain went Garrett and Rowe set up the properties. Trident provided the vehicles. Ridgepoint provided the personnel. 3 separate companies. 3 separate services. 1 operation. She ran one more search. Garrett and Rowe client list, to the extent it was visible through public filings. Trusts required registration. Trust amendments were filed publicly. Beneficiaries were not, but the trustee was. All 4 trusts named the same trustee, Western Pacific Administrative Services, the same registered agent Marcos had found during the Kingman investigation. Registered agent for 412 companies. Salazar pulled up the Western Pacific filing she'd bookmarked 2 weeks ago. 412 active entities. She'd already flagged the 6 security-related firms organized between 2015 and 2022, 2 in LAPD intelligence databases. Now she filtered differently, not by company type, by registered agent activity. Western Pacific entities that also used Garrett and Rowe as counsel. 7 matches. 4 were the trusts she'd already found. The other 3 were LLCs. Salazar wrote down the names, cross-referenced them against court filings. 2 were inactive, dissolved in 2021 and 2022. The third was active. Ridgeline Consulting Group, LLC. Organized 2018. Active. Managing member, Dale Hargrove. Henderson, Nevada. The same Dale Hargrove who managed Trident Mobility, the fleet company. She sat back. The map in her notebook had 5 nodes now. Garrett and Rowe at the center. Trusts branching to properties. LLCs branching to fleet management and security. Hargrove connecting 2 of the nodes. Cortez connecting 2 others. This was not a one-time arrangement. Someone had built infrastructure. Properties in the high desert. Fleet vehicles to move people. Security contractors to handle the logistics. A law firm to establish the trusts and insulate the chain through attorney-client privilege. A registered agent to obscure the ownership. 6 witness relocations in 5 years. She could see the shape of it now. Different cases, different defendants, same infrastructure. A private company that made witnesses disappear from proceedings involving people with resources. Not through violence. Through comfort and fear. You're in danger. We can protect you. Come with us. Fraser hadn't been kidnapped. He'd been serviced. Salazar stared at the screen. The bullpen was empty. The overhead fluorescents buzzed. Outside the window, the Hollywood Division parking lot was half full, the last of the day shift cars pulling out. This should have been a discovery, a breakthrough, a finding that should have opened the case wide, but it didn't open anything. It closed nothing. It proved that the system Fraser was caught in was not improvised. It was a business. Garrett and Rowe didn't know who the clients were. Cortez didn't know who hired him. Hargrove managed the vehicles and the money flowed through trust accounts. Everyone was insulated. Everyone was clean. And it was bigger than Lusk, bigger than Fraser, bigger than the Cole case. 6 relocations in 5 years meant 6 witnesses who didn't testify. 6 cases where someone with money bought silence through logistics instead of threats. She closed the notebook. She was a detective in the Hollywood Division of the Los Angeles Police Department. She had no jurisdiction over trust fraud in Kern County. She had no case number. She had no authority to investigate a private relocation service that, on paper, had committed no crime. Moving a willing person to a rural property was not illegal. Establishing a trust was not illegal. Managing a fleet was not illegal. The machine worked because every piece of it was legal. Her desk phone rang. She looked at the caller ID. Unknown number, 2113 area code, downtown Los Angeles. She picked up. Detective Salazar, this is Thomas Okafor. He never identified himself by full name. He'd called her 40 times in the past 6 months and always opened with, "It's Okafor," or Thomas. Full name meant formal. Full name meant something had changed. "Yamada's clerk just called," he said. His voice was steady in a way that was not natural, controlled. "The ruling is being released Monday morning, 9 a.m. Parties can pick up copies at the clerk's window starting at 8:30. Salazar's hand tightened on the receiver. "Did they say anything else?" 47 pages. She stood up from her desk. The chair rolled back and hit the filing cabinet behind her. The Solis file slid an inch across the desk. 47 pages, she said. 47 pages. I heard you. I've read every ruling Yamada has issued in the last 3 years. Her denials average 9 pages. Thomas. Her denials average 9 pages, Elena. 9 pages. Her grants average 32. Salazar gripped the phone. The Solis file was still open on her desk. The notebook with the relocation network was in the drawer. Monday morning, Okafor said. 8:30. Copies at the clerk's window. She stood up. The chair hit the filing cabinet. The Solis file slid. I'll be there. She hung up. The bullpen was empty. The fluorescents buzzed. Outside the window, the last daylight was gone from the Hollywood Division parking lot. Monday, Chapter 32. The Ruling. Monday, May 5th, 9:14 a.m. Department 127 was full. Salazar counted the rows from the back. 6 wooden benches on each side of the center aisle, 12 total, and every seat was taken. She recognized 4 reporters from the courthouse press pool in the second row on the left. Behind them sat a woman in her 30s with a legal pad and a credential badge from the Los Angeles Times. 2 rows back, a man from Channel 7 sat with his hands folded, no camera allowed inside. Salazar stood against the back wall with Marcos. He had come without being asked. She hadn't told him about the ruling call. He'd walked into the bullpen that morning at 7:45, looked at her desk, and said, "What time?" 8:30 for copies, 9 for the reading. He'd picked up his keys. They'd driven downtown in her car, parked in the structure on Temple, walked across to the courthouse without talking, found the last open space against the back wall of 127, and stood there. Okafor sat at the petitioner's table on the left side, David Shin beside him. The UC Irvine habeas attorney, whose name Salazar had never learned, sat at the end of the row with a yellow legal pad. Okafor's suit was dark blue. He'd gotten a haircut. His reading glasses were on the table in front of him, not on his forehead. He sat with his hands flat on the table surface and did not look at the gallery. Strand sat at the respondent's table on the right. Gray suit, not the charcoal she'd worn to the deposition. Same reading glasses on a chain. Same leather briefcase, closed, on the floor beside her chair. A younger attorney sat to her left with a laptop open. Strand had a single copy of something in front of her. She was reading the last page when Salazar looked. At 9:14, the clerk stood. All rise. Department 127 of the Superior Court of the State of California, County of Los Angeles, is now in session. The Honorable Patricia Yamada presiding. Yamada came through the door behind the bench. Black robe, short, dark hair streaked with gray, reading glasses already on. She carried a bound document in her left hand and a pen in her right. She sat down and placed the document on the bench in front of her. She looked at the courtroom. She did not smile. "Please be seated." The room sat. One sound, collective, gone. We are here in the matter of Cole vs. the People, case number BA416892. The court has completed its review of the evidence and arguments presented during the evidentiary hearing held April 14 through 18 of this year. The court's findings and order are contained in the written ruling, copies of which have been made available to the parties as of 8:30 this morning. She looked at both tables. The court will summarize its findings from the bench. Yamada opened the document. She adjusted her glasses. She did not look up again for 6 minutes. The petitioner, Marcus Jerome Cole, was convicted of first-degree murder in this court on November 3, 2016, and sentenced to death. He has been incarcerated for approximately 10 years. He filed a petition for writ of habeas corpus alleging, among other things, that his conviction was obtained through jury tampering that deprived him of his Sixth Amendment right to trial by an impartial jury. She turned a page. This court initially denied the petition on procedural grounds. Following the submission of new evidence, this court granted an evidentiary hearing to determine whether the petitioner's claims were supported by the factual record. She turned another page. Her voice was flat, deliberately flat. No inflection, no emphasis. A judge reading findings. The court heard testimony over 5 days from 11 witnesses. The court also received documentary evidence, including sworn declarations, financial records, employment records, court administrative records, and expert testimony on memory and cognitive function. Salazar stood with her back against the wall and her arms crossed. Marcos stood beside her with his hands in his jacket pockets. The room was tight. Pressure in the air. Nobody moving. The court will address each category of evidence in turn. Yamada read for 43 minutes. She started with Hadley, his cooperation agreement, his proffer, his testimony that Warren Lusk recruited him 3 weeks before jury selection and paid him with a ground-floor commercial lease at Lusk Tower, valued at approximately $400,000 per year. His admission that he approached juror number 6, Robert Frazier, during a morning break and told him that people who made things difficult had difficult lives afterward. His admission that he called Lusk after Victor Reyes and Patricia Whitmore indicated they would come forward. Then, Strand's cross-examination of Hadley. The cooperation agreement that reduced his exposure from life imprisonment to 4 to 8 years. His financial motive to provide testimony favorable to the prosecution. The fact that every detail of his testimony was consistent with information already in the public record and could have been constructed rather than recalled. Yamada's finding on Hadley. The court finds Mr. Hadley's testimony credible but insufficient standing alone to establish jury tampering. His cooperation agreement and the substantial benefit he received in exchange for testimony create a reasonable basis for skepticism regarding his motive. The court notes, nonetheless, that significant portions of his testimony are corroborated by independent evidence, as discussed below. She turned to Wyatt. Juror number 9. Her complaint filed the day after the verdict. Her testimony about observing Hadley on his phone in the parking lot during a break, speaking with apparent deference to an unidentified person. Her 10 years of filing complaints with the court, the Judicial Council, and 2 state legislators. The cognitive evaluation ordered by the court and administered by Dr. Sarah Huang, which found Wyatt to be cognitively intact with a Montreal Cognitive Assessment score of 29 out of 30. Then, Strand's cross-examination. The 10-year gap. The multiple tellings of the same story. The Whitfield framework on memory consolidation and narrative rehearsal. The possibility that Wyatt had reconstructed her memory through repetition rather than genuine recall. Yamada's finding on Wyatt. Mrs. Wyatt is 81 years old. She has told her account many times. The defense argues this repetition reflects narrative rehearsal rather than genuine memory. The court disagrees. Mrs. Wyatt's account has been consistent across all tellings. Her cognitive evaluation confirms intact function. The court finds her testimony credible and assigns it substantial weight. Salazar watched Okafor's hands. They were still flat on the table. His right index finger lifted a 1/4 inch and settled back down. That was all. Yamada moved to Frazier. Remote testimony from Ventura County under the court's COVID-era remote participation order. His account of Hadley's approach during the morning break. The threat. His departure from Los Angeles after the trial. His relocation to Scottsdale. His subsequent involuntary relocation to a rural property outside Ridgecrest by a person later identified as Eric Cortez, a private security contractor. Strand's cross-examination. The 10-year gap again. Frazier's anxiety disorder and prescribed medication. The absence of any contemporaneous report. The fact that he did not contact law enforcement about the alleged threat until approached by the defense. Yamada's finding: Mr. Frazier is a reluctant witness who testified under circumstances that suggest genuine fear rather than fabrication. His account of the threat is specific and consistent with Mr. Hadley's admission. The court assigns his testimony significant weight, while noting that his failure to report the threat contemporaneously is a factor the court has considered. Then Medina. Yamada read Medina's testimony slowly. Her position in the interpreter's waiting area on November 2, 2016. The wall between the waiting area and the hallway adjacent to the jury room. Old plaster over wood frame, not soundproofed. The foreman's voice, which she recognized from 2 days of testimony. Votes moving, 2 holdouts. The woman won't budge, but the other one is close. A second voice, male, older, deliberate. Then the foreman again. By tomorrow. Her report to Bailiff Deputy Ronaldo within 45 minutes. Ronaldo's duty log documenting the report. The court's failure to act on either Medina's report or Wyatt's separate report, filed the same day. Strand's cross. The wall, the acoustics, the identification of voices through a barrier, the 10-year gap. Whitfield's framework on overheard speech, which placed retention of overheard conversation at 12% after 1 week, with no positive correlation between confidence and accuracy. Then the counter-expert, Dr. James Ota from UC Irvine. Emotional memory persistence. The studies showing emotionally arousing events retained at 2 to 3 times the rate of neutral events. Ota's testimony that Medina's report within 45 minutes constituted contemporaneous corroboration that eliminated the delayed recall problem entirely. Yamada's finding on Medina. Miss Medina is not a juror. Evidence Code Section 1150 does not apply to her testimony. The foreman's statement, overheard by Ms. Medina through the wall of the waiting area, constitutes a party admission under Evidence Code Section 1220. Ms. Medina reported what she heard to Bailiff Deputy Ronaldo within 45 minutes. This report was documented in the bailiff's duty log. The court finds Ms. Medina's testimony highly credible and assigns it the greatest weight of any witness in this proceeding. Okafor's right hand moved from the table to his lap. Salazar saw the motion. Nobody else would have. His face did not change. Yamada went through Ronaldo, through Sandoval and Park, whose testimony the court admitted over Strand's 1150 objection as non-deliberative conduct testimony, through the corporate records tying Cortez to the relocation, through Dr. Whitfield's framework, which the court acknowledged as valid science but insufficient to overcome the specific corroborative evidence presented. Then the legal standard. The petitioner bears the burden of establishing, by a preponderance of the evidence, that his constitutional rights were violated. This is not a standard of proof beyond a reasonable doubt. It is a standard of more likely than not. Yamada looked up from the document for the first time in 43 minutes. She looked at the courtroom. She looked at both tables. Then she looked back down. The evidence presented at this evidentiary hearing establishes, by a preponderance, that the jury in the trial of Marcus Jerome Cole was subjected to improper external influence through the conduct of Carl Raymond Hadley, acting at the direction of a third party. This influence materially affected the deliberation process and deprived the petitioner of his constitutional right to trial by an impartial jury under the 6th and 14th Amendments. She turned to the final page. The petition for writ of habeas corpus is granted. The conviction and sentence are vacated. The court orders a new trial. The courtroom made a sound, not a gasp, not an eruption. A low noise from several places at once, the sound of 30 people exhaling at once. Someone in the third row said, "Oh," and nothing else. Yamada continued reading. The petitioner shall remain in the custody of the California Department of Corrections and Rehabilitation, pending further order of this court. The people shall have 60 days from the date of this order to file notice of intent to retry. If the people decline to retry, the petitioner shall be released. If the people elect to retry, the court will schedule a new trial date at a status conference to be held within 14 days of the filing of notice. She closed the document. Copies of the full written ruling are available at the clerk's window. Court is adjourned. She stood. Everyone stood. She walked through the door behind the bench and was gone. The room stayed still for 3 seconds. Then it broke. Okafor put both hands on the table and pushed himself to a standing position. Shin was saying something to him. The UC Irvine attorney was writing. A reporter from the second row was already on his phone in the aisle. The woman from the Times was writing in her legal pad without looking up. Strand closed her copy of the ruling. She placed it in her briefcase. She looked at the younger attorney beside her and said something Salazar could not hear. Then she stood, put on her jacket, and walked toward the center aisle. Salazar and Marcos walked out through the double doors into the hallway. The corridor was wide, marble floor, overhead lights that hummed. 2 more reporters were outside, one with a microphone. Okafor came through the doors 30 seconds later. Shin was behind him carrying 2 copies of the ruling. Okafor stopped in the hallway. He looked at Salazar. His eyes were wet, his hands were steady. "It's not over," he said. "I know." "It's the beginning of over. I know that too." "She'll appeal. Strand will file a motion to reconsider, then a writ to the Court of Appeal. Then the DA has 60 days. Thomas." He stopped. "It's good," Salazar said. "Let it be good for a minute." He looked at her. He took off his reading glasses and held them in his right hand. He put his left hand on the wall and stood there. 10 years. He's been in there 10 years. He's going to get out. 60 days. The DA could retry. They won't. You don't know that. Yamada just wrote 47 pages saying the trial was corrupt. No DA's office retries a case after a ruling like that, not in an election year. Chen's replacement might. Chen's replacement will read 47 pages and do the math. The double doors opened again. Strand walked out. She adjusted her briefcase strap on her shoulder. She looked at Okafor. "Counselor," she said. "Ms. Strand." She walked toward him. She stopped 3 feet away. She was a foot shorter than Okafor, and she looked up at him without any indication that the height difference registered. Your chain of evidence was effective. The Medina testimony was the pivot. I underestimated the contemporaneous report argument. You made a strong case. Not strong enough. No. Strand extended her hand. Okafor took it. They shook once. I'll be filing a motion to reconsider on the 1150 ruling within the week, she said, and a writ to the 2nd District on the Hadley credibility finding. I would expect nothing less. Strand looked at Salazar. She held the look for 2 seconds. Then she turned and walked down the corridor toward the elevator. Her heels were the only sound in the hallway for 5 steps. Then the reporters started talking. Marcos was leaning against the wall with his arms crossed. He watched Strand walk away. She's not wrong about the appeal, he said. She's not wrong about anything. That's what makes her good. Okafor was reading the first page of the ruling. His lips moved slightly. Shin stood beside him, holding the second copy. I need to call Cole, Okafor said without looking up. Vacaville allows legal calls on a 4-hour notice. I can get a call window at 2. I'll make the call, Salazar said. Okafor looked at her. You? He should hear it from someone who was there. Okafor folded the ruling and put it inside his suit jacket. Room Form 12, you can use my phone. The institutional line connects faster. They drove back to West Temple. Marcos dropped them at the entrance and went to find parking. Salazar and Okafor took the elevator to 4. Room 412 looked the same as it had 6 months ago. Metal desk, bent blinds, files stacked on every horizontal surface. The framed certificate on the wall behind the desk faded in one corner where the sun hit it through the blinds. Okafor dialed the Vacaville legal call line. He gave the inmate's CDCR number and his state bar number and requested an immediate legal call. Extraordinary circumstances. Ruling issued today. The person on the other end put him on hold. 7 minutes, then a click and a transfer. Calls are recorded. You have 15 minutes, the voice said. Okafor handed the phone to Salazar. She put it to her ear. Silence on the line, then a chair scraping on concrete, then breathing. This is Detective Salazar. I know who it is. Cole's voice was the same as the last time she'd heard it. During the hearing, over the video link from the Ventura County Courthouse where Frazier had testified. Flat, measured. A man who parceled out his words like they cost him something. The ruling came down this morning, she said. Judge Yamada read it in open court. Cole didn't say anything. She granted the petition. Your conviction is vacated. She ordered a new trial. The line was quiet. Salazar could hear the institutional background noise. A door closing somewhere. Voices at a distance, indistinct. What does that mean? Cole said. Not a question. A statement requiring translation. It means the judge found that your trial was affected by jury tampering. The evidence was sufficient. She vacated the conviction and the sentence. Am I getting out? Not today. More silence. The DA has 60 days to decide whether to retry you. If they file for a new trial, it starts over. New jury, new proceedings. And if they don't? If they decline to retry, you're released. 60 days. Yes. So I wait. Yes. Cole was quiet for 8 seconds. Salazar counted them against the clock on Okafor's wall. The second hand had a hitch in its sweep, a tiny pause at the 4 that she had noticed the first time she sat in this office. The witnesses, Cole said. They all came? They all came. The woman, the interpreter. Medina, yes. Yamada said her testimony was the strongest. She said she assigned it the greatest weight. Is that the same thing? Close enough. Another pause. I've been here 10 years. 2 years at San Quentin before Vacaville. I learned how to wait a long time ago. I know. 60 more days isn't the hard part. Salazar waited. The hard part is knowing it could still go the other way. That somebody in an office downtown could decide to do it all over again. And I'd sit here for another 2 years, waiting for a trial that might end the same way. It won't end the same way. You can't promise that. No. Then don't. Salazar looked at Okafor. He was standing at the window with his back to her, looking down at West Temple Street through the bent blinds. His hands were in his pockets. Your sister called me Friday, Salazar said. Denise, she asked me to call her when I heard. You don't have to call her. I'll tell her Tuesday. We talk on Tuesdays. I told her I'd call. Then call her. I will. The line hummed. Cole's breathing was steady. Detective. Yes. Tell the interpreter I said thank you, and the old woman, Wyatt. I'll tell them. And Okafor. He's here. He can hear you. Tell him anyway. Salazar looked at Okafor at the window. He says thank you. Okafor didn't turn around. He nodded once. His shoulders moved in a way that could have been breathing or could have been something else. 60 days, Cole said. 60 days. I'll be here. The line went dead. 15 minutes was up, but they'd only used 7. Cole had hung up first. Salazar put the phone in its cradle. Okafor stayed at the window. He's not celebrating, Okafor said. No. He's calculating. He's been calculating for 10 years. That's what kept him alive. Okafor turned from the window. His eyes were dry now. His tie was loose and his sleeves were rolled, and he looked the way he always looked, tired and unfinished. I need to draft the opposition to Strand's motion to reconsider before she files it, and prepare a memo for the DA's office arguing against retrial, and update Cole's legal team, and call 3 reporters who've left messages since we walked out of the courtroom. So work. Salazar picked up her jacket from the back of the chair. Marcos was in the hallway, leaning against the wall, reading something on his phone. Bar owner on Gower called, he said. Pete came in last night, not Thursday. He's a regular, but not on a schedule. Owner got a last name. Pete Cardenas. Lives on Wilton Place. You run him? 2 priors, assault and petty theft. Did 18 months at Lancaster in 2019. He see anything? The owner says he saw everything. Says he's been telling people about it for months. Nobody asked him. Salazar took the stairs. Marcos followed. So we go find Pete Cardenas on Wilton Place, she said. Now. Now. They pushed through the lobby doors into the afternoon. West Temple Street, May in Los Angeles. 72 degrees and a white sky that could have been clouds or haze or smog. The courthouse was behind them. The parking structure was across the street. Somewhere inside the California Medical Facility at Vacaville, Marcus Cole was sitting in a room calculating 60 days. Salazar pulled her keys from her pocket and walked toward the car. 60 days. The system had given itself 60 more days to decide whether to let a man go free. After 10 years and 47 pages and 11 witnesses and 5 days of testimony, and a judge who stayed late to finish the ruling, the answer was maybe. 60 days of maybe. She unlocked the car. Marcos got in the passenger side. She started the engine. There was a witness on Wilton Place who'd seen a man stabbed on Gower 4 months ago, and nobody had asked him. That was the work. That was always the work. You found the person who saw what happened, and you asked them, and you wrote it down, and you brought it to someone who could do something about it. And sometimes they did, and sometimes they didn't, and sometimes it took 10 years and 47 pages. She pulled out of the structure and turned left on Temple. The courthouse shrank in the rearview mirror. Marcos opened the Solis file on his lap. 60 days had started. Chapter 33. The Witness Chain. Tuesday, July 1st, 8:47 a.m. The DA's office filed the notice at 4:17 on a Monday afternoon, which meant someone had waited until the last possible day of the 60 and then let it sit on a desk until close of business. Okafor called Salazar at 4:22. She was at her desk at Hollywood Division working the Gower stabbing, which had a name now. Pete Cardenas on Wilton Place had seen everything. He'd been telling people about it for months. The man in the red jacket was Carlos Fuentes, 26, from a building on Gower south of Sunset, 3 doors from the bar. Fuentes had a prior and a current warrant out of San Bernardino. Marcos was running the warrant. They declined, Okafor said. Salazar looked at the Fuentes file on her screen. The prior was an aggravated assault from 2022, reduced to simple, time served. When does he get out? Processing takes 48 to 72 hours, Wednesday or Thursday. Yamada signed the release order 20 minutes ago. Good. Good, Okafor said. Neither of them said anything else for 3 seconds. His sister is driving up from Stockton, Okafor said. Denise, she'll be there Wednesday morning. Okay. I asked him if he wanted you there. Salazar looked up from the screen. The bullpen was half empty. Marcos was on the phone at his desk, writing something on a legal pad. What did he say? He said you'd know the answer. She did. She was a witness in the case that freed him. She was the detective who found the interpreter and the bailiff and the financial records and the property outside Ridgecrest. She was not his family, not his friend, not his advocate. She had done her job. The job was done. I'm not going, she said. I know. You? David Shin is handling the release paperwork. He'll be there with the transition coordinator from the Innocence Coalition. They have a housing placement in Sacramento, temporary, 90 days. The coalition handles exoneree support services. Is that enough? It's a start. California pays $140 a day for wrongful incarceration. That's $511,000 for 10 years. The claim takes 18 months to process. 18 months. The system that took 10 years to correct itself takes 18 months to write a check. Yes. Thomas. Yes. You did this? We did this, all of us, every single one. He hung up. Salazar closed the phone and put it on the desk beside the Fuentes file. The clock on the wall above the break room door read 4:26. Monday afternoon in July. The bullpen smelled like burnt coffee and carpet cleaner. She went back to the Fuentes warrant. Wednesday morning, 9 a.m. The California Medical Facility at Vacaville sat on a flat stretch of land off Interstate 80, 60 miles northeast of San Francisco. Concrete walls, razor wire, a parking lot that held 300 cars and was never full. Salazar was not there. She was at her desk on the second floor of Hollywood Division, reading the Fuentes case file and drinking coffee that had been sitting on her desk long enough to go cold. Marcos had confirmed the San Bernardino warrant was active. They had a pickup scheduled for Thursday morning at the Wilton Place address. The Solis case was moving. At 9:14, her phone rang. Okafor. He's out. Good. He stood in the parking lot for 4 minutes before he got in the car. Salazar looked at the window. The blinds were half drawn. Morning light came through in bars across her desk, across the Fuentes file, across her cold coffee. His sister was there, Okafor said. She drove a blue Honda. She didn't get out of the car right away. She sat behind the wheel and watched him walk through the gate, and then she got out. Did he say anything? Shin said he didn't speak until he was in the parking lot. Then he looked at the sky. He looked at the car. He looked at the gate behind him. Then he said, "Where do I go?" Salazar picked up a pen from the desk and put it down again. Denise told him Stockton, her house, a room he could use. Okay. He asked Shin if there was paperwork. Shin said no. Cole said, "There's always paperwork." Shin told him not this time. He was free to go. And he got in the car. Salazar heard something in Okafor's voice. Not emotion. Exhaustion. The sound a man makes when a 10-year weight shifts, and the absence of it is harder than the carrying. It doesn't feel like winning, Okafor said. It isn't. No. It's a correction. Yes, a correction. He was quiet for a moment. I'm going to draft the compensation claim this week. And the certificate of factual innocence he'll need both for housing, employment, everything. The work. He hung up. Salazar put the phone down. Marcos looked up from his desk. He'd heard half the conversation. He didn't ask. Fuentes' pickup is confirmed for tomorrow, he said. 6 a.m. His girlfriend's been posting from the Wilton Place apartment. He's there. Good. She opened the Solis file on her desk. Hector Solis, 28, stabbed once in the chest outside a bar on Gower, south of Sunset. Bled out before the ambulance arrived. 2 witnesses saw the man in the red jacket running south. Both recanted. The case had been cold for 5 months before Cardenas walked into it. Across the street from the California Medical Facility, on a strip of sidewalk between the road and a chain-link fence that bordered an empty lot, Doreen Wyatt stood in a gray cardigan and flat shoes and watched the gate. She had taken the 6:05 a.m. Greyhound from Ventura, 2 hours and 40 minutes to Vallejo with a transfer in Oakland, then a local bus to Vacaville. She had not told anyone she was coming. She saw the gate open at 9:12. A man walked through. Blue jeans, gray sweatshirt, white sneakers. State-issued clothes that didn't fit right. He was thinner than she remembered from the courtroom video feed, and older, and he walked the way people walk when they don't know where the ground is. A woman got out of a blue car in the parking lot. She was younger than the man. Dark hair pulled back. She stood by the driver's door with her hands at her sides and watched him walk across the asphalt. The man walked toward her and stopped 6 feet away. They looked at each other. Neither of them moved. Then the woman put her arms around him and held on. The man's hands hung at his sides for 2 seconds before they came up and held her back. Wyatt watched from across the street. She was 81 years old and she had filed the first complaint on November 4, 2016, the day after the verdict, and she had filed 9 more complaints and written 14 letters and made 22 phone calls over 10 years, and nobody had listened until a detective from Hollywood Division knocked on her door at Seaside Palms. The man got in the car. The blue Honda pulled out of the parking lot and turned right toward the freeway on-ramp. It merged into traffic and was gone. Wyatt turned and walked back toward the bus stop. The return trip was the same route in reverse: Vacaville to Oakland, Oakland to Ventura. She would be home by early afternoon. She would sit in her kitchen and drink coffee and look at the folder in her dresser drawer, the one with the complaints and the letters and the receipts for every certified mailing, and she would close the drawer. It was finished. She sat on the bus stop bench and waited. Her purse was in her lap. Inside it was a folded copy of Yamada's ruling that Okafor had mailed her 2 months ago. She had read it 4 times. She did not need to read it again. The morning sun was warm on her face. Cars passed on the road. The gate of the prison stayed closed behind her. At 11:42, Salazar's phone buzzed with a text. Medina. No words, just a photograph. Sophia standing behind a table at what looked like a school gymnasium, holding a ribbon. Second place. The project behind her was a trifold poster board with the title, How Sound Travels Through Walls. Sophia was smiling. Salazar looked at the photograph for 5 seconds. She put the phone face down on her desk. Marcos was on the phone with San Bernardino County about the Fuentes warrant transfer. His voice was low and patient. He wrote something on the legal pad without looking up. The bullpen was quiet for a Wednesday. 2 desks empty, 1 detective on medical leave and 1 in court. The clock on the wall read 11:44. The break room coffee had been reheated at 10, and nobody had made a new pot. Salazar pulled the Solis file toward her. Cardenas had given a full statement last week. He'd been at the bar on Gower that night, at the end of the counter near the window. He saw Solis come out. He saw the man in the red jacket cross from the other side of the street. He saw the knife. He saw Solis go down. He saw the man run south. He could identify the jacket because of the logo on the back. An auto body shop on Western called Ruiz and Sons. Cardenas had been a customer there. He knew the jacket because they gave them to regulars. Fuentes worked at Ruiz and Sons. Marcos had confirmed it Monday. 5 months cold because nobody had walked into the bar and asked the regulars what they saw. 2 witnesses who recanted because they lived on the same block as Fuentes and had to keep living there. Cardenas lived on Wilton Place, 3 miles away. He had nothing to lose by talking. He'd been talking. Nobody asked. Salazar wrote a note in the margin of the file. Then she opened the bottom left drawer of her desk. The notebook was underneath a stack of departmental memos she hadn't read. She'd put it there 3 weeks ago, after the hearing, after Yamada took the case under submission. The notebook was the same one she'd carried since the Whitmore case. Spiral-bound, college-ruled, corners soft from being shoved in jacket pockets. The 2-column system. Left column for facts, right column for questions. She opened it to the last page she'd used. The page was dense with small handwriting. The left column held names: Cortez, Ridgepoint Security Consulting, Apex Fleet Solutions, Trident Mobility Group, Garrett and Rowe, Bakersfield, Desert Vista Holdings Trust, Western Pacific Administrative Services, the corporate chain that led from a gas station in Kingman, Arizona to a property outside Ridgecrest, California, to a network that relocated witnesses through attorney referral chains insulated by privilege. The right column held 3 questions. Who hired Cortez? Who made the referral call to Garrett and Rowe? How many other witnesses had been relocated through the same network? Salazar looked at the page. She had mapped the mechanism. She had not mapped the client. The hearing was over. Cole was out. The relocation of Frazier had served its purpose as evidence of external influence on the proceedings. Yamada had referenced it in the ruling. It had been enough. But the network was still there. Cortez was still in Henderson. Ridgepoint was still operating. The trust in Bakersfield was still active. The referral chain was still intact. And somewhere in the gap between a law firm that made a phone call and a contractor who moved a man across state lines in the middle of the night, there was a client whose name was insulated by 3 layers of privilege and 2 shell companies. Salazar closed the notebook. She put it back in the drawer underneath the memos. She closed the drawer. Not now. Not yet. She pulled the Solis file back to the center of her desk. Fuentes pickup at 6 a.m. tomorrow. Cardenas available for a lineup Friday. The case was moving. The drawer stayed closed. The notebook stayed underneath the memos. The names on the page would keep. Outside the window, Hollywood Division's parking lot baked in the July heat. A patrol car pulled in. 2 uniforms got out and walked toward the building. Somewhere on Gower south of Sunset, a bar owner was wiping down the counter where Pete Cardenas sat every Thursday. Somewhere in Stockton, a man who had spent 10 years on death row was sitting in his sister's house trying to remember what it was like to open a door without asking permission. Somewhere in Boyle Heights, a 12-year-old girl was putting a second-place ribbon on her bedroom wall. The chain had held. Barely. Slowly. At enormous cost. And only because every single link in it chose to hold. Salazar picked up her pen and went back to work.